Oh, these people are, so like Barbara got brought over? Oh, okay. Okay, thank you. Got it. Okay. All right, before we get started, Ms. Williams, can I see you for a sec?
Yes, Judge. Good morning. I didn't first.
Two probation recommendations for letter, and then I don't need pleas or anything. And I have some motions for bonds. What I was gonna see if we can do a plea, just a flat charge and we, I actually. I know, I'm just, the hours are always crazy. But I would have to break out lunch because I don't like.
Who has justice for the probation revocation though?
I mean, yes. Well, who?
Justice for
Oh, that's the one that we're bringing back. And is she add-on? She's not on the count.
Yeah, it's on, they did like a
Yeah, I missed it.
additional count.
I didn't see the add-ons. I didn't know she was getting.
Today for a probation modification.
Oh, okay. It's for today?
Yeah.
Oh, right. Did not realize that. I mean, I don't have her stuff because I didn't know it was today.
All right, good morning, everyone. We are going to get started. We have a variety of calendars this morning. The main one is a trial calendar with trial beginning next Monday. So if your case is not resolved today and it's not announced that it's continued to some other day, then it means next Monday we'll be together to pick a jury and move forward with that case. So that's what we're going to sort through for most of today. We also have a bond calendar. Is Ms. Gibson here?
Yes.
Hey, Ms. Gibson, good morning.
Good morning.
There was a mix-up at the jail, and the jail brought over your client's brother. They are co-defendants in this murder case. But you represent Mason, Washington. That's whose bond hearing we need to have today. And so the sheriff's team is working on taking Mason Washington's brother back to Rice Street and bringing Mason Washington over here. That won't happen right away. So it will be today, So if you have other courtrooms you need to be in, you should feel free to go there now. If you want to leave Deputy Gordon with a phone number we could call, he can let us know, hey, Mason Washington is now on the van coming back here, and that would be 30 minutes notice if you're able to come back here. I don't know where work is for you, and I'm sorry for the inconvenience. I don't know if there's family here for Mason Washington either, but he's entitled to the bond hearing and we will do it. We need him.
That's okay, Judge. I'll report to my other courtrooms and then I'll leave a number.
Okay, great. Yeah, just check back in. That'd be great. Thank you. And then I'm not sure who's here for Ms. Ford. Ms. Rios, your name is on here, but there are some other defense attorneys. Are you handling Ms. Ford's case?
I missed that, calendar, but I'll just go back and talk to her.
Okay, it's a probation modification. She will be here. She's not here yet, but you're going to be here for a while anyway. So we expect her to be here. And then do we need to bring Mr. Mayo up?
No.
No. Okay. Did you hear that? So Mr. Mayo is good. He's here. He was busy and so couldn't come up when Deputy Gordon was doing all that. So Mr. Mayo will stay downstairs. And then for whatever reason, we brought Mr. Barber over. Remember which one of you took his plea? Yeah, he's already pled. Do you want, it was a mistake in transportation. Do you need to see him at all? Okay, so Mr. Barber and Mr. Mayo are good to go, Deputy Gordon. All right. Then let's get going with the trial calendar. So Mr. Compton is everyone else up?
Yeah, everybody up.
Everyone else is up. So Mr. Compton is here. And I think what we'll do after we get through the calendar, because there are going to be lots of lawyers who want to descend on Ms. Smith, she can go into the jury room and deal with those descendings. And we'll do Mr. Compton's sentencing because Mr. Abadi's here and Ms. Wood, you're here. So we'll do that. Position 2 is Mr. Charles, and Mr. Apt is on. I don't know if his client is on, but we've got some iPhones and stuff. Hey, Mr. Apt, can you hear us?
I can, Your Honor. Good to see you. Thank you.
Likewise, happy World Cup. So is Mr. Charles on the call?
I think I see him there. He's listed as meeting. I apologize. He doesn't have his name.
There he is. That's okay. It's all good. There he is. Mr. Apt, Mr. Abadi gave me a just procedural update yesterday as I was asking him about his various cases on the calendar. And he flagged for me 2 things. One, we've had a change in prosecutors. So Mr. Abadi's climbing a little bit of a learning curve. But 2, that he had been talking with you about potentially resolving the case. Tell me where we are from a defense perspective.
I mean, Judge, we are ready. And if we can get the case resolved, that would be fantastic. And if we cannot get the case resolved, I mean, we are ready, but I don't want to. I have a very good working relationship with Your Honor and with Mr. Abate, and I'm just not going to object if the state, the ADA, I guess, left the office less than 2 weeks ago, and I went into this profession so that there would be fair trials. I don't know how fair it is for someone to try and get up to speed on a murder case in less than 2 weeks, but I'll do whatever the court orders me to do, of course. And I'm here and ready and not objecting to the state's request to continue if necessary. In the meantime, we're working hard to resolve the case.
Okay, and it's that last bit that I wanted to drill down on. I appreciate your professionalism with this, and because your client's on bond, even though these are really old charges, there is, of course, less pressure to say we've got to absolutely do this one, given the change on the state side. But there's balance to be struck, and closure is due to your client and to the deceased family in this case. Where are you and Mr. Abadi still talking, or I just want you to put a more of a gloss on it, as in like we're still pretty far apart, but maybe the state will get more realistic, or I need to get my client in a headlock for a little while to work this out, or
we are still talking. I have I don't know. I almost hate that we're on the record, but I know Mr. Abate's not here, but I would.
He is. He's sitting in court. You just can't.
Oh,
You can't see him. So don't say bad things about him.
No, never. I would never do that. He's fantastic. So I guess I'm going to talk to Mr. Abate. We might get it resolved. If there's, I'm again, this is a very selfish request, but there's another judge in another county who's trying to leapfrog, and Mr. Charles' case is older. So if we can reach a resolution, I'd still like to call it for trial on Monday and then resolve it on Monday, so I can sort of dodge that other case. Mr. Charles' case is older, but
I hear you. That's one of the issues we've got, is that it's older. Well, I'll tell you what I'm going to do. I will leave this on the maybe we'll get to it list. You and Mr. Abate keep talking. If you all sort out that it's a resolution, next Monday would be a great day to do that. That might work for everyone. Remind me, Mr. Charles is not local, and so if he's going to be involved with a resolution or a trial, he needs to be here. And I want to make sure he has enough notice to get here, but not that he doesn't have to buy a plane ticket that and then he doesn't use.
Well, if we can't, I understand that, but I'm hopeful we'll get it resolved, and then we could do that on Monday. And then if not, and the state wants to, ask for, whatever continuance, then on Monday they will, and so be it.
Okay. Mr. Abate, anything you want to add to the mix?
No, I mean, I feel very confident that we'll come to a meeting of the mind.
Okay. I don't know if you could hear that, Mr. App, but it was positive words from Mr. Abate. He said he felt very confident that you all would come to a meeting of the minds. So keep the channels of communication open, and I will bug you two from time to time during the rest of this week so we can see what Monday is lining up to look like. Okay?
Okay. So, but for now, I am to report on Monday?
You should assume for now, but I will get an email out later this week saying, here's the order in which we're going to try to do things on Monday. There are, unsurprisingly, other moving parts, and it may be that there's a case where someone's in custody, and we are for sure going to try that on Monday, and then we'll just have to figure out another time to bring this one to the front of the line.
I understand. Thank you, Your Honor.
Okay. Mr. Charles, do you have any questions about what we discussed?
No, I don't.
Okay, stay in touch with your lawyer. He'll get you an update soon.
Thank you,
Take
Your
that
Honor.
as an okay. You two are free to go.
Thank you, Your Honor. Good to see you. I'll
Me
call
too.
you, Adam.
Thank you.
Jose Lopez. We've talked about that. Any change in that, Ms. Wood?
Okay.
Okay, do you want Mr. Lopez to come out today?
Come to the door.
Okay.
That's okay.
Does he need an interpreter? Okay, great. Can we bring Mr. Lopez to the door, please? While we're waiting on that, Dwight Foster is a plea.
I need to speak with
You need to talk with him. Okay. Thank you. Good morning, Mr. Lopez.
Morning, Dave.
Hey, I just want to give you an update on your case. Your case is on the trial calendar. I'm not sure we're going to be able to reach it, this trial calendar. We're starting a trial on Monday, and we've got a bunch of cases, and there are lots of moving parts. The state has asked for a one-time continuance so that they can get their situation prepared. Ms. Wood, your lawyer, has said, hey, we're ready. We are ready to go to trial. So this is not Ms. Wood saying we need more time. She's aware, and I'm aware, that you're sitting in custody. So I will see where this shakes out, but it's possible we don't get to your case on this calendar. It will move to the very next trial calendar, and it'll just move higher up because it's an older case. And you've been in jail now we're about half a year. So I can see your face. And so it's time for this to be resolved one way or the other. The state puts up the evidence and the jury decides, or maybe the state comes up with a different offer that you and Ms. Wood find to be more appropriate. Okay? I just wanted you to hear from me what the plan was. Ms. Wood is pushing to get this thing heard. Okay? Appreciate your patience. All right, Dwight Foster, Ms. Wood, he will speak with, and it may be a plea. He was re-indicted, or he has two cases? Re-indicted, and they're both on the calendar.
Yes, and the state would obviously not cross the original indictment.
Got it. Okay. Kenneth Newton has two positions, and I think those are pleas. Or you need to talk to him too. And is that more likely a plea than Foster, or you need to talk with these folks?
That's more likely.
Okay, great. Ms. Shalenge is pleading tomorrow, so hopefully she's not here. Nope, okay. Robin Johnson. Hi, Ms. Johnson. Good morning. I have this as a likely plea.
Yes, Judge.
Need to chat with Ms. Johnson?
Briefly, Judge.
Okay, so Ms. Johnson, we'll take care of your plea probably this morning. We usually do the pleas for people on bond first, so you can get on your way, and then we bring the other people out. But the deputies may need me to do it in a slightly different order, but we'll certainly take care of it today, okay? All right, Ms. Wood will talk to you in a sec. Sit tight. Joseph Varner should be in custody, still likely a plea?
Yes, Judge.
Okay,
Both cases.
both cases.
Yes.
Is he on a supplemental, or he's just not on the calendar?
Don't think it's on the calendar, but I can give you the number when you're ready.
I'm ready.
26 SC 002659.
Okay, let me do one thing. We have a court reporter on. Ms. Allen, can you hear us?
Yes, Your Honor, I can hear you.
Good morning. Thank you for being here. I will let you know when we need to be on the record. So you're welcome to take down whatever you want, but I'll be clear when there's something for which we definitely need to make a record, okay?
Thank you, Your Honor.
You're welcome. Travis Nelson is here. Good morning, Mr. Nelson. Ms. Wood, you had indicated possible plea?
No, Judge, this is the one where there was a diversion offer on the table.
Okay, possible diversion.
Right, so I just need to speak with him once more.
Got it.
We can be ready if it doesn't resolve with diversion.
Okay. I didn't mean to put it in the wrong category. So Mr. Nelson, Ms. Wood told me yesterday that you right now are in a situation where either you're going to accept diversion, whatever that means, and Ms. Wood will talk to you about that. That's as low as the state's willing to go. They're not going to just make the charges go away absent this diversion piece. If not, Ms. Wood has said she is ready to go to trial. I think the state has said the same. So you might be one of the ones who comes back on Monday, see if we get a jury for your case. All right, but talk with Ms. Wood. We're going to pivot to a sentencing hearing in a little bit. Oh, but that involves Ms. Wood. So she will talk to you in a little bit. Okay. All right. Mr. Brown already pled. So did Mr. Reeves. Jason Bates. Hello, Mr. Bates. Hello, Ms. Cabrera.
Hello, Judge. I have a recommendation from the state, so I need to convey that to him.
You'll talk with Mr. Bates. Got it. So Mr. Bates, you and Ms. Cabrera will talk. If we've worked something out, we'll take that plea today. It could be negotiated, it could be non-negotiated. And if not, then we'll talk about whether this is something that needs to come back on Monday, okay? Before I implicate you on Monday, do you have conflicts next week or leave?
I start, and then so the next 2 weeks I have meetings.
Oh, this is one of the reasons why we didn't put like the Amari Williams case and.
So I have leave that starts this Thursday and runs through Monday, and then I'm back in court for like 2 days.
Of course you do those types of leaves, right?
Yeah, another one that's like Thursday.
Friday through Monday, these trial-proof leaves that you take. Like, I'm not gone. I could be here on a Wednesday for those one-day misdemeanor trials.
But yeah, that's the only real weird leaves that I have all summer.
Well played. Okay. Well, you've got permanent leave for me, sadly, July 1. So we'll see if it's a plea with Mr. Bates. You guys talk and then let me know.
It's a prorated offer, so,
Okay. we'll see. All right, Ms. McClarity and Mr. Walker have resolved. Mr. Ramirez Perez has bumped to an inquiry calendar next month. Mr. Barber pled, although he's here. Mohammed Dumbuya. Good morning, Mr. Lane. Good morning, Mr. Dumbuya. I don't have you listed in any category from my brief conversation with the prosecutor. Do you need to talk with Ms. Smith this morning or yes? Okay. Once we get through the calendar, as I mentioned, I'll be doing a sentencing. And so Ms. Smith will go into the jury room and you should go in there and then you guys can let me know what the plan is. Just to repeat, if this isn't working out today, then we all need to be together on Monday for a potential jury selection. Okay. All right. Thank you. Laura Charles. Hi, Ms. Charles. Ms. Wood told me she is ready to go on this one to defend you at trial if that's where it's going. And the state has announced ready when reached, meaning we put it in the line and see where we are. I'm going to encourage Ms. Wood and Ms. Williams to talk one more time. It never hurts to have a conversation. But Ms. Wood let me know that this is one that could well be a trial. I need you to sit tight until Ms. Wood releases you. You don't need to hear from me again unless we're working the case out, and then we'll all have a conversation. But if Ms. Wood gives you the green light, just know that you may need to come back on Monday. I'll be letting her know soon enough, and then she'll communicate with you saying, we're not getting to your case, or yes, we are. Okay? I don't know about perfect, but that's the situation. Yeah. All right. Kanye Willingham should be in custody. I don't see Mr. Melnick. So Ms. Nelson, if you could get me an update when you get a chance about Mr. Melnick's whereabouts. Thank you. Alex Blue in custody and we're re-indicting. So we'll see what happens with that.
Judge, I just wanted to make an announcement on the record because we have the victim here. She's
Oh.
the person last time that my plea hearing.
For which of Mr. Blue's cases?
Position 22.
22.
Yes,
This one with lots of, we have a victim here.
one of the victims.
One of the victims.
Yes.
Okay.
So I had a conversation with her last night to let her know that the state will be re-indicting and no process to re-indict. She understands what's going on. However, I did tell her that I would make a statement on the record, while she was here in person. about it.
So you would make that statement.
Correct.
Okay. Who is the person that were right there? You two of you here. Okay. Hey, good morning. Ms. Smith shared with me yesterday the mistake in the indictment, that there are a number of people named who weren't victims, and there are some who were unintentionally omitted. And so the state wants to re-indict the case so that all of the victims are included, which is how it should be. You two are both victims. Are you already named in it, or are one or two of you ones who need to be added back in?
One is named and one is not.
One is not. Well, that is going to get fixed. I don't know exactly when that'll happen. I think the grand jury is not here this week, so it may be next week. And then we have to rearrange Mr. Blue. That's a quick process. It doesn't sound like it's a bunch of new evidence in the case. If there were there's not new evidence. Okay, so it's just the DA's office reconnecting the dots from the evidence they already have so that the proper victims are named in the indictment. You should not worry that this notion of, hey, the case is being dismissed is going to mean that Mr. Blue gets released from custody. That will not happen. And the fact that a case is being dismissed doesn't mean some favorable disposition one way or the other. In fact, the state really doesn't need to dismiss these indictments. They just need to get new ones. Once the new ones are in place, I'll probably press them to say, why are there two indictments naming you all as victims? And then Ms. Smith can say, well, you can dismiss the older one. But typically, they leave the older one in place, get the new indictment, and then they ask to have the older one dismissed so there are charges in place. And it just so happens, bad series of coincidences, there was a mix-up in Mr. Blue's other indictment that doesn't involve you all, and the state is fixing that as well. So I was hopeful we could try him on one of these this coming Monday. But he is, of course, entitled to a copy of the new indictment so he knows what the new charges are. I don't think they're going to be a surprise to him. His lawyer already knows this is coming. but we need to make sure we follow due process so that ultimately, if there is a conviction, it's one that's more likely to be upheld if there's an appeal. So I appreciate your patience. You're probably wondering, why wasn't this right in the first place? But there are lots of moving parts in these things, and it sounds like Ms. Smith has caught that and is going to fix it. Do you have any questions?
No, I spoke with Smith yesterday.
Okay.
Over.
I bet she was very thorough. You both are welcome to stay. I don't think, do we need to bring Mr. Blue out?
We can just open the door.
Okay, so I'm gonna have him come to the door right now. When I'm done talking with him, we're probably not gonna talk about that case again today. So you both can stay if you want to watch what else is going on, but if you're ready to go, when we're done with that conversation, that'll be it for his 2 cases. All right? Can we bring Mr. Blue to the door, please? While we're waiting on that, position 24 was a plea. Ms. Wycliffe was pretrial diversion. And then we'll talk about Godfrey in a second. I'm not gonna miss that lock. That's gonna be A-okay. Mr. Blue, good morning. I'm all right. I just wanted to give you an update that you've probably already heard from Ms. Wood, but I always think it's important for a defendant and a judge to connect each time he or she is brought over to the courthouse. You were brought over because today is the day we're calling a pretty lengthy trial calendar, bunch of cases on it, some older than yours, some newer than yours. And yesterday, when I was talking with your lawyer and the prosecutor about, hey, which of Mr. Blue's cases could we take to trial? It was shared with me that there were some mistakes in both your indictments. And one of them, there were some people named as victims who weren't, and some names left off. And when I say victims, these are all allegations. I'm not saying anything is etched in stone, but the state wants to re-indict one of your cases to remove a few people who they contend are not victims, and to add in some names of people who they contend are victims. Your second case, the state wants to add a charge relating to your status as a convicted felon. And so they're actually re-indicting both your cases. You're entitled to be arraigned on both those. It's not going to be anything new. Ms. Wood is well aware of it. It's not a new set of evidence or anything. They're just wanting the state to revise these indictments, and they're going to get that in front of the grand jury. I think you said next week, Ms. Smith?
Yes, June 22nd.
Okay, next Monday. Once those indictments are in place, we'll get you back here or it may be that you and Ms. Wood talk and you say, I don't need to come back for arraignment. You can waive my arraignment. Could we just get into court for a trial? We can get right back in line for the trial. We just need to get those 2 new indictments in place. Okay?
I ain't even gonna lie, sir. I'm actually lost on what's going on with the new indictments and which cases are y'all speaking on?
So, I didn't mean to be unclear. Let me be more clear. Give me 1 second. I'll be more specific, and hopefully that'll help. Here we go with 1. So in one of the cases, Mr. Blue, you are charged with, here it comes, on November 27th of last year, so around about Thanksgiving, you were charged with shooting at Ms. Lowe, Mr. Mitchell, Ms. Ware, Ms. Stewart, I think it's a Ms. Logan, a Ms. Booty, BUDY, and possessing a firearm, et cetera. So something that allegedly happened on November 27th of last year. That's one where some of those names I just read, the state is saying they actually weren't shot at. It was different people who were shot at. So they are substituting the names of the people who were the alleged victims. I don't have those names. Ms. Wood will get them to you, and you guys can parse through, like, well, how do you get that wrong? What's going on there? More importantly, if you are saying, I have no idea why someone is saying that I'm indicted for shooting at people, not hitting them, but shooting at them around Thanksgiving of last year, you and Ms. Wood should talk more. That's one of your cases. Ms. Wood, should I stop?
I just remembered something. So the order that you just signed so that my investigator can bring the discovery to the jail to show him that we just received.
Yeah.
She's got an appointment this Thursday, so she'll be out with the lab.
You will get a whole lot more information, Mr. Blue. Ms. Wood did a good job of getting me one of these orders that allows a laptop to come into the jail so you can watch video footage, body cam footage, et cetera. Anyway, that's one of your cases. And today isn't, and this is not the forum for you to say, well, let me tell you, I wasn't there. That you should just listen to what I'm saying. And then you can have 100,000 questions for Ms. Wood, and she will do her best to answer them. Your other case charges you, this is an old one. No, it's not actually, it's just 1 month earlier. So just before Halloween in 2025, you allegedly shot at a guy named DeMarcus Beauford. And the only thing they're changing in that case, the state is you're charged with shooting at Mr. Beauford. You're charged with having a gun when you did that, of course. And you apparently punched him in the face. They didn't include the count that if you did all these things, you were also a convicted felon at the time, which is a separate offense. So one is a shooting on October 28th where you supposedly shot at Mr. Beauford. The other is a month later, November 27th, you supposedly shot at some other people. Those are the two cases. The state's changing one just by adding that count, possession of a firearm by a convicted felon. It's a status offense. The other one they're changing because some of the names shouldn't have been in there. Those people weren't shot at, but other people are saying, no, I was shot at. And they're going to get those names in there. Hopefully this will become clearer later this week when you get to see the discovery that the state has provided. Those are the changes the state is making. Did me getting a little more specific help, or are you even more lost now? You're going to wait to see the stuff. This way, at least you know what's coming. It's not like it's a brand new case. It's these same two situations. And the state is just changing how they are going to talk about those two situations. All right?
Just to add clarification, there's that third case. Ms. Smith and I have been working very hard. It's unindicted and it's related to one of these cases.
The Beauford case or the many people case?
Yes.
The many people
And
case.
so one set of discovery was coming from Fulton Sheriff Department and the other was coming from APD, and there was wires crossed between the agencies. So I explained that to him last week at the jail. Ms. Smith got it all together for me last week, and that is what we'll be reviewing this week.
Great. Okay. All right.
Really quick, I'm sorry.
No, it's okay.
I was saying that, or I just want to clarify that when we re-indict the many people case, one of those indictments, the language will tweak a little bit because one of those victims was shot.
Was hit. So it wasn't just shooting at. So we're going to have in the indictment, and John Doe, but the actual name was actually hit on November 27th.
That's correct.
Okay. Got it. Okay. Still aggravated assault. It's just one that has a very different tenor to it because the allegation is that that person was actually struck by one of the bullets. Mr. Blue, your lawyer and her investigator will talk with you more about that. I just really wanted you to understand, like, why were you brought over today and why is it that you're not going to trial next week? You're not going to trial because the state's re-indicting, and we'll just get this on another trial calendar. The unindicted case, are the charges less serious than these?
Bring it over there.
Okay. All right. Okay. So that'll catch up. That's not something that we need to wait on because these are the more serious sets of allegations. Do you have any questions for me? Okay, that'll happen. We'll keep you up here so she can come back and talk to you, okay? Mr. Godfrey, I don't see Ms. Nix, but that doesn't, well, she's online.
Morning, Judge.
Hey, Ms. Nix, how are you?
I'm all right. How are you?
I'm well, good to see you. Ms. Wood shared with me yesterday that the DNA results are done. Good work getting those done. You committed, or they committed to you, they'd be done by this time. But now the rub is that the person who got them done is not available until July.
That's correct, Judge. So I do have some issues with witnesses. However, since Mr. Godfrey does have some other cases, if we do get to him in the list, the state would just move forward with one of his other trials.
That's you volunteering Ms. Smith to try a case instead of you trying a case?
Well, we did discuss that before, and I would try it with her.
Oh, you would do it. Okay. Well, Ms. Wood and I talked about that a little bit with Ms. Smith present yesterday. And I think most people's preference is that what I'm going to call your case, the rape case, it will be the one, if there's going to be a trial, it'll be that one, but it cannot be next Monday. And Ms. Wood wasn't opposing the continuance. When I asked, she said that the DNA results weren't necessarily bad news for her client. And she would prefer, rather than everyone stipulating to whatever the DNA results were, her preference was to be able to engage the DNA expert in front of the jury about the significance of the findings.
Yes.
Okay. So I think the plan is that we don't reach Mr. Godfrey's cases. I guess I reserve the right to say you got to go forward with the ag assault or something like that. But that seems inefficient given that there's this charge that's a whole lot more serious. So we'll see, but I will keep you posted. And you're done with your leave by next Monday?
Yes, sir.
Okay. Did you have a nice leave?
I'm still on leave.
Okay.
It has been nice.
You are having a nice leave.
Yes, sir.
Thank you for joining us from the leave. You are free to go.
Thank you, sir.
Do you want to have Mr. Godfrey come to the door?
Just briefly, Judge.
So you said that about Mr. Blue.
Well, Mr. Godfrey is much quieter.
Okay.
Yes.
Will he understand that he's been charged with things?
He already knows.
Okay. Mr. Blue seemed to like, why am I here? You shot at all these people. So I let her go. She's going to other courtrooms. This is the lawyer for the bond hearing we have, where we got the wrong Washington. So we just need to give her.
Right.
Yeah. So Mr. Melnick will be here in about 40 minutes. Does he know about the DNA results? Oh. Hey, Mr. Godfrey. How are you? Good. I just wanted to give you an update since we brought you over today. I had your cases put on a trial calendar, and I was hopeful, since you've been in jail for a year, that next Monday we could start one of your trials. You've got one case with a real serious charge, and then two cases where they're less serious. And everyone is agreeing that the one with the most serious charge is what ought to go first. Ms. Wood shared with me that recently there were some somewhat favorable crime lab results, favorable for the defense. The expert from the crime lab who generated those results is on leave and wouldn't be available next week. And so what we talked about was then moving your case to the next available trial calendar so we can get you that trial date when we can get the expert here as well. Rather than forcing your team to go forward without the expert, it sounds like it's important to have the jury hear from that expert about the significance of the DNA results. And so I agreed with that. We may, I don't think it's likely, but I want you to be surprised if you come back over here on Monday. One of your cases involves the allegation of aggravated assault and cruelty to children. We might try that instead, but the other case is so much more serious. That's the one that if you're found guilty there, the other cases will resolve. If you're found not guilty there, the other cases would likely result in a plea, given how long you've been in custody. So it seems a whole lot more efficient to try the most serious case. All right. Hopefully I'm not telling you something you have not already heard, but I wanted us to connect since you got brought over here. Do you have any questions for me? Would you like Ms. Wood to come back to talk to you? Or are you ready to go back? Yes, talk to you? She'll do that. All right, we'll keep you up here. You're welcome. Same with Mr. Comer. Do you need him brought to the door?
Yes, Judge.
Okay. Gosh, he's been in custody for a long time. Does he know about the severance? We don't need to go into the severance. Okay.
He'll be fine.
Famous last words.
Coleman,
Over.
Comer.
Yeah, I'm here. Hey, Mr. Comer, how you doing?
Going good.
Good, I'm doing all right. So I wanted to give you an update since we brought you over here today on your case. Your lawyer filed a motion a while ago saying, hey, you can't, it wasn't that I can't, but she moved to, you're charged with 2 different murders. And Ms. Wood has said it's not legally proper or correct to try Mr. Comer at the same time for both murders. And you were here when we had that argument, and the state said, yeah, we can do that, and you should do that. I entered an order just a few days ago agreeing with your lawyer. So the state's going to need to try the murders separately. But that's throwing them a little bit of curveball because I just entered that order. So they're getting their witnesses all together, but we're not going to be able to do one of those trials on Monday. The state gets to pick which one it's going to do. And they'll let obviously Ms. Wood know. So we'll know if it's the trial that involves a situation with your mom or the other one, but the state will say, we're going forward with this one. Ms. Wood will let you know that, and then that'll be what we try. We'll see what happens with that. Depending on the outcome, it may be the other half goes away or is resolved. It may be that you end up with 2 trials, but you will not be tried for both murders together, okay? Ms. Wood's going to come back and talk with you real briefly in a minute. We just got to get through the calendar, and she'll talk with you, and then we'll get you back to Rice Street. Do you have any questions for me? Okay, good seeing you. Jerron Reynolds. Still ready?
I'm going to talk to my new owner, and so it might be resolved today, but I'm going to talk about it.
Okay, great. Let me know what we do. Alburn Johnson. Hey, Mr. Johnson. Your lawyer, Mr. Jones, is he en route? What did he tell you?
That the conflict, you're getting another case, another county.
Okay,
And he's supposed to just be here with kids.
okay, we'll check with him and see if we can get an ETA so you know. He is very studious about that, so he's not gonna skip this. A little surprised we didn't hear from him about the conflict. That doesn't mean he doesn't have a conflict.
Inform you got filed some kind of letter.
Okay, we'll look. Sometimes those filings don't make them all the way to us. But we need to definitely talk about the case today, so we'll hold for his report. So we're not gonna bring Mr. Mayo up, Ms. Rios. You're still okay with that? Okay. Then that gets us to Ashley Chambers. Ms. Chambers?
The Chambers is online.
That's right. We gave the green light and it's gonna be a plea.
It is a place of probated.
Okay, all right. And then Elijah Thomas. Hey, Ms. Tembeka, how are you? I'm well. We will bring him out in a little bit at a minimum to work through the Jackson Deno, as in, do we need to have a hearing, or is it one where it's all on tape? So Judge, you can review the tape and we'll make our arguments or whatever. It may be that you and Ms. Smith are still talking.
We are, Judge, at this point, pre-trial negotiations are still active. I do believe they will yield positive results, toward a resolution toward a trial. However, Judge, there is some outstanding discovery. I've already spoken to the state about it, and the state is just waiting on the agency to send it over.
Yeah, Ms. Smith helped me understand that I guess this was Roswell and Sandy Springs. And I remember it was a car and people are driving the car everywhere. And so there were 2 jurisdictions. And it sounds like Ms. Smith is working on getting you either Roswell or Sandy Springs, whichever piece you don't have. Okay, got it. Well, we'll certainly work through the Jackson Deno piece today. Thank you. And then we have a supplemental calendar. Mr. Foster, we already talked about. Ulysses Greer.
So this one is mine, Your Honor. He
We had some, results that returned to the court. So he got put back on the calendar after that.
Yeah.
I do have the state's recommendation, but would he be ready to move forward for trial right now? No. So it's kind of a, not a surprise placement on the calendar, but he was placed on the calendar since he was clear.
I think that exactly. When we got the results, we said the next spot is a trial calendar,
And
which
that's
is,
when you jump back on.
yeah.
We're not ready, but, we're ready to get ready.
Okay.
I do have a recommendation.
So you all will talk and then let me know.
Yeah, I just don't anticipate there being any resolution as of today, and so I would ask that, he be placed on another trial calendar after this, and that the recommendation that was given by the state, that he still have the opportunity to do a negotiated plea, if that's something that he chooses to do at the next calendar date.
So he's not had his final plea because we
We would
paused
right,
things.
we
Okay.
made it to a calendar, but then
Yeah.
we had some things that we needed to do, and so those results will come back in.
Yep.
And so we're kind of picking up where we left off.
Got it. Okay. Well, let's see where we get today. And then you can let me know. Thanks. And on our second supplemental calendar, we have Ms. Jones, who I think I see in the back. Hi, Ms. Jones. And what about Mr. Campbell?
I've not heard from him this morning, Judge.
Okay.
I conveyed a new offer on Thursday last week. I have not heard since then.
We will reach out. But I'd ask you, Ms. Jones, to do the same. You have heard from him.
He texted morning, said he had a couple of dealers in college, he was on his way.
Great. So he will be here this morning at some point. Thanks for the update.
Judge, I've got a hearing in front of Judge Carnesel. Can I step out for like 20 minutes to do that?
Sure. No, go do that. Did you all get the orders?
Yes,
They-
they've been submitted to the.
Great. They are at the appropriate places. Okay. Thank you.
Thank you.
And then finally, Ms. Didier, she may have been excused. I don't know. There's a Mohammed on, but that may not be Mr. Mohammed. Uh-oh, did I miss someone? Hold on one second. Ms. Didier, I have already signed this morning while we were waiting, I signed the pretrial diversion because they accepted that. So we're good on that? Trial diversion. All right. Did I not get to the very? Oh, 33. Yeah, Mr. Lowe, is he here? Oh, he can go. He is with another docket. You could take him to 7E. Was there anyone here who didn't hear their name called that they thought they had something today? No? Okay. Then Ms. Smith, I'm gonna have you go to the jury room. Lawyers can come talk to you. And Ms. Willingham, what do you still, you're waiting to see if there's, whether Foster's a plea or not, or, okay. All right. We will handle Mr. Compton's sentencing now.
Okay, I just need to talk to him for like 2 minutes.
Sure.
Good.
Okay.
Go get comfortable.
Your Honor, I have, an appearance in front of Judge McAfee at 11, and then, I need to run down to check on our preliminary hearing at 1 p.m., but I don't know like that.
Okay, if Ms. Nelson knows how to reach you, we can just let you know. Mr. Johnson can let us know when, I may recognize when he comes on in, but when Mr. Jones gets here, we'll just want to let you know that he's here so that you can, if you can be diverted or whatever. I mean, if he gets here in 10 minutes, then you should feel free to go now as long as we have a good way of reaching you.
Absolutely, and I can come, right back.
Okay.
Thank you.
Mhm. Yes, but Mr. King's not here yet. When I see, but he is, that's another add-on is, and we have a revocation. Oh, that's Ms. Ford. That's, yeah, and she wasn't here yet, but yes, Mr. Moses has decided to take a plea.
Yeah.
Come stand right here, Mr. Conley.
Mr. Body, you ready? All right, Ms. Allen, we're going to get on the record. This is position 1 on the trial calendar. It's case 23 SC 187611, State versus Compton. Mr. Compton is here in court with his lawyer, Ms. Wood. Mr. Abate is here for the state. And on an earlier date, and good morning, Mr. Compton.
Good morning.
On an earlier date, Mr. Compton entered his plea in this case, and the state put on the record its recommendation, what it was committing to. Mr. Compton said he understood that and wanted to move forward with it. We didn't get to the sentencing piece because Mr. Yancey, who's the decedent in this case, his family didn't have adequate notice when we took the plea. And so I wanted to be sure that the state had an opportunity to have any members of Mr. Yancey's family to be present, or if they had impact statements that they wanted Mr. Abate to share, they'd have an opportunity to do that. So, Mr. Abate, why don't you start by stating again what the state's recommendation is in the case, and then I'll turn it over to you if there is any victim impact, anything.
The recommendation made by the state.
You may need to move the microphone towards you.
The recommendation by the state at the last hearing that we had was 20 years to serve 15 years in custody, with the remainder to be served, the balance to be served on probation, Your Honor.
And that was a reduction of the murder count to voluntary manslaughter.
That is correct.
Okay, and then the felony murder was vacated, aggravated assault would merge. And so was it 15 for the voluntary plus 5 for the firearm, and that's the 20 to do 15?
That's correct, Your Honor.
Okay, that was my recollection.
Members of Mr. Yancey's family are present. His mother, and I believe it's his grandmother, are present, or his aunt. I'm so sorry, I'm wrong. But she, and I will express for her, and then she may feel comfortable making a statement. I can wholeheartedly say that she does not, their family does not agree with the resolution, and I completely understand why. But looking at the totality of the circumstances and all the facts and circumstances through the investigation of Detective Sinling with the Atlanta Police Department, the state felt this was the best recommendation and outcome. So
balancing the risk of going to trial and not a favorable outcome for the Yancey family versus the certainty of a plea. And yes, it's a different sentence, but there's a different level of closure.
correct, and it allows Mr. Compton to take responsibility for his actions that night.
Okay. So I'm happy to hear from either or both of you. It sounds like Mr. Abate and people on his team have had some good conversations with the family where you've been very candid in an understandable way about your feelings about how this has played out. If there's more you want to share with me, I'm happy to hear that. You also may say, we've spoken our piece, but I want to make sure you have that opportunity. Okay, what I'd ask you to do is come on up to the prosecution table. If you could take a seat in the middle seat. Our court reporter is virtual, and so she needs to be able to see and hear you. Good morning.
Good morning.
So if you could let me know your name and your connection to Mr. Yancey.
Yes, my name is Latina Mitchell, Latina Mittchell. I am Beyonce's mother.
Thank you for being here.
Thank you. I wasn't prepared today to say anything, but sometimes you have to speak from your heart. Beyonce was a grandchild, a son, a nephew, and a cousin, and a friend. I don't know what happened that day or how everything went on, but what I do know is my son is okay. I'm not a big believer on, religion, but God has showed me that my son is okay. It was so hard just to deal with what I'm going through. The only person that could make me feel okay was my mother. And my mother died 5 months later. I don't know how to bear with this. I have breakdowns still. I can barely work, nightmares. I'm trying to pull myself together and what my son would tell me to do. Sometimes I feel like I'm not even myself half of the time. When I heard the last court case with the sentencing, I heard.
When you say the last court case, meaning the co-defendant?
Yes, sir.
No, the sentence.
Not the sentencing, the plea that was given. I heard Mr. Compton say that his girlfriend was his everything. My son was my everything. I'm glad you get to see your everything every day, through visitation, through writing letters, even when you get out. And I would hate for someone to sit up there and not have that everything, to see that pain and that heart. I'm just a mess every day. And I have the support of my family, but sometimes you're by yourself. I have by myself. I don't have my son anymore. I don't have my mother anymore.
Was he your only child?
He was my only son. I have a 12-year-old daughter.
Okay.
And when you're going through mental breakdowns and you can't be there for that 12-year-old, and you don't see what she's going through, it's hard that I have to sit up there every day and be faced with this opportunity to sit up here and just be okay with this. But I'm glad that God has covered me, secured me mentally and physically. Me and my family are going through it. Just losing people back to back. Holidays are not the same. Birthdays are not the same. And I have to go to a cemetery to celebrate my son and my mother. And it's hard. I appreciate the courts for everything. I appreciate you, Mr. McBurney. I'm going to get through this. I just pray that God will be with you, Mr. Compton. I pray for his family and everything. Thank you.
You're welcome. You're very gracious with your words. And I want to share one thing with you, which is it doesn't have to be okay. You said that, you're just trying to make this okay. What happened wasn't okay. It doesn't have to be okay. What you want to focus on is your healing and being there as best you can for that 12-year-old, because you are still a mom. You'll always be a mom to Mr. Yancey, but you're connected with him in a different way. In a much more tactile, present way, you're connected with your daughter. And so the more you can try to heal through this, the better it will be for your daughter. And hopefully that's a motivator for you to keep moving forward. But I don't ever want you to think that for some reason this needs to be okay. No one is saying it's okay. This resolution is a way to bring closure to it in a way that can be sometimes less painful than if there's a trial and everyone's looking at pictures of what happened, and that can be even more disturbing. So I wish you the best as you continue to recover from this. You won't forget, but in a very healthy way, you already seem to be extending grace to Mr. Compton, which means you may have already gotten your arms around the anger, and so it's the grief that remains. But I appreciate you taking the time to be here and sharing the ongoing impact this has for you and for your family. I wish you the best. You're welcome. Anyone else? You don't have to say anything at all. If you do, you need to switch places so the court reporter can hear you. Well, okay, all right. Thank you, Ms. Mitchell. Anything else from the state?
No, Your Honor.
Okay, thank you for that. Ms. Wood.
Thank you, Judge. Mr. Thompson is 22 years old, Judge. He is from Atlanta. He does have family support. I'm not sure, as you know, when we took the plea, he had his significant other who was here all day. I did reach out to her, and I'm not sure if she was able to log on virtually, but he does have that support. He does have one young child with her. Your Honor, he's accepting responsibility. I know at some point in this journey, we had talked about the possibility of him wanting to go to trial and argue self-defense, because as you know, there was the co-defendant and there were other people involved. I think that would have been quite tricky.
Given the number of shots fired, I think it would have been complicated.
Yes, Judge, and so we appreciate Mr. Abadi working with us on this case. He is accepting responsibility. He has been in custody 288 days, so we've asked for that credit. And then finally, Mr. Compton had asked me, part of our negotiations, I had asked, or he wanted me to ask that the 5-year probated sentence be suspended, to be more in line with what Mr.
Chalmers?
Yes.
Okay.
But that's all.
Okay, got it. I appreciate that. Mr. Compton, you have the right to say something if you want to. You don't have to say anything at all. But in the same way that I need to hear from any of Mr. Yancey's family members if they want to be heard, I need to hear from you. If there's something you want to add, you and I spoke during the plea part of this process, so we've already had some of that conversation. But if there's anything you want to add, this is your opportunity to do so. No? Okay. Well, Mr. Compton, I do find, I probably said this before, but we're going to double cover it, that there's a factual basis for your plea and that your plea was knowing and voluntary. Knowing means you've understood the things we talked about. Do you have any questions about any of the things we discussed today or last time we were together? You got to say it out loud.
No.
No, okay. Voluntary means no one's forcing you to enter this plea. It doesn't mean that you're enthusiastic about it, but it means you've decided that this is the right way to move forward rather than going to trial, running the risk of a guilty verdict, which could result in a sentence of up to life without parole. Is it fair to say that your plea is voluntary?
You have to say yes. Or if it's, do you feel someone's forcing you to take it?
Do you feel like anyone's forcing you to enter this plea, Mr. Comp? I'm not asking if you're excited about it, but I need you to tell me that no one's twisting your arm or saying, I'm gonna hurt your girlfriend if you don't plead guilty or something like that. Is anything like that happening? No? You just say it out loud.
No.
Okay, you made it through. Ms. Wood, any objection to having someone in my office sign for you and sign for Mr. Compton on the indictment?
No, Your Honor, thank you.
Mr. Abadi, can someone sign for you? We'll do that. So Mr. Compton, count 1 of the indictment, murder, the state has reduced to voluntary manslaughter. I'm sentencing you to 15 years to serve on that. You will receive credit for every day you've been in custody in connection with these charges. Count 2, felony murder, is vacated by operation of law. Count 3 merges into count 1, no sentence to count 3. Count 4 is a 5-year sentence that must run consecutive to all other counts, so it'll run consecutive to count 1. It will be 5 years, and I am going to probate it. I think your situation is a little different from Mr. Chalmers, and I think giving you some connection with supervision upon your release makes sense. The only condition of probation that I'm going to impose is that if you don't do it while you're in custody, is that you get your GED. You told me you got close to graduating, this close, and I want you to finish that. So you'll need to get your GED while you're on probation. if you don't get it while you are in custody. Mr. Abadi, anything else from the state? All right, Ms. Wood, anything on behalf of Mr. Compton?
No, Judge, thank you.
That's it. Thank you. And thank you again, Ms. Mitchell, for taking the time to be here. All right, we don't have a prosecutor in here, so I don't know what else we're gonna do.
Oh, Ms. Smith, Ms. Smith.
Oh, Ms. Smith went outside?
Ms. Smith.
Oh,
Ms. Smith.
you're not using your outdoor voice. Hey, Ms. Smith. Psst, Ms. Smith. I didn't mean to interrupt. You can go back to that conversation. I just wanted you to lay out if there's something you're ready, a plea you're ready to do. We could do Ms. Chambers. I think we have a couple other folks who maybe were ready. If they don't involve Ms. Wood, I think Ms. Wood is diving into talking with people there. If we can find Ms. Cabrera.
Ms. Wood, yeah, Ms. Cabrera, we could do, Ms. Chambers.
Okay.
All the rest of the pleas are Ms. Wood.
Ms. Wood. So why don't we try to do Ms. Chambers's plea, and then maybe Ms. Wood will be ready on one, and we'll pivot to that. Did you need to finish the conversation you were having?
It was with her, so I'll just go here.
Okay.
It wasn't about Chambers.
Okay.
Yeah.
Oh, nothing for,
Yes, Mr. Dumbuya, let me find him in here. So I'm keeping up. Position 19.
we agreed to the continuance.
Well, you all can agree to a continuance. It takes 3 on that one.
So in this case, Judge, I had opportunities, I got some additional discoveries from Attorney Lane, and I followed up on that discovery. We just had a conversation, we're still kind of far apart regarding what the resolution in this case would be. So I told them that the likely next step would be trial. I did speak with the victim in this case, who told me that he is a truck driver, 18-wheeler, and he will be in Chicago the week of June 22nd, so he would not be available for trial.
Okay.
So we're asking for the continuance, so at this moment, because it's not resolved, we ask for it. Stay on the trial calendar.
And there's no objection from the defense to the continuance. Okay. I think we're past final plea here. So if there is a plea, non-negotiated or not, that it would something that would be binding on the defendant. But it sounds like the two sides are far enough apart that it's not going to be a non-negotiated plea today. Is that a fair statement?
Yeah.
Okay. And this isn't one where it makes sense that, well, maybe we'll reach it next week because your victim is out of pocket.
That's correct.
Okay. All right, then that's what we'll do. Mr. Dumbuya, you will get notice in the mail, but more importantly, Mr. Lane will be in touch with you when this case is next on a trial calendar. And that's where it's staying. It's just going to keep being on a trial calendar. So I'll let Judge Ellerby know that if next trial calendar, the answer is we don't agree, then we need to try the case. Because you don't need to agree. It may be that you're far apart and the jury will figure that one out. This will be the one continuance absent the unavailability of a witness. But assuming all the pieces are in place for the next trial calendar, it's either resolved or a jury sorts it out. Okay? Mr. Dumbuya, do you have any questions for me? All right. Ms. Smith, anything else?
Nothing further, thank you.
Mr. Lane? All right, you all are excused.
Chambers is on, person, but she represents and Mr. Spit it out.
Greer?
Mr. Bates is a plea negotiated. Ms.
Excellent.
Chambers is a plea negotiated. Mr. Greer, we will come back to maybe later than today.
Okay.
So if he can be released, he has a homework assignment that he's going to get through, and I will talk to the state.
Does his homework assignment, it's something that could lead to a resolution? You don't know. It's in that direction. Okay.
Or changes what the state's current recommendation.
Right, that's what I mean, is that it's something that isn't, that you ultimately could be handed to Ms. Smith.
Yes.
Okay,
Yes.
all right. Mr. Greer, do you have any questions about what's going on? Okay, do you know what your homework assignment is? All right, work on that and stay in touch with Ms. Cabrera, okay? All right, you're good to go.
You're welcome.
So, we're gonna do Ms. Chambers now? That the preferred? All right. So Ms. Allen, this is position 34 on the trial calendar, and let's find Ms. Chambers.
Sorry, I'm here.
Down Mr. Ingram, while we're waiting on Mr. Washington to do that.
Yes, you're gonna be handling that bond hearing? Yeah, we'll let you know. We've got Ms. Gibson's phone number, so we'll let you know when Deputy Gordon says the right Mr. Washington is here. All right. And I saw Mr. King.
He was in the hallway.
Okay. All right.
He went to Ingram, Judge.
He's going to Ingram also?
Yes, he's coming right back.
All right. Ms. Chambers, can you hear us?
Yes, sir, I can. Good morning.
Great. Good morning. It sounds like your internet is back on.
Yes.
All right, well, let's tackle this while it's going.
Scurry through it while we can.
Yep, so we're gonna get on the record. This is position 34. It's 25 SC 006136. Ms. Chambers is one of 4 defendants charged in this armed robbery case. And we've taken one plea and then one of the other cases has been resolved. Quick timeout. Mr. King, good morning.
Hey, good morning, Judge.
Mr. Moses is here. Is he up?
Yes,
Do you need to talk with him?
I would say no more than a minute, Judge. 'cause-
Okay. Well, we're in the middle of a plea. I just wanted to make sure if you needed access to him, you got access.
Yeah, I want to talk to him real quick just to make sure we're on the same page, but I think we're good.
Okay, great. Back to Ms. Chambers. Ms. Chambers is appearing virtually. Ms. Cabrera, her lawyer, is here in court, and Ms. Smith is here in court for the state. Ms. Chambers, in a moment, Ms. Smith is going to put you under oath and ask you a bunch of questions about your case and your rights. You need to answer her questions truthfully and completely. You also need to let me know if at some point you cannot hear what's going on because there's a bad connection or whatever's being said is confusing to you. Will you do that?
Yes, sir.
Good. I have 2 questions for you before Ms. Smith starts. Ms. Chambers, are you willing to waive your right to be present here in court? You have a right to be here in court, but you can waive it and appear virtually. Are you waiving that right?
Yes, sir.
Okay. You also have a right to have Ms. Cabrera right next to you, so you guys could have a little huddle and talk. She is here in court. Are you waiving your right to have your lawyer by your side for this plea?
Physically, yes.
Okay. If you need to speak with her, let me know. She can step outside and call you up on your cell phone and you guys can have a private conversation, okay?
Yes, sir.
Excellent. Let's get started, Ms. Smith.
Thank you, Judge. Before starting, I just wanted to inform the court that counts 1, 2, and 5. So that's the armed robbery, ag assault, and kidnapping charge will be no process in this case. And the state will be moving forward with count 8, which is financial transaction card theft.
Got it.
Ms. Chambers, please raise your right hand.
And make sure you speak up loud enough.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Ashley Chambers.
What was that first part? I'm sorry.
Ashley Chambers.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
31 and I have my associate's degree.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
Sure.
Ms. Chambers, do you remember being arrested on these charges?
Yes. Can
What'd
you
you
hear me?
say?
Yes.
Okay.
Yes.
We hear you better now.
The state is
Sorry.
unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No
warrants.
Okay. Ms. Chambers, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 3 years probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge?
Yes.
I can't hear you.
Yes.
Okay. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
I'll repeat
You
that
said
part.
yes.
Oh, she said yes?
Mhm.
Okay. Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Are you a United States citizen?
I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Ms. Cabrera, is this under first offender?
Yes, it is.
Ms. Chambers, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained what the First Offender Act is to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for the charge in this indictment?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Ms. Chambers, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 006136, how do you plead to count 8 financial transaction card theft?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to directly appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that that process must be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Okay. Thank you, Ms. Chambers. Judge, if this case were to proceed to trial, the facts would show that on August 6, 2025, officers with the Roswell Police Department responded to a robbery call near the Roswell North Elementary School. That's at 10525 Woodstock Road. That's also in Fulton County. When the officers got there, they spoke with Miss Johnny Pierre, who's the victim in this case, who stated to the officers that she was meeting an acquaintance identified as Miss Ashley Chambers. They met a week prior at a store where they exchanged information. They got to know each other, and then they further communicated about meeting up later that week to open a bank account. In this case, they were opening bank accounts all together so they could put checks in the account and get the money out. So on this day, August 6, 2025, they all agreed to meet up. When Miss Pierre got to the meetup location, she saw Miss Chambers, the defendant in this case, and 3 others that was in the car with Miss Chambers. Miss Chambers was not driving, she was the passenger. So in this case, Miss Pierre got in the car with Miss Chambers and the 3 other people. And how they were set up in the car is you had Mr. Cotton, who's already pled in this case as the driver, Miss Chambers as the passenger. Sitting behind Mr. Cotton was Mr. Thomas. In the middle was Miss Junicent, and behind Miss Chambers was the victim in this case, Miss Pierre. In this case, Mr. Cotton took the group to a couple of banks where Miss Pierre was supposed to get out, create these bank accounts in an effort to get money for the group. So after they went to a couple of banks and nothing came from it, the group grew irritated of Miss Pierre. And at that time, Mr. Cotton and Mr. Thomas, well, at that time, Mr. Thomas is reported in the report that he pulled out a gun to force Miss Pierre to give him all of the money that she had. Kind of simultaneously, Mr. Cotton, the person that's driving, hits Miss Pierre in the face. After that, he takes her bag where she has her credit cards.
Mr. Cotton takes the bag.
Mr. Cotton takes Miss Pierre's bag and gives it to Mr. Thomas to go through and take her credit cards out. After that, Miss Pierre was let out of the car. Mr. Cotton told her to get out. She got out. They still had her cards. They still had her personal information like her ID and things like that. So after this, after the group let Miss Pierre out, they traveled to a nearby convenience store. When they went to that convenience store, the entire group got out of the car. They then went inside of the store where they purchased boiled peanuts, drinks, different items like that. And half of that purchase was paid for with cash, and the other half, as it's reported, was paid with Miss Pierre's, the victim in this case, credit card or her time card. Because of that, at the time, the person who was in possession of those cards was Miss Chambers. She had her ID and also her time card. At that time, the Roswell police officers pulled up to the gas station because it was a bundle out for the car at that time. Officers were able to detain all of the 4 people who was inside of the car, including Miss Chambers, but she was in a bathroom prior to coming out and being detained. Officers went inside of that bathroom where they found Miss Pierre's ID and her time card that was used in the transaction. Because of that, Your Honor, the facts and circumstances of the case, nor processing those other 3 charges, but keeping the financial transaction card theft based on these facts is the reason why we're going forward with count 8. I have talked to the victim multiple times, and she told me that Miss Chambers, she does not believe was involved in the actual armed robbery because she did not contribute to it or yell at her or anything else. Miss Chambers just kept quiet. However, she was comfortable with us moving forward on count 8 because her card was used and was in the possession of Miss Chambers at that time. Those are the facts and circumstances of the case. Regarding the negotiated plea between the state and defense, we've agreed to, for count 8, 3 years probation. Regarding those special conditions of probation, we're asking for the defendant to complete an anti-theft course, to have no contact with the victim in this case, to also have no contact with the co-defendants, to complete 40 hours of community service, and also to testify truthfully at trial. And that is all from the state, Your Honor.
Got it. Okay. And is there restitution for the boiled peanuts and sodas or?
Not at this time.
Not at this time. Okay. All right. Ms. Harvey from pretrial, good morning.
Good morning, Your Honor.
Can you share whatever information you have about criminal history for Ms. Chambers?
Yes, Your Honor. 5 cycles out of Georgia and 1 cycle out of the state of South Carolina. Does not appear to have any prior felony convictions. The last arrest was February 11th, 2024 out of Clayton County for driving on a suspended or revoked license. There was no disposition listed for this case. There are 2 misdemeanor shoplifting convictions, one from 2011 out of South Carolina and one from 2014 out of Clayton County, and nothing further, Your Honor.
Got it. Thank you so much. Ms. Cabrera.
Yes, Judge. So, Ms. Chambers is 31 years old. I am definitely going to be asking that Your Honor accept the pleas negotiated. She does her best to get here back and forth to court. Today was not the best day, but she usually tries to Uber or tries to do something to make sure that she's here. She's been incredibly cooperative. She had an opportunity to speak to the state to bring them up to speed on what her involvement was in any of this and what may have happened, which I think was helpful. I would be asking that her plea be allowed to be entered under first offender, and that if I provide an order to the court, that it be done under seal. There are things that she definitely still wants to do, and she does not want this following her at all.
Okay.
So.
All right. Ms. Chambers, anything you want to add?
All I can say was this was, I can't even think of the word. I do, apologize for any involvement. I just felt like I was in the wrong place at the wrong time, honestly. So,
Who did you know who was in the car? You obviously knew Ms. Pierre in the sense you guys had met, but did you know Mr. Cotton or Mr. Thomas?
I did know Mr. Cotton. He's a friend, but obviously I'm not that best of a friend or good of a friend or a close of a friend to not get the information that you were about to do something dumb. So I don't even really blame anybody.
Okay. Yes. Got it. Is your driver's license situation fixed or what is happening with that?
Yes, sir. Yes. My driver's license, I had to take a driver's class and everything for that situation. So yes.
All right. Are you working these days?
I am trying to. I am not gonna lie. This case has put a bundle on my career right now. With this popping up on my background, I'm an X-ray tech, so I cannot get in my field with this. So currently, I am working, but I'm not in my field. I am.
And what did you say your field was? I didn't hear you.
I am an X-ray tech.
Say it one more time.
I am a radiologist. I take X-rays.
Oh, radiologist. Got it.
Sir.
Okay, right. No, you can't be doing medical stuff with this open arm robbery charge. Okay.
Yes, sir. Yes.
Ms. Chambers, I know you and Ms. Cabrera talked about first offender, but I need to talk to you about it as well. You qualify for it. It is essentially a good opportunity for you. It means this is not a conviction. It means that even though you'll be on probation, you're not a felon. You don't need to check that box. And Ms. Cabrera is going to be getting me some paperwork that ought to seal up your record from the eyes of would-be employers. So that should help. There is a small risk that you need to tell me you understand and that you are willing to bear. And that is that while you are on first offender probation, if you are arrested for something new, not only do you have new charges, but you could come back here and have your first offender status revoked. Because you pled guilty, I could go ahead and resentence you up to the maximum in this case. So it can end up in a bad way if you are not done with capers like the Ms. Pierre, Mr. Cotton caper. Do you feel like you understand how first offender works?
Yes, sir. Okay.
You still there?
Yes, sir. Can you hear me?
Yes. Were you able to hear me?
I heard the last thing you said was about revocation, and you would take it away if I got new charges.
Right. So you understand there's a risk to being a first offender. You understand that?
Yes, sir.
Okay. Do you want to be sentenced as a first offender?
Yes, sir.
Okay. All right. Well, Ms. Chambers, I find there's a factual basis for your plea and that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to plead. Do you agree with that?
Yes, sir.
I will sentence you as to count 8 because the state is dismissing the other counts that were brought against you to 3 years probation. Special condition number 1 is that you will testify truthfully should Mr. Thomas's case go to trial. Special condition number 2, you will complete 40 hours of community service. Number 3, you'll complete an anti-theft course and probation can help you find one of those. And finally, no contact with Ms. Pierre while you are on probation, and also no contact with any of your co-defendants. So insofar as you and Mr. Cotton were friends, you need to stay apart as long as you are on probation. Any questions about that?
No problem.
What
No,
county do you live in?
I live in Clayton County.
Okay. Do you want to get a phone number so you can give her a call?
But she has the phone number and the mailing address.
Okay, I just need to get her.
Okay. In just a moment, Ms. Chambers, Ms. Simpson from probation is going to give you a reporting date. You will report in Clayton County. You are supervised in the county where you live. So she'll give you that information and we will go from there. Anything else, Ms. Cabrera?
Nothing for me, Your Honor.
Any questions, Ms. Chambers?
No, sir.
Okay. Ms. Simpson?
Good morning, Ms. Chambers.
Good morning.
So you're going to report to the Clayton Probation Office. Do you have something to write down?
Matter of fact. No, I'll take it over my phone though. I'm listening. Sorry.
Okay, so the address is 1331.
So Ms. Cabrera is writing this down, Ms. Chambers, and she's going to text it to you, okay?
Perfect. Okay. Thank you.
So your reporting date is going to be June the 26th at 8 a.m.
Yes, ma'am.
And your attorney is going to send you the address and the contact number.
Okay.
Thank you.
Thank you.
And both of it, June 26th. June 26th, the time, 8 a.m. I sent it to you.
Is that it?
Yes, Judge.
All right. Thanks, Ms. Chambers. You're good to go.
Thank you. You have a good one.
I have one other plea, if Your Honor is interested.
I'm always interested in your pleas, but I did. But I need to give an update to Mr. Johnson. Mr. Jones sent an email. He is still in Walton County. The judge there just took the bench, so he will be here. He is forecasting after lunch at the earliest. So you should feel free. You're welcome to stay right here, but if you want to go find lunch and be back by 1, Mr. Jones should be here by then. Okay? That is my update. Did you end up talking with Ms. Tembeka? I don't see her. She's coming back. Okay, I just thought since we were on this case, we would talk about Mr. Thomas, but we'll come back to it. You have Mr. Chamber? No, Ms. Chambers we just did. What's your other case?
So the next one I would have is Mr. Bates.
Mr. Bates, are you able to do that?
I am, but can I have a second to call the victim? I didn't know.
Of course. Ms. Rios, you ready to go on anything?
I hope we ready. I said, no, we were gonna discuss it.
Ready. Dry Reynolds.
Is ready? Is that a Ms. Smith case?
Yes.
Okay. We will do it right after. We're going to knock out Ms. Cabrera's other plea, and then we'll do Jerron Reynolds.
Huh? Yes. My other courts gave me virtual ones.
Look at that. It's our turn to get you, and they have to get you virtually.
I got 2 virtual ones. One of them has clients in deals.
Okay.
what you think?
Your Honor, may I take a point of privilege and just say how proud that I am of Ms. McBurney when we were young lawyers and she was just what were you, case manager? And look at her, she's like blossom and she's a big time lawyer.
I still have one of her business cards because I took over Judge LaGrua's chambers.
Yes.
And so there's a Euphemia Cabrera, I may have had a different last name, litigation manager card. I love it. It's a collector's item.
I mean, I feel like we have kind of like planted seeds and now she has blossomed. So I don't know if we should be more proud of us or her because she has reached this point. I just wanted to say that. Is that okay? Or no?
Well, it doesn't matter. You said it, so hopefully it's okay.
I think.
I'm seeing his back in this. So
Yeah, he been looking for you all morning. I thought he was in the jury room.
I was talking about he was taking. She's working.
Ms. Jones, what did you hear from Mr. Campbell?
Just that he had a couple of hearings.
Oh, okay, it's nothing new. It's that he went sort of like Attorney Jones, same thing. Okay. Do you want more time and we do a different plea or you're good?
I didn't get her, but she knows about I just didn't know she wanted to speak or not.
Do you guys know there's a restroom in the jury room? Yep. Go through there and then look to your right is the jury room. So you're good going forward. All right. And where's Mr. Bates? Come on up, Mr. Bates, please. All right. Let's get on the record, please. This is position 14 on our trial calendar, State versus Jason Bates, 25 SC 003518. Mr. Bates is here, so we'll have better sound with his lawyer, Ms. Cabrera. Ms. Smith is here for the state. And Mr. Bates, my understanding is you're prepared to enter a plea in your case now.
Yes, sir.
Okay. Ms. Smith will put you under oath, ask you a bunch of questions. You've heard what they are because we just did this with another client of Ms. Cabrera, so this will be fairly similar. Please answer the questions to the best of your ability, and please let me know if you have any questions of your own, okay?
Sir.
All right, Ms. Smith?
Mr. Bates, please raise your right hand.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can lower your hand. Please state your true, correct, and legal name for the court.
Jason Cornelia Bates.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Ma'am, I might not be feeling up the part, but I'm still all right.
Meaning you're not feeling well?
Yes, sir.
Okay, but you feel like you can go forward with this process?
Yes, sir.
All right, if you need to take a seat at any point, let us know.
Yes, sir.
How old are you and how far have you gone in school?
To the 9th grade, I'm 43.
You're how old?
43.
Are you able to read, write, and understand the English language?
Not as well like that.
If you need anything explained, let me know.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Good.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So
Mr. Bates, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
no more.
No warrants.
Okay. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
I didn't, you go back over that again?
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Bates, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 003518, how do you plead to count 1, aggravated assault, count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies, and count 3, receipt, possession, or transport of a firearm by a convicted felon?
Guilty.
You say,
Yes, ma'am.
okay. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right. Thank you, Mr. Bates. Your Honor, if this case were to proceed to trial, the facts would show, my apologies, that on November 2nd, 2024, officers of the Atlanta Police Department was dispatched to 205 Harwell Place, Northwest Atlanta, Georgia, 30318. That's also in Fulton County. They got a report about a person being shot. When they got to the incident location, they went to an apartment complex that was owned by the victim in this, or rented by the victim in this case, Ms. Cardwell. When they got there, they noticed shell casings in the parking lot and the bullet hole in the upstairs apartment unit, Unit B, that was being rented by the victim in this case. The EMS forced entry into the apartment where they found upstairs Ms. Joyce Cardwell. She was lying between the bedroom and her bedroom in the hallway. She had a gunshot wound to her stomach. She stated to the officers that there was a fight going on outside. So this is an apartment complex we're talking about. There's a fight going on outside. She looks out the window, and while she looks out the window, she hears a shot. And before she knows it, she's the one that has this gunshot wound to her stomach. At this time, she was alert, she was present, and she was taken to Grady Hospital by EMS. After she was taken to the hospital, the officers then did an investigation where they found out that two of the people that were fighting in that parking lot was the defendant, Jason Bates, and also Ricky Hightower. They were arguing about, I don't know what it was about, but at that time, Mr. Bates took out a gun, tried to fire at Mr. Hightower. However, it missed Mr. Hightower and shot Ms. Cardwell, or it went through her window and she was shot. The state got a chance to speak with Mr. Ricky Hightower, who was incarcerated at Fulton County in this case, where he told us and confirmed that it was Mr. Bates that he was arguing with that night, that it was Mr. Bates that took a shot at him, missed it, and it went through Mrs. Cardwell's window where she was shot. In this case, I spoke with the victim, Ms. Cardwell, who said that at this point, she just kind of wants the case to wrap up because it's been a very long time. She said that she is still sometimes dealing with back pain, fatigue, and things like that. She told me that she's kind of older, so a lot of these things come with age, but also it's worse than because she did get shot. She said that she does not know Mr. Bates. She moved out of the apartment complex after this, and she has not returned since. I did talk to her about the probated offer in this case. It was encouraged by her because she wanted the case to be resolved. She does not believe that Mr. Bates intentionally tried to shoot her because they don't know each other, and she knew that he was trying to shoot someone else. However, she wants him to take accountability for what happened. So with the facts and circumstances of the case, and also with the talking to the victim about what a resolution would look like in this case, the state is offering 10 years of probation for the charges we have in this case. Regarding the special conditions of probation, the state is asking for the defendant to stay away from the incident location. It's my understanding that he had maybe a godmom or grandma who lived in that apartment complex. I'm not sure if she still lives there. However, we would ask for the defendant to stay away from the incident location. We will also ask for the defendant to have no contact with the victim. Again, she does not believe that he knows who she is. However, through discovery and learning her name and possibly someone else knowing her from the complex, the victim in this case will ask for no contact. We're also asking for the defendant to complete an anger management course and 40 hours of community service. And that is all from the state, Your Honor.
All right. So Ms. Caldwell or Cardwell, she's okay with not more jail time for Mr. Bates.
That's correct.
And Mr. Hightower, I know he's not listed as a victim, but that's who Mr. Bates was trying to shoot.
Yes.
He's okay with this.
Well,
You may not have asked him
when I went to speak with him, he just kind of told us about what happened that day.
what the deal was.
What he felt about jail time for Mr. Bates.
Okay.
And to add on to that, Your Honor, we had previous conversations where custodial time was the offer that was given in this case. Back in February, the case was on the trial calendar where we
To continue it because the
continued.
detective wasn't available.
Correct. But during that time, I have been speaking with Ms. Cardwell, and her biggest concern is to have to come to court to testify, to go through the trial. So she said this resolution is something she's okay with because she wants the case to wrap up. And she would just hope that Mr. Bates would take accountability and not get into any more trouble over the next 10 years.
Okay. Got it. And Ms. Harvey from pretrial, tell me about Mr. Bates.
Yes, Your Honor, 33 cycles, convictions from 2022 for aggravated assault, simple battery family violence, possession of a Schedule I controlled substance, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. 2020, possession of marijuana with intent to distribute. Also, 2020, sale of cocaine and sale of a Schedule II controlled substance. 2020, possession of a firearm by a convicted felon, possession of a firearm during the commission of a felony, possession of cocaine with intent to distribute, possession of MDMA, possession of a Schedule I or II controlled substance. 2012, possession of cocaine with intent to distribute, and 2001, aggravated assault. And nothing further to add, Your Honor.
That was plenty. Thank you.
You're welcome.
Ms. Cabrera.
Yes, Judge. I'm asking that Your Honor accept the, plea as negotiated. He has, mental health issues. He got some physical issues, ulcers and other stomach issues. He is, in the process of starting therapy at a program down on Edgewood, where he will receive counseling. With his stomach issues, he's often, admitted into the hospital. So whenever he goes into the hospital for the ulcers or anything, he's admitted. So that was one of my concerns as it relates to, community service. I'm just kind of, I don't want to set him up to fail the community service. But that was my concern, and I did speak with the state about that. So she actually did cut the community service hours by what she initially had requested. There are bipolar issues and things like that that he's managing. He is on disability. While he was in custody, he lost a disability, so he is going back through the process of getting back onto the disability that he had. He has children, he has grandchildren. He's supported here today. So I'm asking that Your Honor accept this plea as negotiated. I do not know that he is eligible for any sort of behavior incentive date. If he were, then I would ask for that, but that's what I'm asking for, Your Honor.
All right. Mr. Bates, how many kids do you have?
I got four. I got four children. I got 2 girls and 2 boys, and I got 4 grandkids.
It's a good collection. Are they local?
Yes, sir.
Tell me, are you taking medication now for any mental health diagnosis?
Well, I'm starting my I'm starting it up. My what the word I'm looking for? I'm starting
Have you used to take the medication?
Yes, sir.
And then you stopped?
Yeah, I got to start out back over with my disability and all that.
Okay, so without the disability, you cannot afford the medication?
Yes, sir.
What were you taking before?
They had me taking Seracrid, and they had me taking some Hound Dog.
Well, yeah, the names don't matter to me so much as for what were you taking them? What did the doctor say you were taking it for?
Bipolar and schizophrenic.
Okay, but right now you're not taking that medicine.
No, sir.
Do you feel like you're understanding what we're doing?
Yes, sir.
When's the last time you worked?
Last time I worked, it's been a minute.
Okay. And where do you go on Edgewood for therapy? What's the name of the place?
It's right downtown. Yeah, I don't know. I can't recall it.
But you know how to get there?
I know how to get there.
Okay. And where are you staying these days?
Well, I'm staying with my fiance, her friend.
Oh, but what part of the city is that?
Fulton County.
It's in Fulton County. Is it in Atlanta or?
In Atlanta.
Okay. What neighborhood is it in?
It's on the west side. It's on west side.
Okay. How long have you been engaged?
I've been there at least about 4 months now.
It's a new relationship.
Yes, sir.
How'd you guys meet?
Well, my fiance, she been knowing her friend for a little minute. So she she rent us a room now.
Okay. How do you know Mr. Hightower?
I don't really know. I know him because of my girl.
Okay. And what were you guys arguing about?
We want to argue with him and another dude named Brian were arguing.
Okay. And how'd you get mixed up in that?
I don't know how I get mixed up in that, sir. I guess because, cause on down the line, I was trying to defuse the wedge. I was trying to defuse it, but it wasn't me. It was the other guy who he thought it was me, but I was trying to defuse the fight what they were going at it with.
Okay. Do you have any questions about anything we discussed?
No, sir.
All right. Well, Mr. Bates, I find there's a factual basis for your plea. This is a real tragic situation. We're lucky Ms. Caldwell wasn't more seriously injured. I know you weren't aiming at her, but when you pull the trigger, you don't control where that bullet goes. Hitting Mr. Hightower wouldn't have been a good thing either, but Ms. Caldwell didn't have anything to do with anything. She's minding her own business and you shot her in the stomach. Well, I find there's a factual basis and that your plea is knowing and voluntary, meaning you've understood what we talked about, and that no one's forcing you to enter this plea. Do you agree with that?
Yes, sir.
Okay. Ms. Cabrera, do you authorize someone in my office to sign the indictment on your behalf and Mr. Bates's behalf?
I do, Your Honor.
Ms. Smith, can someone sign for you?
You're good.
All right. So Mr. Bates, Here's how I'm gonna handle this. Count one, I am sentencing you to 5 years to serve 3 months with the balance on probation. You've already served the 3 months, so you get credit for that time. Count two, is 5 years. It has to run consecutive to count one. I'll probate that. And then count three will be 5 years to serve 3 months with the balance on probation. That'll run concurrently with count one. So it's a total sentence of 10 years to serve 3 months, balance on probation. It's a long time of probation. I am not comfortable with just the 3 months in custody. I think this is a low recommendation. I understand why it is. It doesn't mean I have to embrace it. So I'm adding a special condition of probation. You are going to have 10 weekends in jail where you turn yourself in on Friday and you get out on Sunday. It's not going to, well, it'll start this Friday because this is only Tuesday. So you will on Friday the 19th. Let me just finish and then you can talk with your lawyer about it.
Yeah, sir, they really have been allegedly, overwhelmed for me. I'm really pleading guilty to somebody and do those, sir.
So I'm reacting to all the things I heard. Aggravated assault with drugs and gun in 2022.
Same thing too.
Marijuana, cocaine, back in 20, gun, drugs, 12 drugs. So,
Doesn't, I think his desire is to explain to you all the other cases.
yeah, that's not helpful.
It's irrelevant.
Right. They are what they are. They are with you. They are part of your profile. There are great things about you. You're a dad, you're a grandfather, you're engaged. Hopefully you're going to get your benefits back. That's why I was initially inclined to say, you know what? I think you got to go back in custody for another 3 months. So total 6 months because you already did 3. But when I heard you're trying to get your benefits back, it's not going to help if you're locked up for 3 more months. You also need to get back on your medication. So I'm not interfering with your weekdays, Monday through Friday. But for 10 weekends in a row, you're going to turn yourself in on Friday, you get out on Sunday. That doesn't interfere with your ability to get your benefits back, doesn't interfere with any of that. If you'd prefer to just do 3 straight months, we could do that instead.
When that starts, sir?
When does what start?
The weekends.
I was going to have it start this Friday. You want to wait one weekend?
I'll wait one, yes, sir.
So have it start next Friday? Okay. So it'll start the 26th. And every Friday then for 10 weeks, you turn yourself in, they process you out on Sunday. So next Friday we'll do that. That's special condition 1. Number 2, what's the name of the apartment complex there? Do we know, or we just say Harwell Road? Do you remember the name of those apartments?
Yes, sir.
What are they called?
Dogwood.
Say that again?
Dogwood.
Dogwood?
Yeah.
Does your godmother still live there?
No, sir.
Good. You're gonna stay away from the Dogwood Apartments on Harwell Road.
Ran away from them.
Good. Keep doing that. You're gonna do that for 10 years. No contact with Miss Caldwell. That's easy. You don't know her. She doesn't know you.
I can speak something to my lawyer.
Yeah.
About, good behavior.
What about?
When you say good behavior, sir, it's like.
Well, I asked Judge about that. He was inquiring about the behavior incentive day.
We'll get there. So no contact with Ms. Caldwell. You're gonna need to do 40 hours of community service, and you're gonna need to do those within the first 6 months of your probation. Not 5 years from now, but first 6 months of probation. And you'll need to complete an anger management course. That may be part of the kind of therapy you get at Edgewood. You may be able to do that all in one, and I'm fine with that. I am also going to set a behavioral incentive date for you of June 17th of 2030. That's 4 years from now. That means if you have stayed out of trouble, no arrests, you're doing the things you need to do, because I need to add one more condition of probation, and that's that you take all medications that are prescribed. So if a doctor says, take one of the things you mentioned, Seroquel, you got to take it. It's not an optional thing. So if you're prescribed medication, you got to be taking that while you are on probation. If you've done the things you need to do and we get 4 years under your belt, no new arrests, we can close this case out early. You'll be 47 by then. You should be done getting in trouble.
Yes, sir.
Maybe you and your fiance will have settled down. But life is complicated. Hold on one sec. I know you've had some run-ins with the police before. You've been arrested 33 times. I'm hoping you're slowing that down going
Yes,
forward.
sir. I was just finna say, I haven't had no conviction since I've been out.
That's good. And I noticed that. That's good stuff. And it's another reason why I'm all right with just these weekends. I don't want to interfere with your therapy, your recovery, your family, but you're going to be away from them for a few weekends in a row. And to me, that balances these things out a little bit. I think so. I think that makes sense based on what Mr. Bates has said he's been treated for in the past.
That's specifically though. I forgot to mention.
Yeah.
He asked for that.
Okay, so we're gonna shift up your probation officer, so it's someone who is gonna be more supportive of the treatment you're getting, okay? But that means Mr. Bates is on probation now. Do we need to work through any revocations there, or that's?
He had a revocation in May of last year before Judge Todd.
Okay, got it. Then we don't need to worry about that. So Mr. Bates, you may be on probation for 2 cases. It'll be 1 officer. That'll be someone who helps you make sure you're staying current with your therapy and your medication, all that kind of stuff. Anything else, Ms. Smith? Ms. Cabrera?
Nothing further, Judge.
Do you have any questions, Mr. Bates, about what we talked about?
No, so about the, how long would that weekend be?
So you turn yourself in on Friday. If you show up at 3 on Friday afternoon, you get out 3 on Sunday afternoon. If you show up at 6 on Friday evening, you get out at 6 on Sunday evening. They keep you for 48.
Okay.
Okay?
That'll work with me.
Hope so. Don't miss any of those weekends.
I won't.
Because probation will reach out to me and then I'll say, I need to give you some straight time. And I know you don't want that.
No, you've been fair a lot.
All right. Well, good luck with things, Mr. Bates. Ms. Simpson is going to talk with you about your reporting instructions, okay?
Yes,
So you can step outside. Don't leave until you've spoken with Ms. Simpson, okay?
Yes, sir.
All right.
Thank you, Judge.
Thank you, Ms. Cabrera. Hi, Ms. Rios.
Yes, Senator, D'Anthony Owens, I sent an email about him because he missed court, I believe, on the 26th. And it was because his address was not correct in the system. And he came up here to change his address, but I guess it never went through. He's here now.
What's his case number?
26 SE 001469.
D'Anthony Owens, okay. This would be a Ms. Nix case. I don't know if Ms. Willingham is willing to weigh in on this. I think it's a Ms. Nix case.
What's the charge?
It's a registry violation. I'll give you a minute to look into things.
Give me a minute.
Yes, yes.
Can you give me the case number again? I missed it.
Okay. I'll look into it, Judge.
Sure. And so what happened was, so this was an arrest from back in February of 25, so more than a year ago. And Mr. Owens moved, so his arrest address wasn't his address for where things would have been sent, or what is the claim?
Yes, it was not, but he said he came up to update his address, but for some reason it wasn't updated. And then he called my office trying to get in touch with someone because I think someone let him know he had a court date. Who told you? Who told you he had a court date? Huh? Oh.
The clerk's office?
No, that's our office, and he called.
You have someone named Tina Robinson in your office? That's confusing. Okay. I have 2 addresses in the system. There's a Crestwood Circle and a Highwood Drive. Louder?
I said both of them addresses.
Bad addresses. Okay. Your piece of paper has a better address? All right. Do you want more time or are you?
No, I'm good. I was just gonna say, Judge, we would ultimately defer to the court. I mean, it's the defendant's responsibility, and although I understand he's saying he came to the clerk's office, we have no way of knowing that that happened, so we will just defer to the court.
Okay. Mr. Owens, is the address that Ms. Rios has on that piece of paper, does the sheriff have that address too? Because of course, the whole reason we're here is that you had an issue with the registry. They have it. Okay. That's probably the bigger issue. Let me check one thing and. Yeah, so the notice that went out for court went to the Crestwood Circle, and that's not the address that you have, Ms. Rios?
No, Your Honor.
All right, do you have good contact information in your system now? I don't just mean mailing address, but
Yes, I have his number.
email, cell phone, whatever it would be?
Yes, sir.
Okay, all right. I will lift the bench warrant, Mr. Owens, and you will get a new court date. I guess we didn't even get to, can we do an arraignment waiver now?
Yes, I'm gonna file that.
All right, so that'll take care of you. You won't need to come back to court for a plea and arraignment. We'll get that waiver of arraignment and the scheduling order, and that'll move the case along. Do you have any questions? Okay, so Ms. Rios, you will get to Ms. Nelson, change of address and an arraignment waiver.
Yes, sir.
Ms. Willingham, anything else from the state?
Nothing further, Your Honor.
Okay, thanks for checking into that one. You're good to go, Mr. Owens. Mr. Melnick.
Good morning, Your Honor.
Good morning. So you were suddenly the lawyer for, let's find the case. Mr. Willingham, who is on not a plea and arraignment calendar, but a trial calendar for which I am really searching for a case to try.
Well, Judge, I'd like to accommodate that, but I'm not sure this is going to be the one. I'm still obviously getting my feet wet on the case.
Okay. Any reason you care to share that Mr. Willingham on the eve of trial switched lawyers?
So, Your Honor, I wasn't sure. So just so you know, I've represented members of Mr. Willingham's family for a while. And they'd been talking to me about this case for quite some time. I think they kind of struggled a little bit to come up with the money to hire me for the case. But I know that they have wanted to retain an attorney to look at the case and see if there's a better resolution that we can come up with than what had previously been offered in this case. So, you know, I'm just asking that you accommodate that. I think he's entitled to have an attorney of his choice now that I'm on the case.
He is. It's all about balance. Ms. Smith, anything you want to chime in about the Willingham case?
No, Judge, we've shared all discovery with Mr. Melnick, the offer, everything that we have, he has.
Okay. Is it a particularly complicated case from your perspective? How many witnesses, if this were going forward from the state? Ballpark.
That we would actually call him before.
Okay. Okay. All right. Do you need me to speak with Mr. Willingham or he's good to go?
No, I've talked to him, Judge.
All right. Stay tuned.
All right.
That doesn't mean you need to stick around.
That's what I'm saying. Do I need to stick
Yeah,
around?
you don't need to stick around.
Okay.
But I'll be sending an email out and I'm just watching the list shrink. So we'll see what happens.
Thank you, Judge.
All right.
May I make a couple of announcements?
Yes, let's do that. And then we'll take a quick break. So our court reporter can take a break, et cetera. And then we'll pick up the plea line.
So position 11, Mr. Travis, there it is. This will be a trial, Judge.
Mr. Nelson.
Yes.
Got it. Okay.
And Judge, just for the record, the state would like to make it clear that diversion is not going to be an option after today. As your Honor knows, if the terms of diversion are completed, the case will be dismissed. That will no longer be the case if Mr. Nelson does not agree to that today.
Okay. I trust.
Diversion, we have till the close of business because it's the order that I submit.
Got it. But I'll say the same words. Come on up, Mr. Nelson, so you're not in the distance there. So, you have an absolute right to go to trial. I'm not trying to talk you out of it. I just need to make sure you have heard and have processed what Ms. Willingham said. The state made this offer of pretrial diversion, which had some conditions. I'm not sure what they are, but they were shared with you. And Ms. Wood has explained to me that you have politely said, no, thanks. I'm not interested in doing diversion. Is that a fair statement?
Yes.
Okay. The state is leaving open the option of diversion through close of business today, which we'll call 5 o'clock, should you have a change of heart. If you don't, then they are withdrawing that option, meaning if you wake up tomorrow or on Monday when we bring in a jury and we start to pick a jury and you nudge Ms. Wood like, hey, you know what? I thought about it. That diversion thing would be nice. That offer is no longer there. You don't get to resurrect it because you've had a change of heart. It is an option for you until, I'll call it 5 o'clock today. And Ms. Wood would just need to email Ms. Willingham saying, hey, Mr. Nelson changed his mind. But after 5 o'clock today, I don't know what the state will do, but you cannot compel them to give you that offer again. Do you understand?
Yes.
Good. I thought you did. I just want to make sure. I want to hear it from you so there aren't surprises on Monday. Given that, this case will go on the short list of cases for trial Monday, which will mean you need to be back here Monday morning for jury selection. Ms. Wood will keep you posted on all that, it's the logistics, et cetera. But we need to get that degree of closure because the state has work to do as well. If they're going to get ready for trial, they need to prep their witnesses. And that's why Ms. Willingham is doing the reasonable thing, which is, hey, here's this offer, but I have to close that door today because I need to know that I then am getting ready and it won't be Friday afternoon. I get this phone call saying, yeah, we'll do that diversion thing. Okay. Any questions about any of that?
Can I take a second to ask one question?
You can ask your lawyer a question. We understand each other?
Yes.
Excellent. Stay in touch with Ms. Wood. I'll be keeping her posted and I may see you on Monday.
All right, thank you.
All right, appreciate your time. Well, hold on, before you go, Ms. Willingham, anything else from the state?
Nothing from the state.
Okay, and you don't have a conflict next week? Okay. Got it. Let me provide a couple you have more up. You finish your updates, then my turn.
Miss Charles, Miss Laura Charles, she's position 20 judge.
Yes.
I reached out to Miss Williams. I think she had to go to a different courtroom, but this wasn't going to resolve today anyways.
Okay, so it stays on the ready when reached list.
Yes.
Okay, are you Miss Charles?
Yes.
Great, okay. So very similar to what you heard me just say to Mr. Nelson, other than I'm not saying anything, I don't know what the offer was, so Ms. Wood will be telling you about that, or whether the state's keeping the offer open. You will be on this list of cases that are potentially trials on Monday, and Ms. Wood will let you know, yep, you need to be here Monday, or it's not going to be reached. That doesn't mean the case goes away. It means it goes to the next trial calendar. Okay? Thanks. All right. Ms. Jones, Mr. Wooten, Mr. Campbell sent an email about 10 minutes ago saying he's en route from Cobb County. So he exists and he's heading this way. My guess is we won't get to this till after lunch because we'll take care of people who are here now before we do go to lunch, but we will be able to have a conversation with counsel present about what's next with Ms. Jones, and he and Ms. Jones can together process the new offer from the state. Okay? So if you guys want to be at ease, just assume we won't tackle Ms. Jones's situation until after lunch. Thank you. Ms. Tembeka, we took a plea with Ms. Chambers. So I got to hear the facts again. She's agreed to testify truthfully if Mr. Thomas goes forward. I know you are still waiting on a police report or a collection of reports. So 2 questions for you. One, do you need more time to speak with Mr. Thomas today about a non-trial resolution, or that's not where we are at this point?
Judge, yes, I did ask, for an opportunity to speak for them again. I also, asked if you could hold or have our conversation about the Jackson Dental until after I speak with Ms. Smith. I'm very optimistic, Judge, that a conversation, could result in something that we need to
Great.
have.
I will stay out of the way, and when Ms. Smith has that window, which she's about to have in a moment, because we're going to take a quick break, you guys can talk. I think those were my updates that I've received. Mr. King, I know you're ready to go.
Judge, I just wanted to get an understanding. Do you remember we went through the whole, colloquy?
I remember Mr. Moses.
You remember it?
Yeah.
Do we have to go through it again, or is it just a quick, he accepts it, accepts the plea? I was just wondering.
That's a good question. If it is, I think I came down at 18 months.
Correct.
Yeah, I don't.
He wants me to ask for you to, move a little bit, but.
You can ask.
We're ready to move.
Okay. But we would just really get back to that nub of sentencing, because Ms. Rivers took it down. And so the takedown exists, and we would rely on that as the record of the plea colloquy, which was extensive. And then we would just talk about sentencing. I'm good with that, as long as you are. The only logistical hiccup, it's not impossible to overcome, is that today we're benefiting from the good services of Ms. Allen. And I'll just make clear when we go on the record in Mr. Moses's case that this is an addendum in terms of transcript to the record that was made on the day the plea was rejected.
Yes, sir.
Okay, good.
Whenever the court's ready.
We'll do it after the break so that you're done before the lunch break.
Thank you so much.
All right. Ms. Wood, any other announcements from your roster?
I have 2, please. Can we go whenever we're ready for those?
Okay. Anyone who is on bond?
Yes.
Who would that be?
Robin Johnson.
All right.
Who's position 9.
Yep. Okay. Ms. Rios, do you have any bond pleas ready to go?
I have one who's in custody.
All right. And we will do that. I think then, so you're going to talk with Ms. Smith. So why don't we take a break, and when we come back, we'll do the Moses sentencing and then the Johnson plea, and then we'll see what time it is. Maybe then we break for lunch, and then we'll come back and take care of remaining business. Okay? Thanks. You guys can come back to chambers.
So that's all I have. But yes, I saw the Smith's slide. Are you withdrawing any of that for the? Okay.
He's
Yes, Oscar. Yes. Yeah. No,
I'm sorry. Wait, I'm sorry, not Renell.
Okay.
What, and I missed what your announcement was on him, and he's still a non-negotiated, correct?
Yes, and that's why I was like, I wanted to just ASAP.
And so I will tell you, I don't know if he still stands where he did when I was living. Because at least that was one of the conversations, but then the conversation said something. Could you not?
No, I don't.
No, that's not doing it.
Yeah, no, I don't.
Yeah, but I mean, if that's not his answer, I'm just gonna ask. That was the last question, and that was the last thing I heard, so then I'm gonna stick with my ask, because what I have a feeling is his original answer. Okay.
I will add the addition to your piece.
I know. I know. It's an old case too. That's why I'm like.
I like your girls.
Thank you.
Like, is this, he's. Well, you know, what I gather that over phone. Okay. I'll be very interested to see, because like it's gonna be a lot of. Investigating. Yes. Yes. What is that? Criminal damage second. Oh, there's a battery on it, but yes. Yes.
Y'all really gonna try this again?
Oh, I've offered the version. I'm not dismissing. I literally offered the version. Absolutely. No, right. We started out.
Can you like community service?
I asked, it's part of the version.
Oh, it's Oh,
No, I was, that's why I said.
That's what I was asking for. Oh,
It's
okay.
literally the version.
Okay, well, guess you didn't do it.
No, the officers arrived, and they saw, so. Why did your guy think you were?
Oh, do you have the, there's an active warrant, you said? Yeah. Do you know what it's for? Barner? What's the charge? Barner. I think it's this case. Oh.
Oh, man. We think of it.
Well,
really, you ain't said no about before.
I forgot. I forgot to read the fact that we just had. But so as soon as he comes out, because her mom's here, as soon as he comes out, I'm gonna ask him. Her mom's here and her daughter, her sister. Mom and sister. What do you modify? Just the time served, because she was supposed to do a program, but they couldn't, they went. Why did they not take her to the program? Why did they not take Miss Ford to the program? I thought she was a walker.
She's got some medical issues. She told me when I did her interview that she got something going on with her larynx, something in her throat that she got to have surgery on. And so the program denied her. And it's like, you know, you need to get something that requires surgery. We can't. That's a 12-hour pay grade. So.
Okay.
Well, I think myself, because I came in and he was like, what do you have? And I was like, oh, one plea. And then he was like, oh, we'll do it right after her plea. And then I never felt, I was like, oh, I was expecting that I was gonna stay here all day. And he didn't say, he probably thought about it.
Oh my God, that's what he
If he
did.
didn't say it to me in the face, I was like, oh, I called out your mistake. You planned on keeping me out of the house. I was like, you said nothing. I just said, okay. Every time when I'm like, oh yeah, we're gonna shoot day. Look. Me and my husband had dinner plans tonight. He was like, is this gonna be one of the all day things? I'm just like, it's a trial calendar, but I mean, technically it shouldn't.
It shouldn't.
But every time we say that,
We ended up bidding until like 4:30.
I literally this. I feel my way
Because his original off day was tomorrow, and he switched it to just
And everybody
like the
went
first one, and he had to work. So he took off the day.
Because technically that only
Now, literally the only day that I told him I never had to go. I was like, just put it out. I said, but that might still be all day. And he was like, huh? And I was like, listen, you know, and I know that may be like all day.
One of the ones that I didn't even take anything. I keep talking about it.
Wait, what's that?
You're still on
And I haven't even done anything.
somebody that's up there.
That's career. That wasn't me.
Whoever it was, it changed the attorney that passed it.
They had Rios, yeah, that I can stand. I was like, yeah, no. That's crazy.
Oh, guys, yeah, we can still be heard.
Oh, but on the Zoom.
Yeah, they can
Not
still.
on you.
Oh.
Just on the Zoom? Yeah.
That's what, yeah, cause no, it still says live. It still says live, we're still live.
Your last week. Like, they people are so much. I want to sound.
Yeah, this is her intent.
Earlier, I guess I don't.
You get it back here from.
Oh, we got this. What?
Switch it over there. Oh, yeah, no, that wasn't what we're speaking about. See, I'm about to put some on.
Yeah, it's kind of, because I look good at guys.
Yeah, I had you and Lacey and
I started over on my one day was there.
So, it's actually not good to necessarily go on the diet and instead try to do a lifestyle change. No, we can actually, no. Well, first, technically, but no, the reason I say that is because when you come off the diet, whatever you deprive your body of,
You're gonna crave.
and then your body attacks it when you start back eating it.
Yeah.
So that's why they say you should not actually go on a diet. You should instead try to do a whole lifestyle change, because otherwise your body's gonna act in terms of like your eating. Like if you instead just go on a diet and say you eliminate carbs, but then when you start back eating carbs, those carbs hit you double time. So
Double time, so does your weight.
But that's what I mean when double time. It makes you gain quicker. So because it messes up your metabolism. So that's why they say it's better to make small changes over time as it is to instead of just one. I'm with you though, that it's actually not easy to do, but that's what they say.
No,
You ain't trying to lose no weight, are you?
I'm always trying to lose weight, actually.
It's not acceptable.
Because I just want to point out that she really didn't have room to look at me and say something about me, but I was just gonna let that ride. When I said it, she was like, "Oh, you're not talking," and I looked at her like,
So wait a minute. So you looking at her like, oh, hey, you lose some weight? You looking at her like, is that
She actually said that, like, it's good, just like, don't have to.
No.
Ouch.
So you ain't gotta worry about it then. That's what she said. You ain't gotta worry about it.
She might be in the back. Let me check. They're in the back talking. Yeah, Ms. Rebecca and Ms. Smith are talking, trying to resolve that case.
Oh, neither one of you guys were baked.
No.
What's your name? Thanks.
I'm doing fine. The address at Dockwood Apartments.
Oh.
Yeah.
He just said the name.
That's all you do now.
That's all I do.
Must be nice.
I'm leaving to go to Detroit. And then as soon as I get back, I'm going to Barbados. And then I'm going back to Europe. And then I'm going to Vegas. I like traveling, but it's too much. I'm blaming my wife.
Yeah, I always think, it don't sound like it's too much, but you're just going here and here and here and here. That's good.
Oh, I love it. I didn't grow up like this. My wife, like I'm married to her and I'm happy. But at the same time, like, this is not what I'm used to. All of this activity. You know what I'm saying? I'm not used to it. It is. How you been doing? You all right?
Yeah, I'm as well as I can be. Expected going to see family.
So that means you're not gonna be doing anything. Right? I mean, and the family division, the staff is there to deal with all this stuff. You come just picking your feet.
Somebody else.
Yeah, go be picking your feet.
Well, like, one of them was like, okay, and then like now he's like giving me pushback. Like, it's a step by shot. Like, if you're aiming for one, you should have got like a million. Like,
Yeah.
so
So we'll see you later.
Have you ever been on family?
He was like, so you go to the law library and the judge can deviate,
I'm not gonna lie.
but he's not going to. Like, that's the deal. Like, you
I
have a
know.
bunch of
Yeah.
multiple shop applications that you
When I say that,
the past, like, 10
y'all in
years.
the week, y'all
Like,
back.
and then down to Newport, he's out on bonds about.
Yeah, I get you a second. I get you a second.
Anyways.
I would.
Let's try this.
Y'all are better than me out here.
Right,
Yeah.
I mean.
The back and forth, family law stuff? No.
So you wouldn't, that's not your area of interest.
No, I used to do it. And it was the worst of the worst. I would deal with a criminal. Then a family. Plaintiff, I mean, assistant or respondent, every single day. Every single day. That's how hard it is. It's hard, man.
I know, right? I'm actually.
And the thing is, the judge on a criminal calendar, what, 20 cases, 30 cases? Wow, and on the family calendar?
I wasn't expecting.
Wow, two or three. Too much drama.
Me too.
You have already reached your limit of drama in your mind. Unless you can reach the point where you just don't care. I care. I care about my client, and he cares. But the problem is is that he really actually came up with his own. And I don't have to agree with you, but process. He gonna make
I've been following the people coming to the US. Yes, so it's. Right. I don't think that's like. That's so much.
Oh, yeah, she's not.
Yeah, I got it. I think it's not like green something.
Don't look over here, I can't go. That's art, that's art candy. No, that's clear. No. Because I can't do that. So that's what's. We don't get a candy. Everybody's like, it's the 30. Oh, whatever, it's the day of 30. It's the day of the 4th. Yes, it's the 30. Oh, wait, that's the day of the.
Yes, the 30th.
Then I need to reschedule my dinner.
That's
What's the
right.
30th? Yeah, no, I'm gonna just.
Oh,
lunch. Cause it's also my birthday. Okay, I'm on. Thank you so much. 30. Here?
Yes.
No, I'm not doing that yet because we're not supposed to go in this.
We've been dodging the bullet. Every time it comes up.
No, listen, y'all fuss at me when I don't have please.
Are you- do you have
fuss
to
at me when I do? No, we're not. No, we're not.
The Mara will
It's
do.
not that bad.
Mara, you have to be here.
She only has one.
Yes.
Yes. Yes, I'm personally.
Oh, but then people are coming like.
Oh, well, look at you. Did you work this? So go shut the doors down.
But that's why I said if you just. It's not. I changed my mind.
Hey, what y'all doing?
Yeah, but you're not. Yes, but we're different. You're getting.
Oh.
Yeah,
You get extra day.
Miss Simpson,
Come back.
they took all your candy out the bowl.
I've been here, and that's what people like. I knew it wasn't sure. Yes.
She's here. Okay, great.
Ready when you are.
All right, if Mr. King is around, we could do,
Other.
Yes, sir.
you ready?
I'm ready.
Sure.
You guys interns?
They are.
I figured that. Y'all look great. Awesome, awesome. You got any other intern positions I might be able to apply for, Judge?
So, I was supposed to have two, but a colleague is scarce right now, so I'm fostering a couple others.
Okay, so you don't have any more room?
No, the inn is very full.
Understood. You know, my travel schedule is probably, you probably write me a bad review.
I know. It's like, where is this guy? He's never around.
I've always called. Yeah.
All right, Deputy Gordon, when you're ready, we're ready for Mr. Moses. Received a motion to recuse ultimately me, but my staff attorney, because she went to the same law school as it's a pro se plaintiff fighting a pending foreclosure. It's a doomed fight. The law firm that represents the lender, the lawyers from that law firm went to the same law school. And so she said that it's a loyalty club.
Yeah.
Mr. Moses.
Yes, sir.
Good to see you.
Good afternoon.
Still morning. We got 8 minutes.
Okay.
So we're going to get on the record in your case, Mr. Moses. Ms. Allen, this is I don't know what calendars you got sent. It's a plea calendar for today as well. But more importantly, it's case 25 SC 004-517. State versus Willie Moses. Mr. Moses is here in court with his lawyer, Mr. King. Ms. Smith is here for the state, and today's proceedings are a follow-on to a plea conversation that we had a while ago, during which Mr. Moses tendered a guilty plea, a conditional one, because he had his final plea rights then. He pled guilty, he understood his rights, he waived those rights, and that was all taken down. So we've got a thorough record of that. This would have been back on the 28th? Is that when we did this? I don't think there was a separate hearing. That was the trial calendar. Did we do it the day of the trial calendar? Seeing if there were any, that was the last court date.
June 16th, 2026 for a plea.
That's today.
Today, this is.
Oh, yes.
Yeah. I almost fell for that as well.
May 28th.
Yeah, so we were together on the 28th.
Yes, sir.
And on that day, Mr. Moses accepted responsibility for what these charges are. I accepted his guilty plea. He ultimately did not accept the sentence that I imposed. And at that time, he had the right to say no, thank you, if the sentence I imposed was more severe than what his lawyer, Mr. King, advocated for. And I said, got it. That's your call. Since that time, Mr. Moses, I am told, has had a change of heart. I'm going to start again with Ms. Smith to have you state the state's recommendation. I'm assuming it's not different from what it was last time, but let's get all those things out in front of everyone so we've got all our necessary talking points. Then I'll hear from Mr. King. It may be that I've changed my mind, but that would be peculiar, and we'll see where we go. So, Ms. Smith, what is the state's recommendation in Mr. Moses's case?
Yes, Judge, the recommendation in this case is 10 years to serve 2 with the balance probated. The state also asked for the special conditions of probation to be for the defendant to complete an anti-theft course, to have no contact with the victim, and to pay a $500 fine.
This was the stolen Macan, it's some Porsche SUV.
Yes.
Got it. Right, okay. So no contact with the victim, and what was the last?
A $500 fine.
Okay, got it. All right. Anything else from the state?
No, Judge.
I believe in making your recommendation when we were last together, you also were willing to withdraw the recidivist notice.
That is correct. Yes.
Okay, so this is a non-recidivist sentence that we're handing down, that we're working through, which means most importantly for you, Mr. Moses, is that it's a parolable sentence. Whatever sentence you get, you will be parole eligible. Mr. King.
Thank you, Your Honor. We stated before, we understand what the court's ruling was. We understand and respect you guys' positions, but we want to just reiterate that this is a theft by receiving case, and my client hasn't in the past done any significant incarceration time. And at this point, he's been in consistent incarceration since July 4th of 2025. So where we are now is that he is about to have been completed with a year. And we're just asking for that year to be the year that he has to do on this case. Now, understanding, and in all candor to the court, he had a probation. And Judge Ingram, she revoked that probation on August 25th of 2025 for a year, and didn't give him credit for any time that he served prior to that. So he has to stay in jail until August 25th of 2026, unless oftentimes we don't know what the Board of Pardon and Parole are going to do.
Right.
But when it comes to the sentence, that's what his sentence is. So we appreciate everybody's consideration, but what we're still asking is that the court give him a year. And that is, he did a couple of days when he first got arrested on this case in 2024. And then when he got arrested on the probation matter that was a basis of this arrest. He has been in incarceration since July 4th of 2025. So we would just ask the court to give him as much credit as the court can give, but we're asking for 1 year based on this. He's taking responsibility. I told him I was gonna, reiterate this to the court, but he also understands that what the court has already said. And if you don't have a change of heart, he's here to take responsibility and move forward.
Understood.
Thank you, Judge.
You bet. I appreciate your time on this. Mr. Moses, anything you want to add in addition to what Mr. King said, or you echo his sentiments?
I do.
Okay, understood. Well, I appreciate the perspective of both sides. I did back on May 28th, and for reasons I expressed then, which include the background you bring to this situation. This is not your first rodeo. You've been mixed up with this kind of stuff, whether it's a stolen car or not your ID, someone else's ID. Because I should add, I'm remembering now, it wasn't just that you were driving a car that didn't belong to you, but you had, I think it was a New York ID with your picture on it, but not your name. And it's just sort of a history of you being a little too slick. And it's catching up with you, and it's time for it to stop. Live a different life for your remaining years, and you've got plenty of them left. They will be more complicated, though, if you keep getting mixed up with hustles like these, because judges and prosecutors, not that they are in a league together, but I think both those groups are going to be less and less patient with you getting involved with something like this, and less interested in hearing the latest version of, well, it was a misunderstanding. I'm not sure why I have 4 IDs with different names on them, but my face, or I was just borrowing this car from this person I can't identify. If you were 19 years old, maybe a couple times that would work, but you're the dean of things now, and need to be leading by example. So, Mr. Moses, I am, what is the range for count 2? Is that 1 to 3? I just don't want to impose a illegal sentence for.
Your Honor, we don't object to the theft course. We would just ask to waive the fine under the circumstances, Judge.
That's what
1 to 3? Okay. All right. Mr. Moses, on count 1, I am sentencing you to 7 years to serve 18 months or 1.5 years with a balance on probation. Count 2 is 3 years to serve 18 months or 1.5 years. Those will run concurrently with each other. You will get credit, whether I say so or not, but I am saying so it's doubly clear. You're statutorily entitled to credit from that July arrest date of last year, plus another, well, that's that.
I believe who's October? Is it October date?
You do. You have 4 days in October, but every day counts. And so you will get 4 days from October 24, and then many days from July of last year through now. Those will all be credited to the 18 months that you need to serve. And again, pardons and paroles may say that's not what you need to serve. It's something less. They can't make it more, but they can certainly make it less. When you are released, you will need to take the anti-theft course and have no contact with the owner of the vehicle. And in lieu of a fine, I am going to have it be 80 hours of community service that you need to complete during the first 8 months of your probation. That'll be it. I hope you are ready to head in a different direction, but you're your own boss, Mr. Moses. You've been a free agent for a while. There was a DeKalb case. Is that still open? And is that his next destination? Because I know before you got involved, Mr. King, there was some argument that these charges actually have already been dealt with because they're not, they haven't been. It's a different case.
I represented him in DeKalb on a felony charge that we closed that out.
Okay, that's resolved.
So my understanding is he has a couple of misdemeanors in different places, but no felonies, and I worked that out.
Okay, and I'm asking.
On the same page.
Good. And I'm asking only because I want Mr. Moses to know what his next destination is. If he has holds from other jurisdictions, that's where you'd go next, not to the Department of Corrections. And it may be that just working those out takes enough time that when they add it all up, they say, don't even come here. We're just going to parole you
We
out.
would expect that he goes back to the Department of Correction, and then if I'm unable to release his hold in Coweta based on a bench warrant, which it should be released because he was in prison
Sure.
at the time, then he's going to be on the street, and we still got to just work on his situations.
With Coweta.
Yes, sir.
Okay. Sounds good. That'll be Mr. King project. Ms. Smith, anything else? Mr. King?
No, Judge.
All right. Thank you.
Thank you, Your Honor. May I be excused, Your Honor?
Yes, sir.
Very nice to see you.
Same. Ms. Johnson? Ms. Johnson, you want to come on up, please? So, Mr. Wooten, you're sticking around to engage with, or is Ms. Campbell, he's here? Excellent. Well, we'll talk after we take Ms. Johnson's plea. All right, Ms. Allen, you ready? Great. This is position 9 on our trial calendar. State versus Robin Johnson, 26 SC 000-084. Ms. Johnson is here with her lawyer, Ms. Wood, and we have Ms. Smith again for the state. And Ms. Johnson, Ms. Wood tells me you're ready to enter a plea. Is that correct?
Yes.
Okay. Ms. Smith will put you under oath, ask you the standard questions. Please answer carefully and let me know if at any point you've got questions or you need to speak privately with your lawyer. Will you do that?
Yes.
Okay. Ms. Smith?
Ms. Johnson, raise your right hand.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Robin Johnson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
20, 9th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Ms. Johnson, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you also understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote,
Yes.
the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Ms. Wood, is Ms. Johnson asking to be sentenced as a first offender?
No.
Okay. Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove that you're guilty beyond a reasonable doubt, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Ms. Johnson, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment 26 SC 000084, how do you plead to count 1, aggravated assault, and count 2, possession of a firearm during the commission of a felony?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Ms. Johnson. Your Honor, if this case were to proceed to trial, the facts would show that on June 5th, 2025, officers of the South Fulton Police Department responded to the incident location of 4375 Cascade Road, Southwest Atlanta, Georgia, also Fulton County. And that location is an apartment complex named Parks at Utah Creek Apartments. When the officers got there, they responded to a shooting call. When the officers got there, they saw 3 people standing at a bus stop across the apartment complex, which one of those people was Robin Johnson, and the other 2 was Takira Griffin and Dakira Stewart. When the officers got on the scene, they approached that bus stop, and when they got to the bus stop, someone ran up to the officers and said, "That's the one who shot my nephew." So the officers began to investigate, and after the investigation, they found out that Ms. Johnson went to the apartment complex and engaged in a physical altercation with 3 people of the Joneses family. And the Jones is the victim in this case, but the little boy's family. She got into a fight with one of his aunties. While fighting, the other sister, the other Joneses sister, stepped in to pepper spray Miss Johnson. Once she was pepper sprayed, she asked one of the people who was standing at the bus stop with her to hand her the red purse that she had. Inside of the red purse was a firearm. Miss Johnson got that bag from her friend and took out the firearm, aimed it at the breezeway that people had ran to once they saw that she had a gun. She shot once in the air and then toward the breezeway that the Joneses family and other people in the neighborhood who was outside watching the fight had ran to. She shot one time. It went past one of the people she was fighting, and and a little boy named Chance Jones was shot instead. He was shot in his right leg, in the thigh. He was rushed to EMS. He is doing fine now, but he hasn't sustained any, like he can still walk and things like that. So it's not any permanent damage. So after that shooting happened, Miss Johnson, along with the two people who were with her, those people I named earlier, Miss Griffin and Miss Stewart, they ran to the bus stop across the street to potentially try to get away. But simultaneously, South Fulton pulled up, and the aunts of Chance Jones was able to identify Miss Johnson as the one who shot her nephew. Miss Johnson was taken down to the South Fulton precinct, where she confessed that she did have the weapon. She took it out of her purse, and she knew that Mr. Jones had been shot. At that time, she was arrested for the charges we have in front of us. I did get a chance to speak with Jemiah Jones, who is the mother of Chance Jones. She said at the time he was, believe he was 7 years old. She said that since the shooting happened, it's taken a toll on their family. Her child was shot. She said now the biggest thing about him is he's angry a lot. He gets into a lot of fights at school, and she believes that that is a result of him being shot, having to go to the hospital, and just having to deal with the pain and memories of that day. I also had a chance to speak with the two aunts that was engaged in that physical altercation with Miss Johnson, and they kind of reiterated what the police incident report said as far as what happened, but as far as how their family is moving along now, it's kind of that same sentiment of having to still live in that apartment complex and dealing with what happened and remembering what happened to their nephew, because they were all there at the same time. I spoke with Miss Jones today, Jemiah Jones, who is the mother of Chance Jones, and she told me that she is dealing with a family emergency. I believe she wanted to make a statement today, but she's not on the Zoom. She did tell me that her mom was on the Zoom, who is Chance Jones's grandmother. I'm not sure she wants to speak, but if she would like to speak, I would ask for her to make a statement if she would like. But as far as the facts and circumstances of the case, that is what the state has regarding the factual basis. Regarding the recommendation in this case, the state is asking for the defendant to be sentenced to 10 years to serve 5 with the balance probated. Regarding the special conditions of probation, the state is asking for the defendant to have no contact at all with the victims or with the victim's immediate family. So those aunts she got into a fight with. We're also asking for the defendant to stay away from the incident location. We're asking for the defendant to also forfeit the firearm. When the officers went to the bus stop, they found the gun laying next to the bushes that was next to that bus stop that was used in the shooting. So we're asking for that firearm to be forfeited, and also for the defendant to complete an anger management course. And that is all from the state.
So 10 serve 5, balance probated, plus all the conditions you mentioned.
That is correct.
Okay. And you mentioned that Ms. Johnson confessed to the police, but what you described was she confessed to having the gun, and she understood that the little boy was shot, but that leaves this middle ground of, and I'm the one who pulled the trigger that fired the bullet that hit him. She confessed to firing the gun.
Correct.
Okay, so she said, look, I did this thing after I was pepper sprayed. I didn't, sort of like Mr. Bates' situation, I didn't mean to shoot this kid.
Yes.
I was shooting in the direction of these people who had pepper sprayed me.
Correct.
Okay. Did she explain in her statement to the police why she went to parks at Utah Creek to begin with?
No, but when I spoke with the aunts who got into a fight with her, they said that Miss Johnson came to the apartment complex basically looking for them because the aunts had previously got into a verbal altercation with someone named Chucky in the apartment complex. And it's my understanding that Chucky and Miss Johnson may have had some type of relations or may have been friends. I heard they met at the pool some days before. So she was looking for them on behalf of Chucky because they had previously disrespected him or got into a verbal altercation.
Okay, thank you.
And I'm not sure if the grandmother would.
I'm going to check there because there are a couple things that say Jones. Is there anyone on the Zoom call here for Chance Jones who wants to be heard?
Yes, I'm here.
Okay, I'm gonna, if you could turn your camera on, please. Excellent. Well, it was, there we go. All right. If you could tell me, please, who you are and how you are connected to Chance Jones, I would like to hear your thoughts.
I'm Melissa Jones. I'm his grandmother.
All right. I hope the family's okay. Ms. Smith said that Chance's mom was dealing with a family emergency, so I hope everyone's all right today.
Yes.
Okay. What did you want to share with me about this situation from, so now we're about a little past the 1 year anniversary.
I'm just glad it's over. I forgave her for everything, so I'm just glad it's over.
Okay, well, I appreciate you being forgiving. It doesn't sound like Ms. Johnson was trying to hurt your grandson, but when you shoot a gun towards people, you run the risk of something real bad happening, and that's exactly what happened. Fortunately, it sounds like young Chance is okay, that he can run around with his friends. It sounds like there may be some anger issues, but otherwise, is he doing okay?
Yes.
Good. Okay. Do you have any thoughts or recommendations as to how I ought to handle the case?
No,
Okay.
I don't.
Anything else you want to share?
No, that's it.
Okay. Well, thank you, Ms. Jones, for being here, and let your daughter and your grandson know that we're working through this today. Okay.
Okay, thank you.
You bet. Ms. Harvey, any criminal history information on Ms. Johnson?
Yes, Your Honor. 5 cycles. Does not appear to have any felony convictions. The last arrest was June 5th, 2024 out of Muskogee County for battery. There was no disposition listed in this case. There's also a separate arrest from June 5th, 2024 out of Columbus for burglary in the first degree and criminal damage to property in the second degree. No disposition was listed for this case. There's a arrest from November 8th, 2023 out of Columbus, Georgia for hijacking a motor vehicle in the first degree, also with no disposition listed, and nothing further, Your Honor.
Thank you so much. Ms. Wood,
One moment, Judge. Do you have a question? Okay, we'll talk about that later. Yes, Your Honor. So one of the reasons this case made it this far and we didn't resolve it at final plea is because Ms. Johnson was working on gathering bystander video for me. She did get that to me. I got it to Ms. Smith. And it basically showed us that what the police report says, there was a big brawl outside of the apartment complex that day. It was never her intention for this young child to get injured, but of course that is the problem with senseless gun violence. And we are just fortunate and grateful that it wasn't much worse.
right.
So she's here accepting responsibility, Judge. She's 20 years old. She's from Atlanta. As you heard, she has a 9th grade education. One of the things I would be asking for to be included as a special condition would be for her to get a GED and then also participate in some sort of job corps training, or I'm not sure how probation can work that. She was previously working at Taco Bell and Burger King. However, she's been having issues with the ankle monitor that is still on, keeping her from finding better employment, Judge. We have no issue with stay away and anger management course, and then the no firearms provision. Our request is, so she served 209 days on this case.
Right.
So for count 1, I'm asking for 5 years probation to serve 209 days. Count 2, 5 years probation to run consecutive to count 1. We don't have any objections to weekends in jail, although I understand that since she's currently unemployed, it might make more sense to change that up, Judge, if you understand.
I do.
My direction. And that is our request of the court right now.
Okay. Ms. Johnson, I would like to hear from you if there's anything you want to add, but I have a few questions first. And then if there are things you want to say, I'll certainly hear from you. Tell me what your connection is to Columbus, Georgia. You seem to have some business down there.
Well, I'm originally from Columbus, Georgia, but I came to Atlanta when I was 14. I ended up getting kicked out of my mom and my dad's house. I went back to Columbus because I had it was a case in Clayton County, but it's not anymore. So I was 17 at the time, so I went back home to my parents' house. So basically that's.
The home is Columbus.
Yes,
Are your parents
basically.
still there?
Yes.
Okay, so that's your connection to Columbus that's where you grew up. You still have family there.
Yes.
When this case is behind you, meaning you're just dealing with probation, do you intend to live up here in the Atlanta area or are you going back to Columbus?
Well, I intend to live here, but I still have a case open in Columbus that still needs to be taken care of.
Okay, which one is that? I heard about a burglary, I heard about a carjacking.
See, all of those are, I got arrested November 8th, 2024 for the hijacking charge. And they had pinned burglary and the other charge on me while I was incarcerated.
Okay.
So all of that is really.
It's all tied together.
Yes.
And that has not been resolved.
No.
Okay. Do you know if you've been indicted down there or are they just charges?
That's just charges. I haven't been indicted yet.
Okay. All right. Do they have a good address for you though? If there is an indictment, would they know how to send you something in the mail so there's not a bench warrant?
Yes.
Okay. You have a lawyer helping you down there?
I have a public defender down there.
That's a lawyer. Good. All right. That's just going to make it more likely that that lawyer learns if there is an indictment, so that lawyer then can reach out to you and you don't miss a court date. Tell me what was going on with Chucky and you and Chance Jones' aunties. But about a year ago, last year, this time.
Well, Chucky was my boyfriend.
You say was, he not your boyfriend anymore?
No.
What happened?
I don't communicate with him.
Okay. But at the time, he was your special someone.
Yes, at the time he was. He stayed in those apartments with his mom.
Yeah.
And I went there to see him, spend time with him. And an altercation happened where those females had came up to him and I got into it with one of them and two other females they jumped me and then they had maced me.
Okay, that's the pepper spray we heard about.
Yes.
And so this is all the same situation. That's when you went back and got your gun and shot in that direction.
Yes.
So you weren't there avenging something that happened to Chucky. It was all sort of at once. You were with Chucky, people had words, you got jumped, you got maced, and then you escalated things.
Yes.
Okay. Why did you have a gun?
It wasn't mine. That wasn't my purse.
Oh, you knew someone who had one? Like, hey, give me that piece, or?
One of the girls who I was with had it.
Okay. And did you know that she had it, or she said, hey, you should shoot these people?
I didn't know she had it when we on the way there. I didn't know she had it, but I learned that she had it while we was out there and while I was spending time with my boyfriend. That's when I learned that she had it.
Got it. And with that information, you went to her to say, give me that gun.
Yes.
Words to that effect. Okay. All right. Anything you want to add?
No.
Okay. So Ms. Johnson, I'm going to sentence you to a little more time in custody. I'd like you and Ms. Wood to talk about whether you can go into custody today or if you want to have a turn-in date. So you guys should talk about that. But let me tell you the whole sentence and then you can talk about it some more. I have a couple more questions for you. So you're not working right now. The ankle monitor makes it kind of hard to work.
Yes.
I don't think I missed this. Did anyone talk about, do you have kids?
I don't have any kids.
You don't have kids. All right. So you've got family, mostly down in Columbus, but right now no job and no kids.
No.
Okay. You're only 20. It's okay. Plenty of time for both kids and more jobs. But gosh, it's awfully young to have gotten mixed up in something like this. Ms. Johnson, I find there's a factual basis for your plea. It was a traumatic and dramatic time, but the last thing that needed to happen is a gun coming out. It sounds like you were actually able to get away from these young ladies who had maced you, and you could have just left, but you didn't, and made it a whole lot scarier for everyone, in particular this young boy that you didn't even know. You may have known him, but that's not, I don't think you intended to shoot him, but you pulled the trigger. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. And knowing means you've understood the things we talked about. I think at one point you had a question for Ms. Wood, but she answered that. Do you feel like you understand where we are right now?
Yes.
Okay, and no one's forcing you to enter this plea?
No.
Okay. Ms. Wood, do you authorize someone in my office to sign the indictment on your behalf and your client's behalf?
Yes, sir.
Ms. Smith, can someone sign for you? All right. Ms. Johnson, I'm going to sentence you on count one, which is the aggravated assault, to 3 years to serve 1 year with a balance on probation. Count two has to run consecutive and has to be 5 years. I'll probate that. So it's a total sentence of 8 years to serve 1 year with the balance on probation. You'll get credit for the 7 months you've already served. So you are going back into custody. The most you'll be in custody would be an additional 5 months. That gets you to the full year that you're going to serve for firing a gun into a crowd and hitting a little boy in his leg. I don't think the state's recommendation is out of bounds. This was scary. It could have been so much worse. But right now, you don't have any convictions. You got some mess you got to deal with down in Muskogee, but you come into this young and not having been in a whole lot of trouble. And I'd like to get you moving in the right direction sooner rather than later. I think 5 years in custody might do more harm than teaching you not to do something like this again. But I may be wrong. But I left a lot of probation so that if you do mess up, we can just use that probation as prison time. So I'm hopeful that while you're on probation, things go smoothly. Just know that if they don't, I will remember what this case was about and that I sentenced you more leniently than what the state asked for. And I won't make that mistake again if you get into a situation like this. And by that, I don't mean you get into a fight. Someone may jump you. You need to not pull out a gun and shoot into a crowd. You need to walk away from that situation. Easier said than done, but that's what you're going to need to do in the future. And again, I'm just so grateful that Chance is walking and talking, because we would have been talking about something real different. If that had hit a femoral artery and he bleeds out, then we're talking about, is it life for Ms. Johnson or 30 years to serve? And we don't need to worry about you having kids, because that's not going to happen. Special conditions of probation. Number one, most important, is that you have no contact with the whole Jones group. It sounds like you know some of the aunties of Chance Jones, but you know who I'm talking about, that family. We met grandma. Mom couldn't join us, but no contact with Chance, anything like that. Do you still have people you know who live at parks at Utah Creek?
No.
Okay, because number two is you stay away from that apartment complex. What makes it easy is if the Joneses are still there, it's going to be easy to have no contact with them because you're not going there. But if they've moved, you don't reach out to them on social media saying, I had bad aim this time, I'll be better aim next time. Just nothing. You don't communicate with them. You'll forfeit the gun that was seized. I appreciate it may not have been your gun, but you can't seek to recover it. If the young lady who owns it wants to step forward, say, hey, I want my gun back, we'll work through that. But it's not for you to collect when you're done with your sentence. You need to get your GED. You're very well spoken for someone who stopped at 9th grade. I want you to get your GED. It'll help you with employment in the future and whatever else you hope to do. Now I need you and Ms. Wood to talk. I will let you know that I had a bad experience very recently when I said to someone, you can report in a little bit. And I don't want to put that on you because it wasn't your bad experience, but it had gone well until the last person I told you can come back in a little bit and report. Everyone else had shown up on time when they were supposed to. I'm going to give you that opportunity if you need it, but that's just a few days to get your affairs in order. It's not, hey, I'll be here in August. But you may want to say, look, let's just get these remaining months going. Talk with Ms. Wood. And then let me know what your preference is, okay?
Okay.
All right. You're welcome. While they are talking, we'll go off the record and turn, speaking of situations where someone didn't turn herself in. Ms. Jones, now that your lawyer is here, Mr. Campbell, Mr. Wooten let me know that there was a revised offer from the state. He didn't say it was better or worse, just revised. But Ms. Jones is in theory, there are two cases still standing. Ms. Brown's case isn't getting better for her. But we do need to figure out what we're doing with Ms. Jones's case.
Yes, Judge, and I did receive the offer on Friday. And after seeing the order for the co-defendant, light bulbs going off with Ms. Jones. I have some mitigation to provide to Mr. Woodland that hopefully will help her some. And she's working on getting those documents. We're going to go once we leave here today, and I'll provide those to Mr. Woodland as soon as I can.
Give me an example of something that your client has told you she hopes to get her hands on, to get to you, to get to Mr. Wooten. Bank records, okay. And Mr. Wooten, was bank records the kind of thing that Ms. Moorman got to you? And they don't need to be the same, but what I don't want to do is say, hey, we'll see everyone in a few weeks when whatever Mr. Campbell might get from Ms. Jones isn't going to be a needle mover for you.
So, yes, Judge, it was bank records from this morning, but that was a very different situation. Without going into all the facts of the case, Mr. Jones was never physically present, and we had an issue proving his knowledge and intent based on what was provided to us, and felt that we could not necessarily overcome potential reasonable doubt.
Okay.
That's not the same situation for Ms. Jones. She was physically present for some of the transactions based on the testimony of Kayla Brown that frankly made things worse for Ms. Jones, because I believe it implicated her even more and demonstrated more of her knowledge.
But knowledge and mere presence doesn't get you to being a party to the crime. I mean, I know you know that, but so maybe this is where the bank records help, or?
I don't know that it would move the needle for me. I'll also say to the court that the new recommendation is a probated first offender recommendation. So I don't know how the needle kind of is as far as it can go.
Got it. Given, I'm sorry to interrupt you, but given what you learned from Ms. Brown's sworn testimony, that links Ms. Jones to some of this situation, being physically present, aware of it, et cetera, and then what you heard from the victims, it's not a Mr. Jones situation, which is, we're just going to carve you out of this. That's what happened. But it is as low as it can go, first offender, probation. If you can demonstrate during the course of this sentence that this was not the normal operating situation for Ms. Jones, it's like it never happened. It's not on your record to begin with, and it's not on your record to end with.
That's right. I can say, of course, open to look at what they've got, open to continue the negotiations as it relates to some of the special conditions, restitution in particular. We
Sure.
had a conversation, but as far as the recommendation itself, I don't see it changing.
Okay.
Only thing I would add, though, Judge, is that now that Ms. Brown has entered a plea and has testified, and I believe that testimony helps our case, she's a witness now. And so.
Ms. Brown is a witness?
Yes, I would call her to the stand, absolutely. I think I have to, if we proceed to trial. So I mentioned that to say that, now I did learn that she is now out of the hospital as of this morning. I don't know where that leaves things as far as us getting a subpoena in her hand when there's an arrest warrant out there. So I don't know where we go. I think the first step has to be getting her into custody in that chain of events. So I'll just bring that up all to give the court some context as to where we are with our state's ability to proceed to trial. We intend to go to trial if we need to. It's just she's kind of a keystone witness that we need.
Got it. And when you're talking about trial, you would be ready to go on Monday?
There's a few weeks. So knowing that Ms. Brown was going to enter her plea, we kind of put our witnesses on hold. I think it's a trial that would take more than a week based on the number of witnesses.
Even if the trial is of Ms. Jones and not Ms. Brown?
Yes, I think because it's a RICO, we got to put the whole case.
Okay.
And provide the whole story.
I got the sense that the victims were pretty motivated to participate, so I don't know that you'd have trouble getting them here.
I can't say for sure just because we did not immediately have a discussion about everyone coming in for trial.
Sure. Okay. Well, let me throw one more fact in there as Mr. Campbell, you and Ms. Jones are thinking about what's the best way to move forward. I will have jurisdiction over this case through the last day of June. After that, it goes to a different judge who doesn't know anything about the case, is going to have a steep learning curve. And I'll let you talk with Mr. Wooten about whether that judge is generally a more sympathetic judge or less sympathetic judge. But it will be a whole new can of worms as to how everyone navigates it. So insofar as there's value to familiarity, then there's a time frame for things to happen. I am available any of the days between now and the end of June for a plea. So if we don't try it next Monday, and that seems like it would be a bit of a crunch to do that, then if it is resolvable, especially with the state's offer, the time to do that would be before the month ends. And that has nothing to do with the state. It's just dockets being handed off between judges. And that switch might not be advantageous, but you'll need to sort that out. So I think I understand where you all are. And I share that only because that would be, hey, don't just put those bank records in the mail, put them in FedEx 20-minute delivery kind of thing. Because I'll check in with the two of you after a bit. I don't mean today, but in a few days, maybe next week, saying, where are we? Is this something that can be resolved? It's just probably more efficient and smoother if there's a way to close everything out while it's still under my purview rather than my successor's purview. For what it's worth. Okay. Ms. Jones, do you have any questions about what we've been discussing? For me, obviously, Mr. Campbell is your go-to guy and can give you good advice, but do you have any procedural questions for me? Okay. Your daughter is home with you or home at her place? Okay. All right. If there is nothing else, then I need to see Mr. Wooten and Mr. Hansel, and then we can be done. You don't need to, it's not about your client, but we will check back in with you. And why don't we break for lunch? We will reconvene. We'll try to start as close to 1:30 as we can.
Before we do that, that's fine, but can we finish off Ms. Johnson before?
Yes, sorry, I forgot. We need to, yes, yes, of course. Are you guys able to hold on for 2 more minutes? Okay. Ms. Johnson, come back up, please. All right. Ms. Wood, did you have a chance to speak with Ms. Johnson about her preference of going into custody today versus really, really soon?
Yes.
And?
We spoke about it. She was requesting if she could turn herself in on one of these court dates that we have in the next couple of days.
Okay.
So she can get everything lined up.
So I'm good with, will you be here for the plea and arraignment calendar on Thursday? Yes. Okay. Does that work for you, Ms. Johnson, Thursday?
This Thursday.
This Thursday. When you said next couple days, I took that literally. Did you not mean literally?
We have a couple. So we have that one and then we have, I guess, Monday, whatever happens.
Yeah, I mean, it could also be Monday. Would you prefer this Thursday or next Monday?
Next Monday.
Next Monday.
Yes, I have to call my mom. No, my family is in Columbus. So
okay.
I have to get all that in order.
Okay. So here's how it's going to work. You need to be here next Monday, 9 a.m. like you were going to trial. You're not going to trial. Don't show up with lots of folks. Don't show up with lots of belongings. Whatever you're wearing, it should be the kind of thing that if you end up never seeing again, that's okay. I'm not saying you won't see it again, but it'll go on the property. And I don't know how likely it is that you get reunited with it. If you are not here by 9:30 on Monday, and Ms. Wood isn't here saying, no, look, she's coming. I got her right here. She's on the phone. I'm going to impose the sentence that the state asked for. So right now, it is the 1 year to serve followed by some probation. If you are a no-show on Monday, then I'll impose the 10 to serve 5. That's the value to you of being on time on Monday. And between now and then, not disappearing on us, okay? You got the ankle monitor, so disappearing will be complicated. Don't cut the ankle monitor off. Don't stop the charging of the ankle monitor, because I'll be reaching out to Second Chance saying, hey, over the next few days, let's keep a close eye on Ms. Johnson.
Okay.
Make good decisions between now and Monday, okay?
Okay.
Any questions about any of that?
No.
All right. You'll get reporting instructions about probation when you are released from custody. But if you're staying in Fulton, you'll be reporting in Fulton. If you're down in Muskogee, you'll be reporting down in Muskogee.
Okay.
All right. Anything else, Ms. Wood?
No, Judge, thank you.
Ms. Smith?
Nothing further, thank you.
All right. Appreciate it.
So just let me.
So for those of you in the gallery, we will get to all the other cases after lunch. We're going to break for lunch. We're going to try to start up about 1:30, maybe more like 1:35. I got to get everyone fed. But we'll pick up everything from there in whatever order you all arrange. Mr. Jones, I haven't seen yet, Attorney Jones, but he said he was going to be here hopefully by 12:30. He didn't quite make it, or he may be talking to his client now, but he did affirm that he would be here.
Thank you, Judge.
Okay, you're welcome.
Judge, can I let him know that you wouldn't be taking the bench back till sometime after 1?
Excellent. Good plan. Thank you. I will mute things here.
Amazing. God bless you, Amir.
Running out of steam.
I know.
How are you? Yeah, I'm happy to go to her channel.
He's here. So everyone is here. Excellent. Okay.
Oh, she's coming. She was the one who. No, I thought we hosted. I think it's also not here. But she.
All right. Welcome back, everyone. That kind of scared me. Thank you, Deputy Gordon. Well done. It is time to get back on board and figure out what we're doing next. Ms. Willingham, is your case ready for a plea?
Yes.
Before we do that, I see Mr. Jones. Appreciate you driving all over the state to be here. We got notice you'd be late. Your client was here on time. Ms. Williams has been here. So let's touch base about the Johnson case to see where we are and where we aren't. And then we'll take the pleas at Foster. Is that the right name?
Yes.
Then we'll take the Foster plea.
Thank you, Judge, and good afternoon.
Good afternoon.
Myself at the podium or no, okay, right here.
Wherever you'd like to be. We're not on the record. We're just talking scheduling.
Fine, right here, then, Judge.
Okay. You like the protection of the wall. Okay.
Just a convenience, but, so in terms of where we're at with the case, I believe, Sheena or Sheba Goodrum sent your office the defects records from Columbus. So I'm not sure if you got an opportunity to review those, but those are still outstanding, as well as the mental health evaluations and treatment from psychologists that were in question, Judge.
Okay. If we received the DFACS records and you haven't heard anything back, then I've reviewed them. I reviewed lots of DFACS records, and if they are disclosable, then I would have let both sides know, here's some materials to which you're entitled. So that's if we receive them. I don't have a specific recollection one way or the other. That name of Goodrum, is that someone you work with, or that's someone from DFACS? That's a lawyer for DFACS?
Lawyer for defects.
Okay. Let me. It's not jumping out, but that doesn't mean it didn't come in. And I think I did come across an email recently that would have been from you, Ms. Williams, that detailed, nope, that's Donikia Mann. But I thought it came from you that said, here are all the different, there were 4 or 5 counseling providers that the alleged victim had spent time with?
Yes, Judge, that was, 88 Clark sent that, back in August, I believe. So the therapy records, I do not believe have been received by the court. And that's a function of me not staying on top of that. I spoke with Mr. Jones and, he does still, want and need those records. So I would need to, follow up and get on top of that.
Okay, I'm seeing here, this is an email from Ms. Clark. So this predates your involvement in the case. And it lists 4 different treatment providers and the time frame during which treatment was provided. And then contact information, or at least last known. Some of this goes way back. And Mr. Jones, you were copied on that. Where are we with getting those materials? You need an order from me, or you were going to get me an order?
Potentially, last time we were in court, I believe you asked the state to kind of reach out and either subpoena or get those records. I'm fine if we need to do something else to kind of get a fire under them. I've reached out to these providers as well, no response.
Well, they're not going to give them to you necessarily.
Well, yeah, they're not for
Right.
records, just to make an introduction and let them know what's going on.
Oh, right. Here's who you are and why people are in the mix. Understood. So were you saying, Ms. Williams, the work that you need to do is in connection with these 4, or it was on the DFAC side?
Well, in the order that you issued after the Bobo hearing, you would ask the state to deliver your order
To these providers. Okay, that's what you need to do.
Correct.
Okay, so we know to whom the order needs to go. We've got 4 names here. Although I guess we need to work through one of the 4, what Mrs. Roy is saying, so mother of victim, is that actually Mr. Johnson took Abigail to the provider. So those you might be able to, it's just one date, it's 2 days before 3rd birthday, it says.
Yes, more of those, yes.
So you have those?
No,
No.
not.
Okay. Well, I'd like to get some momentum in obtaining those. And on the DFAC side, you put together a proposed order that I had entered, and that went off to DFACs?
Yeah, the order was emailed, I forget when, maybe April or May-ish of this year.
Of this year, okay. Oh, so it is fresher than the counseling situation?
Yes.
Okay. And we then need to follow up. Well, I guess you sent it off to someone. You knew, I don't know where to send those orders. So you got the order and
Sent it to legal department with DFACs in Columbus, that they communicated back and forth with them. Ms. Goodrum is with the legal department.
okay, that's how you got that name.
She's supposed to be sent them to your office, Judge.
Got it. Okay, I see the order I entered in March for the 4, I mean, it didn't list their names, but this is the order that the state needs to get to the 4 providers in Ms. Clark's email, so that those records will come here. And then I guess if you wouldn't mind forwarding to Ms. Nelson, my litigation manager, obviously copy Ms. Williams on it, whatever contact information you have for Ms. Goodrum, maybe I can reach out to see what the situation is, because as I think about the records that I've reviewed more recently, and it would have to be fairly recently given when that order was done, I'm not recalling records from this case. And so it may be that DFACs didn't follow through, or I don't know if their default is to say if there are no records, they just say nothing. it would be more helpful to send something saying there are no records rather than saying nothing.
But no, there are records, and I do not mind doing what the court has suggested, so.
Okay.
Like you said, we do need to do some more measures on my client does want to resolve this. And ultimately, we need to get a special set date. But, you know, we can figure that out at a later time.
Okay. Let me just check one more thing. Yeah, the last ones that I saw were for a different case. So why don't we do the follow-up with Ms. Goodrum to say it was an order, it wasn't a could you please, see if that makes a difference. Does that work?
Absolutely.
Okay, and as for your request for special setting, if we don't try Mr. Johnson's case next Monday, then it will become a case that belongs to Judge Ellerby. She is inheriting my criminal docket as of July 1. So you'd be working with her litigation manager and obviously Ms. Williams to see if that's something Judge Ellerby would be willing to do to special set it. I don't mean to speak for her, but she may want to have a once through with all these cases before she starts deciding from her own perspective which ones require a special setting and which don't. But she may be very open to it, especially if both sides are asking for it. Okay?
Very well, Judge.
So the do-outs are you, Mr. Jones, will get to Ms. Nelson the contact information for Ms. Goodrum. And you, Ms. Williams, will get that order, the March order, to each of the 4 providers that are listed in Ms. Clark's email and let them know. It directs all the records here anyway. Nothing's going to end up in a particular lawyer's hands. And then I'll go through those, or I know it's a little awkward because we're close to this transition period. If something comes too late, I may just have to give it to Judge Ellerby for her to review. But she may be okay if I just close out that part of the case and say, here's what's disclosed and here's what's not. But I'll coordinate with her. You all won't need to do that. Anything else from the state?
No.
Okay.
Now I'm back to Mr. Johnson, Judge.
Okay. Mr. Johnson, you follow all that?
Yes.
Okay. All right. Thank you, Mr. Jones.
That's all I have, Judge. My client wants to excuse me.
Yep. Yes, I don't know what the first one is. Do you have another? I just don't. Oh, yes. Give me a second. Yeah, it's 35, but that's, so we're gonna take this plea, and then, what we'll do is handle Ms. Ford's situation. And then we need to get whatever closure we're gonna get today on Mr. Thomas. I don't know what that is, but, for transportation reasons, we need to do Ms. Ford and then Mr. Thomas. Okay? Have you had a chance to talk with him?
I'm not going to talk to them. I have to Ms. Miller, go back and get their opportunity.
Okay. And then we will do the bond hearing, now that Mason Washington is here.
Okay, Judge, do you know about how long, because I'm bouncing between courtrooms today?
Is the plea particularly complicated? It's medium. It's Mr. Foster.
You just need to we're gonna just try to get through it, Judge. That's
Okay.
all.
You probably have about a half hour. Does that give you enough info about which direction to go?
That's perfect. I'll be
Okay.
fine.
Great. We'll see you. Your counterpart's not here yet anyway. Mr. Body needs to get here. But we'll do that bond hearing when you're both here. All right. Sorry to keep you moving back and forth so much. Hello, Mr. Foster.
Okay.
So we are going forward with the 01 of it was, somehow you managed to make it so the superseding was just an 01 rather than a whole new number.
Yes.
Excellent.
And as to count 3, Ms. Nelson,
Even though this is non-negotiated, the state will be reducing that to OCGA 16-12-4, the cruelty to animals, which is a misdemeanor.
What the calendar says is criminal attempt to commit a felony. That's the count you're talking about.
Yes.
And that'll be 16-12. Did you say 4 or 14?
4.
4, and that's the misdemeanor.
Yes.
Okay.
That was that charge was the attempt. So.
Okay, got it. Okay. Well, let's get on the record, make sure we've got Ms. Allen back. We do. You with us, Ms. Allen?
Yes, I'm here, Your Honor.
Excellent. Okay. We're handling a case off the supplemental trial calendar, position 1. It's State versus Dwight Foster. Mr. Foster is here in court with his lawyer, Ms. Wood, and we have Ms. Willingham for the state. The case is 26 SC 000-081-01 because it's a superseding indictment. Mr. Foster, are you ready to go forward?
You got to speak up so the court reporter can hear you.
Yes. Okay. What I understand we're going to do over the next few minutes is have a conversation about whether you're entering a plea in your case. For that to happen, Ms. Willingham's going to put you under oath. Once you're under oath, she'll then ask you questions about your rights, things you and Ms. Wood already talked about, a little bit about your background. You need to answer all those questions. Ms. Wood will give me her sense of what this case was about. And then if I accept your plea, I'll let you know what the sentence is going to be. Okay? All right. If at any point you have a question for me, let me know. And if at any time you want to speak with Ms. Wood privately, let me know and we'll make that happen. Okay? Good. You just got to make sure when you're answering the questions, you're welcome to nod or shake your head, but you also have to verbalize the answer because our court reporter is not in here watching you. She is listening to whatever it is you say. Okay? All right. Good. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
It's Dwight Laquan Foster.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Prescribed medication.
Okay. Tell me, I don't need to know the names of the medications. Those are often hard to say. Tell me what you're taking medication for.
Anxiety and depression.
Anxiety and depression? Do you take that medicine in the morning or at night?
In the morning I take anxiety and mood. I'm under mood medicine and anxiety and depression. And at night I take medicine for sleep.
Okay. Did you get your sleep medicine last night?
Yes.
And that helped you sleep?
Yes.
Good. Did you get your anxiety and mood medicine this morning?
Yes.
Did you take it? Yes?
Yes.
When you take it, does it make you drowsy or woozy?
Yeah.
Do you feel drowsy now?
Tired, yeah.
You're tired. Okay, I'm tired too. Are you awake enough to be able to have a conversation about your case?
Yes.
Okay, you can go take a nap afterwards, but you think you'll stay awake for our conversation?
Yes.
Yes? Okay. If you start to fade, let me know. Will you do that? Okay.
How old are you and how far have you gone in school?
I'm 32 and half of the 11th, 12th grade. I made it to half of the 12th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Including any potential defenses.
Do you feel like you've had enough time in meeting with me and my investigator and Ms. Ross to talk about your case?
No. To defend myself properly, no. I have not been able to talk to the investigator at all.
So two different things. I appreciate there's some conversations you'd still like to have. But I need to be comfortable that you're comfortable having the conversation we're having. That even though it'd be nice to talk to the when you say investigator, do you mean it's Ms. Wood's investigator, not the police officer?
Yes, and Ms. Wood's investigator.
Okay. If you were going to go to trial, I'm sure that you and the investigator would talk. But it sounds like you are okay with working this case out by way of a plea. So you can get, is this a negotiated plea?
It's a non-negotiable.
Non-negotiated plea. So that Ms. Wood can make the argument she's going to make today. That means that you are going to stop your preparations and instead say, rather than going to trial, I'm ready to try to work this case out. Are you okay going forward, or were you saying, nope, stop, we're done for today, I need to go talk with Ms. Wood's investigator?
We can go forward.
We can go forward? Okay. We'll keep doing that. If we need to stop at some point, you should tell me, okay? All right.
Counsel, are you satisfied your client has a full understanding of the proceedings?
Yes.
Have you reviewed the indictment in this case?
Yes,
Do you waive formal reading of the indictment?
we do.
Has your client been arrested on these charges?
He has.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
We do not.
Do you understand, and I'm sorry, Mr. Foster, do you understand that this is a non-negotiated or a blind plea and the state will recommend a sentence to the court?
Or I said she's gonna ask for one thing and then we'll ask the judge for what we talked about in the back, okay? So that's what that means.
All right, yeah.
Yeah, blind plea doesn't mean it's going to be a secret. All it means is that Ms. Willingham's going to be arguing for I'm going to make it up. She's going to argue for 5 years to serve 1 year with some probation. And Ms. Wood's going to argue for a different lower sentence. Maybe hers is going to be straight probation, so you get out this week. I don't know what they're going to be. I'll hear them. But they're not agreeing. They're arguing for different sentences. Do you understand that?
Yes, Your Honor.
Okay, you also understand that I'm not obligated to follow either one. I may agree with Ms. Wood, I may agree with Ms. Willingham, I may be somewhere else. Ultimately, I'm the one who'll be deciding what the sentence is. Do you understand that?
Yes, Your Honor.
Okay.
And do you understand that you would be entering a guilty plea to 2 counts of aggravated assault, each which have a minimum of 3 years and a maximum of 20? Cruelty to animals, which has a minimum of 1 day and a maximum of 12 months. Battery, family violence, misdemeanor, which has a minimum of 1 day and a maximum of 12 months.
Yes.
And were you made aware of the state's offer prior to today's hearing?
That's when I was telling you what her offer was. That's what she's asking if we talked about it before right now.
Oh, yes.
And do you understand the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
And Your Honor, for the record, the state's recommendation in this case would be, as to count 1, 10 years to serve 5 years. As to count 2, 10 years to serve 5 years. As to count 3, reduced to cruelty to animals under OCGA 16-12-4, which is a misdemeanor, and the recommendation would be 12 months to serve. As to count 4, 12 months to serve. All counts would run concurrent. We would be requesting that the defendant complete family violence intervention program, stay away from the victim, complete a mental health evaluation, and follow any recommendations. And Mr. Foster, do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts? Are you on probation or parole for anything, anywhere?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment?
Speak up and make sure.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
So that's what she's making sure that you understand that by taking a plea date and a trial, so the rights that you.
I ain't taking no plea today.
So that's what we're doing right now is a plea.
So what's the plea? 5 to 10 be 5?
So it's non-negotiated. So she's asking for 10 circle and we're asking for 5 circle.
Oh, 10, 5 circle.
That's what she's asking for. And we're asking for something different. Mhm.
And we're asking. I'm lost.
Okay. So I get to talk at the end.
So I'm taking a plea of 10 to 1, 5 to 1.
5 to 1. So what am I talking?
Okay. Oh, yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Oh, this is, so we're doing that. So I think I said this earlier, it's gonna be a best interest plea, so, and so that's where you say I'm pleading guilty because it's in my best interest.
Best interest.
Mhm.
So no low or alpha.
So that is an offered plea. So when she asks me, how are you pleading? You say I'm pleading guilty because it's in my best interest. Okay?
All right, yes.
So is this a plea under Alford?
Yes.
Yes.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial? How do you plead to the charges to 2 counts of aggravated assault, cruelty to animals, and battery family violence in indictment 26 SC 00081-01.
That's what you say. Okay.
Pleading guilty in my best interest.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today. Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, if this case were to proceed to trial, the state would expect to show that on January 8th, 2026, officers responded to 37 Wadley Street, apartment 37.
I had 2025. That's what the indictment says. I'm not disagreeing with you. And we can amend that defect.
And I was just going to say, with that said, counsel, do you waive any defects in the indictment?
I do.
On January 8th, 2026, officers responded to 37 Wadley Street, apartment 37 in Atlanta, Georgia, in reference to a domestic altercation. Upon arrival, officers made contact with the caller downstairs, with the downstairs caller, who was the neighbor, Miss Tam, and the victim, Miss Doris Gaffney. Investigation determined the following. Ms. Gaffney and the defendant had been in a romantic relationship for approximately 7 months prior to the incident and were at the time residing together in the apartment wherein the incident occurred. The defendant had been drinking alcohol and set the couch on fire. This caused an argument in which during the argument, the defendant attempted to set Ms. Gaffney's house cat on fire before pushing Ms. Gaffney into the fire on the couch. The defendant then punched and bit Ms. Gaffney upon the face multiple times, and officers were able to observe severe lacerations in her face, blood in her eyes, and bruising on her right hand. Additionally, and I believe I stated this already, but additionally, the defendant threw her onto the couch into the fire. And Your Honor, there was not and also tried to choke her. There was not a arson charge on this because the couch belonged to the defendant. So
you can set your own couch on fire and that's not arson.
that is correct,
Okay.
Judge. But the case was re-indicted to add the aggravated assault for actually pushing Ms. Gaffney into the fire on the couch.
Okay. And were they, Mr. Foster and Ms. Gaffney, at the time in a relationship, or this was post-relationship strife?
No, Judge, they were in a relationship, and actually, Ms. Gaffney literally just texted me to get an update. She knew that we were going to be doing the non-negotiated plea today. She is willing to testify should this case have to go to trial, but she did believe that based on everything involved, that she thought this was a fair resolution. She would like to not have to go to trial, but is willing to should we come to that.
Okay. So she's ready on Monday if we need to go to trial.
Yes.
She's aware of what the state's offer is. She doesn't want to be heard. She's speaking through you.
Yes, and she is aware that we did discuss that the court can sentence the defendant to either more time or less time than what the state is asking for, and she does understand that.
Okay, understood. Do we know how the cat turned out?
It is my understanding from her that the cat is fine.
Okay. All right, and she's okay?
She is.
Okay. And your understanding of the facts are that Mr. Foster intentionally set the couch on fire as opposed to he was drinking and maybe someone was smoking and alcohol and flame and it wasn't, whoops, the couch is on fire.
Correct, Judge. It is my understanding that it is intentional, and just a little bit more about why Ms. Gaffney is also okay with this being a non-negotiated. Ms. Gaffney has reached safety. And she is aware that should this case actually proceed to trial, that more of her information will need to be turned over. And I think that is in part why she would prefer we resolve it this way.
Understood. Okay. Thank you so much. Ms. Harvey,
Yes,
turn
Your
on
Honor.
my clockwork.
6 cycles out of Georgia and 12 cycles out of the state of Tennessee. Out of Tennessee, a 2019 felony conviction for theft of property. Out of Georgia, he was sentenced in 2023 under first offender for robbery out of Fulton County. He was also sentenced February 3rd, 2026 in 2 separate cases, one for criminal trespass and the second case for willful obstruction of a law enforcement officer to 12 months probation, also out of Fulton County, and nothing further, Your Honor.
Were the 226 cases, were they state court or superior court? Are you able to tell?
They were state court, yes, Your Honor.
State court. Okay. Thank you so much.
You're welcome.
Ms. Simpson, is Mr. Foster, he said he's on probation, so it must be the first offender probation in the 2023 case. How much time does he have left?
Has 5 years, 5 months for me.
5 years, 5 months. Has there been a revocation in connection with this?
He had a revocation in January.
In front of? Okay, so there are no probation implications of this plea. All right, thank you. Okay, Ms. Wood.
Thank you, Judge. So Ms. Willingham and I actually started working towards a resolution on this case back in February. So it has been quite a journey. I actually, thanks to Ms. Willingham, I also spoke with the victim. She was very gracious to speak with me, knowing who I am. And everything that Ms. Willingham said is exactly what she told me as well. They were in a relationship. One of the hiccups here and one of the reasons that Mr. Foster had been working with my investigator is because it was his contention that there had been, it was a tumultuous relationship leading up to this point. And so I had my investigator try to do some work to see if there was any proof. I'm not doubting what he said, but just if there was any hard proof that I could share with the state. And so that is one of the things that we had worked on. And so after doing our own investigation, we found that it was just best to move forward in a non-negotiated fashion here, Judge. He was already plugged in with 10 Park Place. He actually had housing earlier this year. I don't know, I didn't get confirmation. I know he lost it, but I don't know what that process looks like. I'm sure they will be able to work with him at some point once he's done with his custodial time. But yeah, so he was getting his medication through 10 Park Place and had the housing through Grady ICM. We're asking the court to consider a sentence of 5 served 1 year in custody with the balance probated. Of course, we have no issue with the stay away. And I would also be in line with him having a mental health evaluation and taking his prescribed medications. And I would just like to add that his mother and his brother, they live in Tennessee and they have been very, very plugged in and concerned about him. And so he does have that family support on the outside,
Good.
albeit not in the metro area. They do call and check in on him quite often.
Sure. Did you and Mr. Foster discuss at all whether when he's done with the custodial part of his sentence, he'd want to go back to Tennessee? I ask only because that's complicated on the probation front, not to say he needs to or he shouldn't do so.
The last that we discussed was that he was going to be in Atlanta. for the
Okay.
time being. I'm not sure if the mom is going to try to get down here or whatnot, but yes.
Got it. Mr. Foster, when you get out, is it your plan to stay local?
Yes.
Not go back to Tennessee? Where in Tennessee is your family?
In Knoxville, Tennessee.
Knoxville. Okay. Do they stay in touch with you?
Yes, Your Honor.
Good. And who do you have? You have your mom in Tennessee?
My mom, my brother, my mom and my brother, and
Okay. And they both reach out to you? Good. Do you have kids?
not that I know of.
Not that you know of.
That it's possible. But
Okay.
we
But
never-
there's not a child who's you're not active in a child's life.
I'm not active.
Got it. Okay. Do you have any questions about anything we discussed?
I mean, I would. I mean, would it harm if I share my side of the story?
No, well, two things. One, you're free to tell me what you want to tell me. But I'm gonna get to that in a minute. I wanted to make sure if you had questions like, well, tell me how probation works or what's the family violence in it. I'm happy to talk to you about that insofar as I know an answer. In a moment, I'll give you an opportunity to say what you want, but that doesn't mean you have to tell your side of the story. I know there are always two sides of the story. And when you told me this is a best interest plea, that's the way of saying there are two sides to the story. That, hey, some of this stuff happened, but it's a lot more complicated than maybe the police made it sound. And I get that. It's still a scary situation for Ms. Gaffney. It may have been a scary situation for you. You may have been in the middle of some kind of episode and you don't remember a lot about it. But it sounds like she was pretty beat up when the police came. You may have been beat up too.
Man.
So, and I understand that. You're the one who's been charged, and it sounds like some of the things that happened are at your feet. There may be some things that ought to be at Ms. Gaffney's feet, but that's not whose case we're talking about today. We're talking about yours. All right, so you're on probation out of Judge Richardson's courtroom, and then you resolved your two state court cases. Were those just time served, or was that probation? Do you know?
Resolve the.
This would be like the trespass case and the obstruction. It would have been earlier this year.
I think, yeah, we resolved them.
Okay, you did resolve them. I was just curious if you remember for what. Anything more you want to share?
You don't have to say anything if you don't want to. Oh, you didn't. I think I want, well, putting in this non-negotiating plea. So with the non-negotiating plea, I don't know what's being offered.
So you do. Ms. Willingham has argued for 5 years in prison, followed by 5 years on probation. That's 10 serve 5. Ms. Wood has argued for a different sentence, much lower. And so that's why it's non-negotiated. I'm going to tell you what I'm going to do now, okay? Now that it's been very helpful to hear from Ms. Willingham, and through Ms. Willingham, hearing Ms. Gaffney's view of things. And it's been super helpful to hear from both Ms. Wood and you, because there are always two sides to each story. Mr. Foster, first of all, I will accept your plea as what we call an Alford or best interest plea, where you're saying it didn't go down quite like the police said it went down, but I don't want to run the risk of going to trial. There'll be pictures of this burnt couch. Ms. Gaffney's going to come in and say this happened and this happened. Could be pictures of a cat with singed hair, things that could be a problem for you at trial. There might be good things for you at trial as well. That's why you've got this great lawyer. But you've told me, best interest judge, it's easier to work it out this way. So I will accept that best interest plea. I do find there's a factual basis for the plea. If the state can prove all the things that it said, then a jury could find you guilty. I don't know if they would find you guilty, but that's a risk you're choosing not to take, and I appreciate that. I also find that your plea is what we call voluntary. No one's forcing you to enter the plea, and that it's knowing, meaning you've understood the things we talked about, and when you didn't, you and Ms. Wood talked about them until you said, yep, I got that. Do you agree with that?
Can you repeat that?
Sure, I'm gonna break it down. I believe that your plea is voluntary, meaning no one's forcing you to do this. No one has said, hey, man, we're gonna hold your mom hostage until Foster pleads guilty. Nothing like that's happening. Is that fair?
The only reason, I'm gonna tell you the truth. I can't get the records of where I tried to make the police phone calls to get her out of my apartment every month that she's been in my apartment.
Okay.
And That's one of the reasons, because I can't.
Got it. There are lots of different reasons why people enter a best interest plea. But in the end, that defendant and that defendant's lawyer have looked at what they do have and what they don't have. You don't have those records. They look at what the state has. Maybe it's pictures of Ms. Gaffney with some injuries. I don't know. I don't get to see that stuff unless there's a trial. And you weigh all that and you say, you know what? It's not what happened, but it's in my best interest to go forward with a plea, meaning your best interest, not mine. Am I describing your situation?
Yeah.
Okay. Well, I'm gonna accept that plea then. We'll keep going. Ms. Wood, do you authorize someone in my office to sign the indictment on your behalf and Mr. Foster's behalf?
Yes, Judge, thank you.
And Ms. Willingham, can someone sign for you?
Yes, Your Honor.
All right. So, Mr. Foster, I am sentencing you in connection with these different offenses on count 1, that's the fire aggravated assault, to a term of 7 years to serve 2 years with a balance probated. Count 2 is 7 years to serve 2 years. Count 3 is 12 months to serve. Count 4 is 12 months to serve. They all run together at the same time. So it's one sentence, and that's 7 to serve 2. The state asked for 10 to serve 5, and I think a better fit based on what I've learned about you, what you've shared with me about this situation, is the 7 to serve 2. You will get credit for the half year you've already done in custody. You are parole eligible. And so the most you would do would be another year and a half. But you will be considered for parole likely well before then. You'll be on probation for 5 years. Special condition of probation number 1, the most important one, is that you stay away from Ms. Gaffney. Sounds like that's going to be okay by you. But you don't reach out to her, you don't go around her, you don't text her. If you know where she is online, you stay away from that. That's number 1. Number 2 is that you are going to have a mental health evaluation. I think you already have good treatment and you know what the diagnosis is, but the point is to have another doctor get with you so that he or she can say, here are the meds Mr. Foster needs so that things are smoothed out for him. Less anxiety, less depression, fewer mood swings. Any medication that a doctor prescribes you, you need to take as a condition of your probation. They're not going to be optional pills. If the doctor says you take these things, you'll need to take those. I'll ask, if that's not already the case, Ms. Simpson, that Mr. Foster get to work with a probation officer who focuses on mental health treatment. And Ms. Willingham, I am torn with the Family Violence Intervention Program. It is a great program, and I think it fits these facts. I'm not real clear that it fits Mr. Foster's abilities to meet that requirement.
I will have to take a look at the language of the indictment. If the language is for intimate partner, then it is actually a requirement.
Okay.
However, if it's not,
I'm not fighting it. I just don't want to set up a requirement for Mr. Foster that's going to be unduly complicated.
and I do understand, Judge, let me.
Well, I've got the indictment right here.
You could.
So it's the accused and the person are persons formerly living in the same household.
So.
Or do you need other language?
What I can do is, I don't have a problem if the defendant is going to accept the court's sentence, then I don't have a problem amending it to take the family violence aggravator off, and that would give the court the ability to require that.
No,
Otherwise, it's statutorily required.
And the aggravator is that language, persons formerly living in the same household. You don't need to change it. I'll include that, and if we need to revisit it because it's something that's not working out, I can always modify it. So final condition is the Family Violence Intervention Program. So, Ms. Willingham, anything else in connection with Mr. Foster's case?
Nothing from the state.
And assuming we go forward with this, you'll be dismissing the older indictment.
Correct.
Okay, all right. And Ms. Simpson, we don't have anything we need to work through on the probation side because Judge Richardson already did the revocation. Okay. Ms. Wood, is there anything else on behalf of Mr. Foster?
No, he did have a question, while you were looking at the indictment about where he will be housed. I advised him that that is up to the custodian and not the judge.
Right. So Mr. Foster, it is likely that you will go to the Department of Corrections, but I don't decide that. The sheriff will look at what the sentence is, how much time you've already done, which is a whole lot. And there may even be a conversation with the parole folks where they'd say, don't send him there because he's going to be paroled soon. You should ask folks at the jail. They'll have a better sense. But it may be that you do go for a little while to Department of Corrections, okay? When you get out, it's going to be important to plug in with treatment, and probation can help you with that. 10 Park Place, all those spots. They're going to have all your records and you just want to slide back in because you'll get good treatment while you're in custody. You just don't want that to end when you get out. Will you do that?
I don't know what's gonna happen to me here, Your Honor. Honestly, I don't.
Okay, well, no one has a crystal ball. I'm just asking that when you are released, because that'll happen, assuming you're staying local, because you said you want to stay in the Atlanta area, is that when you get out, you plug back in at 10 Park Place.
Oh, yeah, that's what you said.
Yeah, that's what I'm saying. You'll do that? Okay, good. All right, Mr. Foster, good luck with things, okay?
Thank you, Judge.
Judge, that concludes my business. We did submit a.
Oh, I meant to ask about that. So, there was a change of heart?
Yes.
Was that Ms. Wood?
Yes.
Who's he working with?
Yes.
So I think you get his name backwards each time. That's all right. Mr. Nelson has decided to do diversion. Is that correct?
Yes, Judge.
Okay. I will take care of that today and cross him off the trial list.
Thank you.
Judge, I'm not sure what matters we would take next, but the victim for Kenneth Newton has been on the Zoom since 9 a.m. and he's entering a non-negotiated plea. So I was just going to ask when we get a chance to do the plea.
Okay, I'm sorry we've been delaying that. We need to do, Ms. Ford for transportation issues. So we'll do that. And I think before we bring Ms. Ford out, let's not bring her out yet. She was supposed to go to ITF and now can't go to ITF? All we're doing is modifying probation. I'm just wondering if it is we're fighting it or it's, nope, she's not eligible.
Denied because she had advised the council when they did her eval that she had some medical issues going on. They required some type of surgery.
Okay,
And so they denied her on that basis.
got it. So we have to come up with this is now plan C.
Yes, it's plan C.
Okay,
I think we're all in agreement just to time served and
Yeah,
just
she's
let her know.
been dying to go back to Macon, which is fine with me. I'm here.
as long as Ms. Simpson's okay with it, we'll do that.
So, the only thing is that I was gonna ask that is that if we could, include as a special condition that she makes sure to maintain some hope.
Yep,
Are we clear that she's not having to do any type of like drug court or drug program, right?
I think she's got booted from that before. I thought that was the whole,
Okay, I was making sure, because I know, her mom, Ms. Gibbons said that also conflicted with her being able to go to her doctor. And so that not hindering, she'll be able to go to her, all her appointment. Okay.
We're just.
yeah, I don't think we're putting, other than you need to, comply with all medical recommendations, take your medications. We're not imposing it. Okay.
We just want to make sure she.
Okay.
All right, so let's bring Ms. Ford out, please. Yeah, so she had day reporting center and was terminated from that. Then we went to, I think it was gonna be RSAT, but maybe it was straight away ITF?
We did add on her.
Got it. Okay. All right, let's get on the record. Hello, Ms. Ford. Good to see you.
Nice seeing you too.
Your case is 24SC002846, and we are hopefully on the final chapter of dealing with your revocation. Way back in the day, I was revoking you because you had been in the day reporting center and you got terminated from the day reporting center. And so we were trying to get you some in-custody treatment. We didn't structure the order right the first time, and then the second time, you shared some information about some medical procedures you're gonna need. And the in-custody treatment place said, well, we can't work with Ms. Ford then. She needs to get the procedures and not be with us. And so I think there's now a joint recommendation, but I'm gonna hear from Ms. Rios, your lawyer first, see if Ms. Smith, the prosecutor, has anything different to say, and then I'll let you know what we're gonna do, okay? Ms. Rios?
Yes, Your Honor, we're just asking for you to continue her on probation so she can be released to her mom, who is here, Miss Bivens. Her sister's here too, and so we.
Here as in the courtroom?
Yes.
Oh, there they are.
They've been patiently waiting. And so we are asking that she go to live with her mom in Macon. I spoke with her mom and she'll be able to get mental health services by living with her. She is very concerned about her staying in Atlanta. She's had a lot of issues with Atlanta and things have happened to her here. So her mom wants her to be safe with her. And so we're asking for, I think the probation, they'll be able to transfer it. So that's what our request today. And I understand this probation wants her to be a requirement that she take her medication. That shouldn't be an issue. She has services in place to go get her medication.
Okay. Ms. Smith, do you see this in any different way?
I do not, Judge.
All right. Then that's, I think, what we'll do. Ms. Ford, do you understand what's going to be happening?
Yes.
I'll be modifying the revocation one last time to basically be time served. You have been in custody for at least 4 months now. There was a purpose for it. We were trying to get you into the treatment program, but that's not the right fit. And so I'll turn it into just a revocation of about 4 months, although I'll work with Ms. Simpson to make sure we get the right math. I'm not saying you're getting out today. Don't misquote me. It might be in the next few days, but it's not next month or anything like that. It may be a few days to get it all processed. And then Ms. Rios says your new residence will be back in Macon. You won't be in Fulton County. So you'll be supervised out of, would it be Houston County? I think that's the right county. Bibb County. You'd be supervised out of Bibb County. And I'm gonna modify your probation.
The first offender. I don't think that she wants to make sure her first offender is still in place.
The incentive as well.
You mean the early termination?
Yeah.
Nothing's changed. You have a behavioral incentive date of March 22, 2030. So it's about 4 years from now, a little less than 4 years from now. It was 4 years back when you got sentenced. Oh, okay. So it'll be a little longer than that, but you still have a behavioral incentive date. You're gonna live in Macon, and I'm gonna modify your probation to include the condition that you take all medication that's prescribed. So if a doctor says you need to take X, you gotta take it. If it's treating you the wrong way, then you talk with the doctor to say, could I get a different prescription? But you don't say, I'm not taking this. Because the medicine is meant to help you feel a little more stable and maybe not get mixed up in the kinds of things that got you stuck here to begin with, okay?
Yes, sir.
Any questions? Do we have the address in Macon, or will you get that from Ms. Bivens? Okay, but you can do that with mom, okay. All right. Ms. Smith, anything else in Ms. Ford's case?
Nothing further, thank you.
Ms. Rios?
Thank you.
All right, any questions, Ms. Ford?
No, sir.
Okay, you ought to get out in the next few days. If you are still in and it's next week, call Ms. Rios and we'll figure out what the issue is, okay?
Yes.
All right.
Make sure she have my number. Okay. Good luck. Thank you.
So, Ms. Smith, what are we doing with Mr. Thomas?
It's my understanding that the defense counsel would like to continue negotiations in this case regarding if we will be resolving the case short of trial. But as far as the discovery that needs to be sent over to,
Just making sure he's okay. He's okay, he gave the thumbs up. Okay,
regarding the discovery that needs to be sent to Ms. Timbelka, we've already made contact with Sandy Springs. She'll have that soon. But from my end, I think that's the conversation we last had.
okay, and then there's the Jackson Deno.
That's correct.
Okay, is she talking to her client now? Is that, she can stay back there, we can do Newton, while that's happening. Why don't we do that? All right, we did Foster. Is this a plea to both cases or to one and something's being dismissed?
To both.
Non-negotiated, Judge.
Kenneth Newton.
That's not.
Wonder how far we would get. It's like, yep, and you're charged with this and you've got 2 cases. And he's like, all right, whatever you say, I'm going home. It's great. Yep, I set the cat on fire.
I would say, Judge, in the indictment ending in 4-0, position 7, count 3, reckless conduct will be nullified, but that's the only challenge.
All right, that's big. All right. Oof. Good rock on the boat there. What about Varner? That's still a go? We just haven't gotten to it yet. Okay. And did that. Did that. Oh, all right. Then let's do Mr. Newton. Hello, Mr. Newton.
Hi, guys.
I'm all right. We're going to get on the record in your 2 cases. It's position 6 and 7 on the trial calendar. And Mr. Newton, you are represented by Ms. Wood in both cases. Ms. Smith is the prosecutor in both. She, Ms. Smith, in a moment is going to put you under oath, ask you questions about your cases and your rights, and we'll see if we can get through the 2 pleas. They're non-negotiated. The state's dismissing 1 count in the second indictment, but that'll all get on the record. Please answer all the questions out loud and loudly when you answer, but also let me know if at any point you've got a question for me or you need to speak privately with Ms. Wood. Will you do that?
Sir.
Great.
Mr. Newton, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, if you can lower your hand. Please state your true, correct, and legal name for the court.
Kenneth Newton.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given today?
I took my medicine earlier, like at about 4 o'clock. It's like blood pressure and pain medicine.
Okay. Does any of that medication make you loopy or woozy or drowsy?
It's a little drowsy.
Okay. You feeling awake enough to go forward?
Yes, sir.
Okay.
How old are you and how far have you gone in school?
56, complete high school.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in both of these indictments?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
So waived.
Mr. Newton, do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes.
Do you also understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this guilty plea?
I am.
Mr. Newton, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 26 SC 000309, how do you plead to count 1, aggravated assault, count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies, count 3, reckless conduct, count 4, discharge of firearms on or near public highway or street, and count 5, possession of a firearm by a convicted felon?
Yes.
How do you plead, guilty or not
guilty.
guilty? Is this guilty plea freely and I'm sorry. That was indictment, the first indictment. For the indictment 26 SC 000040, how do you plead to count 1, terroristic threats and acts, count 2, criminal trespass and damage to property?
Yes.
Okay. And for the record, count 3, reckless conduct, will be known processed by the state in this indictment. Are both of these indictments for this guilty plea freely and voluntarily? Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to directly appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that that process must be completed within 30 days from today?
Yes.
Do you also understand that you have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
All right. Thank you, Mr. Newton. Your Honor, this case were to proceed to trial, starting with indictment ending in 309. The facts would show that on November 21st, 2025, officers of the Atlanta Police Department was dispatched to 3337 Cascade Park Boulevard. When the officers got there, they spoke with Miss Alyssa Johnson, who was the victim in this case. Miss Johnson informed the officers that she was standing outside of her residence waiting for an Uber when her ex-boyfriend, Mr. Kenneth Newton, the defendant in this case, pulled into her driveway in a vehicle. The victim in this case stated that the defendant got out of the car, brandished a silver and black firearm, and confronted her saying, "You got me effed up. Who you talking to?" Miss Johnson told him to leave her alone, at which point Mr. Newton allegedly pointed a gun at her head and stated, "B, you don't know who you're playing with." Miss Johnson further stated that Mr. Newton discharged his weapon by firing one round into the ground. He then knocked Miss Johnson in the head, causing her bonnet to fall off. A nearby neighbor in this case heard the commotion, went outside, and was instructed by Miss Johnson to call 911. At this point, that neighbor did call 911 and they responded to the scene. When the officers got there, two things happened. So they spoke with the neighbor who confirmed that she heard a scuffle going on outside. She looked outside and saw the defendant and the victim fighting, and she saw that the victim was running into, like, trying to run back to her front door because she was standing outside of her home, and that the defendant started chasing behind her. They got into a physical altercation. As far as the shooting, she said that she did hear a sound that sounded like a gun. However, they do live by an highway, so she said maybe she thought it could have been a tire popped or whatever the case may be. The neighbor stated that when she went outside and she saw them fighting, the victim in this case asked her to call 911, so she did that. When the officers responded to the scene also, they found a shell casing, a 9mm shell casing in the bushes near the garage, which is where the shooting into the ground was supposed to have happened, matching one of the guns that Mr. Newton had. In this case, I had an opportunity to speak with a neighbor while prepping for trial, and she told me kind of the same thing that's in the police report, that she saw the scuffle. She went outside. The victim told her to call the police, so that's what she did. I also had a chance to speak with the victim in this case, who is on the Zoom call and would like to be heard, but she basically told me the same thing that was in the police report. She told me a little bit about their history, and I'll just save her statement for when she wants to make a statement later. She's the victim in both of the cases, so we can hear from her after the second circumstances of facts that we have. All of this occurred within Fulton County. At that time, Mr. Newton was not arrested for the charges we have in front of us because he fled the scene. However, later, he was arrested for both this case and the next case at the same time. Those are the facts and circumstances of the indictment ending in 309. For the facts and circumstances for the indictment ending in 040, the state would show that on December 19th, 2025, officers of the Atlanta Police Department responded to that same incident location, 337 Cascade Park Boulevard, Southwest Atlanta, Georgia, also in Fulton County. When the officers got there, they spoke with Miss Alyssa Johnson, the victim in this case, who stated that she was sitting in a chair, or she was sitting on a couch in her home when her window was broken. This is kind of late at night when her window was broken by a chair that was sitting on the porch. Someone tried to throw the chair through the window. She ran upstairs and she looked out the window and saw that Mr. Newton was leaving or running away from the location. At that point, that's when she called the officers to the scene because she was afraid of what he may do based on their past interactions. Also, in this case, the defendant sent multiple text messages to Ms. Johnson, threatening her, saying that if he couldn't get to her, his family could, that they would drag her. He also sent her a message saying, "Say bye-bye to Zora." Zora is her child. So he would send threatening messages just saying that he would kill her. And if, of course, if, like I just said, if he couldn't get to her, his family could. So with all of those facts and circumstances we have, and those text messages, which I've provided discovery to defense counsel with those text messages, the defendant was charged with the offenses we have before us today. As I told you, he was arrested on one day for both of these cases that we have. But those are the facts and circumstances of this case regarding the non-negotiated plea between the state and defense. The state is asking for 10 years to serve 3 with the balance probated. As far as the special conditions of probation, the state is asking for the defendant to stay away from the incident location, to have no contact with the victim, for the firearm that was found on the defendant the day he was arrested to be forfeited, and for the defendant to complete a family violence intervention program. I would like to note for the court that on January 23rd, 2025, so the top of last year, the victim in this case was granted a restraining order against the defendant.
I was going to ask, there's no ag stalking charges in here.
It was missed.
Meaning it could have been included,
Correct.
but your office wasn't aware of the restraining order.
Correct.
Okay.
But I did receive a copy of it, and in that restraining order, it was signed by Judge Glanville. It stated that the defendant was not to be within 200 yards of the victim, was not supposed to be outside of her residence or have any direct contact with her. Mr. Newton was aware of this restraining order. He was made aware by the court and also through the victim when he came to her home. Because he was in direct violation of this restraining order, to know not to be around her and then to commit 2 offenses, is why the state is asking for that 3 years in custody, with the remaining to be served on probation. But with that, Your Honor, nothing further from the state. I believe the victim would like to make a statement.
Okay. Good afternoon, Ms. Johnson. Thank you for your patience. I know you've been waiting both today as well as for months since these cases were brought to light with the arrest in December of last year. It's important that you have an opportunity to be heard. It's important that I hear from you. So if there are things you want to add to what Ms. Smith shared, either how this has impacted you, what you think the right outcome is, or just what's on your heart, I'm here to listen.
Thank you, Your Honor. Your Honor, I just want to say, before I met him, my daughter and I had a beautiful and peaceful life. Over the next year and a half, that life was taken from us. At first, he presented himself as a good man, but he was anything but that, as he began to control me through beatings, fear, psychological mind games, and intimidation. The abuse became a constant part of our lives and left us living in fear every day. A witness saw him hit me in my own front yard and then fire his gun next to me to intimidate me in broad daylight. This was about the 6th time he has discharged his weapon next to me to control me at any of those times. The bullet could have ricocheted and killed me. A couple of weeks later, and despite him knowing I had filed a restraining order against him, he came to my home at night and broke my window. He has said on multiple occasions that he does not care about a restraining order and that he would still get to me. He threatened to kill me and threatened to kill my daughter so many times that I had to send her to live with my sister, because I truly believed that if he succeeded in killing me, at least she would still be alive. I was constantly on the run from him, and because of that, could not hold a job. Everything I had worked so hard for was almost taken from me simply because I wanted to leave him. My daughter and I both have PTSD. We are still trying to heal and rebuild our lives, and the fear and trauma he caused has not gone away. I respectfully support the state's recommendation of 3 years in prison, followed by 7 years of probation, because I truly believe that sentence is necessary for our safety and to give us the chance to rebuild the life we lost. Thank you, Your Honor.
Thank you, Ms. Johnson. I've got a couple questions if you're okay with that.
Yes, Your Honor.
Tell me how old your daughter is.
She's 12.
Okay. And is she still with your sister, or are the two of you reunited?
No, we reunited, thank God.
Good.
We
Okay.
reunited.
All right. And I guess it's summertime, but she's doing okay in school? She's
Doing well. She's a gifted student. She speaks 3 different languages, and of course, this entire incident took her off her path. But hopefully, she'll get back in the school that she was in. I had to change schools for her safety. I had to do a lot of things for her safety, but hopefully, she can get back to the school where she was being nourished with the proper education.
Great. Well, I'm glad you two are together again. The other thing has to do with where you're living, and I don't want you to tell me where you live, But I want to make sure that I am putting in place as effective a stay away as I can. And so part of that might be, well, someone needs to be in this county, someone needs to be in that county. Are you in Fulton County?
Yes, I'm in Fulton County.
Okay, all right. Anything more you want to share?
I just, I support the state's recommendation wholeheartedly for our safety because this man truly does not care about any laws.
Okay. Well, Ms. Johnson, again, I appreciate your patience. We had, as you've seen, since you've been online, lots of cases to deal with. This one was no less important than others. We typically try to get folks who are here on bond out and then keep moving on. But you had to wait for a long time, and I apologize for that. Appreciate you sharing your thoughts and the impact this has had, not just on you, but also on your daughter.
Thank you, Your Honor. It's okay about the time. It's okay.
Okay. All right. Well, take care.
You too.
Ms. Harvey, criminal history for Mr. Newton. I've seen the recidivist notice. There's some old burglaries, but I'm curious about total number of cycles and the more recent stuff.
Yes, Your Honor, 19 total cycles. I show the last felony conviction was in 2010 for possession of a firearm by a convicted felon. His last arrest was in 2021 out of Fulton County for a failure to appear. There's also a 2014 conviction for battery family violence, and nothing further.
Thank you. Ms. Wood.
Thank you, Judge. Mr. Newton is 56 years old. He is a lifelong resident of Atlanta. He lives here with his wife, who is not who you just heard from.
Is not what?
Is not who you just heard from. It's a good
Okay.
day.
I didn't think that was his,
Okay.
but I didn't know there was a wife. Okay.
He also helps take care of his elderly mother, Ethel, who also lives here in Atlanta, or in East Point, actually. He is a high school graduate. And Your Honor, part of the reason that he's here accepting responsibility and hoping to move forward is that he's actually fighting cancer, and he doesn't feel like he's getting the proper treatment while he's incarcerated at Ray Street. And so, he also wanted me to make sure the court knows that he did not receive, or he was not served properly about the TPO until he was incarcerated. So just putting that out there. He hasn't had any convictions in over a decade. We're asking the court to consider a sentence of 10 years probation served was done at 180 days. Judge, so we'd ask for credit for that. And then he understands no contact, stay away, and all of the conditions that Ms. Smith requested, we're fine with.
Got it. Okay. Thank you. Mr. Newton, I'm sorry to hear about the diagnosis. Is your concern that you're getting no treatment while in custody, or just not the level of treatment you could get if you were
I've
out?
had 2 hospital appointments. Haven't made neither one of them.
Okay.
It's time. It's the longer it gets, the worse it gets.
Okay. All right. And when you are eventually released from custody, but you'll be on probation, tell me where it is you plan on living.
With my mother.
Okay. And what county is that in?
That's Fulton, but she stays in East Point.
Okay.
I have a son that lives in Virginia, so I can leave the state if.
I'm not saying anyone needs to leave the state, and that actually is a little complicated while you're on probation. It's not at all impossible.
Right.
It might, in the end, be a better outcome for you as well as Ms. Johnson. But upon your release, you actually need to be in Georgia until you transfer your supervision to another state. I'm not going to require that. I was going to see if we could just keep you out of Fulton County, since we know Ms. Johnson's in Fulton County, but you have family in Fulton, and that's actually going to be a stable home for you. I'm a little curious. I'm not prying, I think, in an inappropriate way, but there was mention made of a wife. Is that not someone you can stay with, or the nature of that relationship now is?
She lives in Atlanta as well, so.
Okay, got it.
I basically wanted to stay with my mom because she's like elderly and she's getting dementia, and who's right there now is my nephew. He's like 19, he's not responsible, so she's not missing her doctor appointments. And
okay, all right. Do you have anything you want to add to your situation?
yes, take consideration the health issue, because I missed 2 appointments, and they've been scheduled by the medical department, but I guess the department has been short, so I can make the appointments.
So you would have an appointment at Grady and then
I have an upcoming one now, but I don't know if I'm gonna make it. It'll be the third one.
Okay, but just so I'm understanding, there'd be hypothetically an appointment at Grady on May 15th. And you'd give that information to folks at the jail and then you would not get
No,
transported?
actually, the doctor at the jail makes the appointments.
Okay, doctor at the jail says, I'm checking out Mr. Newton. He needs to go to Grady on this date.
Right.
And for whatever reason, you're not transported on that date.
Right, twice.
Twice. Okay. The second time that happened, did the doctor not raise the alarm?
He did. My family also reached out to the head provider at the jail, and they said they would reschedule again, but there's no guarantee that I still make it.
Okay. All right. Well, sorry, that's how it's playing out. So, Mr. Newton, I find there's a factual basis for your plea. Not quite sure what was going on, but it sounds like I'm less concerned about whether you knew about the TPO.
I did not. I got served those papers while I was incarcerated.
I heard what Ms. Wood said, but you don't need to be served papers after what happened in November to know that December is a bad idea. And frankly, what happened in November is a bad idea. You don't need papers to know that you can't treat someone like that it's going to be terrifying for that person. And Ms. Johnson made it pretty clear that while the police got involved in that one, it wasn't the first time something like that had happened. We need to make sure that doesn't happen again, at least not with Ms. Johnson, ideally not with anyone in your life.
Yes,
So I find there's a factual basis for both your pleas. These are incidents that were barely 2 weeks apart, a situation that clearly was and understandably was upsetting for Ms. Johnson. I also find that your pleas are. You good?
Yes.
I will pause. That your pleas are knowing and voluntary, meaning you've understood what we talked about, and no one's forcing you to enter these pleas. Tell me what kind of work you've done, say, over the last 5 years.
Security Operations Center.
Tell me what that means.
HD Supply Corporate Security in the Security Operations Center. It's basically like a 911 center. Take all calls and monitor all the locations.
Okay. You receive the calls or you get dispatched?
Receive. I work inside like a 911 center.
And you are letting people know, hey, there's an issue.
If alarm company calls the alarm, I check the cameras, make sure there's no one inside the facility. Also do incident reports for any incidents that happen at any location.
Okay. Got it. Accepting the two pleas, here is how I am going to handle them. In 26 SC 000309, that is the November incident. I'm going to sentence you on count 1 to 2 years to serve. Count 2 has to be 5 years, has to run consecutive. That will be 5 years probated. Count 3 is, I'll make sure I'm structuring this the right way. Yes, so count 3 is 12 months to serve. Count 4 is 12 months to serve. And count 5 is 2 years to serve. All those run concurrently with each other, except count 2. Count 2 has to run consecutive, and that'll be consecutive to count 1. So it's a sentence of 7 to serve 2, balance probated. You'll get credit for all the time that you have been in custody in connection with these two cases. Special condition of probation number 1, obviously, no contact with Ms. Johnson. That's no direct contact. If for some reason you two have shared connections, don't use a third party to contact Ms. Johnson. The stay away is a little complicated. I don't want to be putting Ms. Johnson's address in the final dispositions. And it's not like Mr. Newton will have an ankle monitor on. So I'm going to define the no contact as no direct contact, but that also means to not be within 500 feet of Ms. Johnson. You're not violating your probation. If you walk down the street and Ms. Johnson happens to be there, you just need to turn around. But I'm not listing a location that you have to stay away from because I want to respect Ms. Johnson's privacy. a gun was seized from you, you're forfeiting that gun, and you will need to complete what's known as a family violence intervention program. You'll need to do that within the first 6 months of your probation. In 26 SC 000040, count 1 is 2 years to serve. Count 2 is 12 months to serve, and count 3's been dismissed. So it's a total of 2 years to serve for that second case. That case will run concurrently with, at the same time with the case ending in 309. I didn't hear you say anything about restitution. It sounds like there was a broken window. We're leaving that alone. Okay, all right. So there's no probation in the second case. It's purely custodial time, but the same duration as the custodial time in the first case. That full half year you've already served is credit in both those sets of sentences. And we'll go forward from there. Ms. Smith, I didn't ask. Do I have your authorization, Ms. Wood, to sign your name and Mr. Newton's name to the 2 indictments?
Yes, sir.
And Ms. Smith, can someone in my office sign for you?
Yes, sir.
All right, having cleared that up, last thing, other than do you have anything else? You filed a recidivist notice in each case. Are you withdrawing that for purposes of this sentence?
They will be withdrawn under A but not C.
Tell me what you think that means.
That means you will have to serve the entirety of the 2 years
Okay,
under C.
all right. I'm gonna modify my sentence then. I forgot to ask about the recidivist piece before I sentenced. That was my mistake. So that removes the question of parole from the situation. And so for all of those 2 years to serve, I'm gonna make that 1 year and 6 months to serve. Because then we're closer to where I thought this case would shake out with parole being involved. So we're clear. In the case ending in 040, the sentence for count 1 is 1 year and 6 months. Sentence for count 2 is 12 months. Those will run concurrently with each other and concurrent with the case ending in 309. The sentence for count 1 would be 2 years to serve 1.5 years, balance probated. Count 2 is 5 years probation consecutive. And then the misdemeanors are all 12 months to serve that will run concurrently with the count 1. And it is a C recidivist.
Yes.
All right. Anything else, Ms. Wood?
No, Judge, thank you.
All right, Mr. Newton, I trust you are going to get better care where you are going and even better care when you get out.
Thank you, Judge.
You're welcome.
Okay.
Can we do, what? I don't know which attorney she's getting.
Just the backup?
Okay, great. We'll talk about that, and then we could do the bond hearing, although I don't know where the lawyer for Mr. Washington went. Hey, Ms. Tembecca. So Ms. Smith told me that we're not sorting the case out today, but I do want to bring Mr. Thomas out, and we just need to figure out the logistics of the Jackson Deno hearing. Before he comes out, I just want to run by a scenario, and if it works for you, I'll tell him this is what we're going to do. Was his statement recorded?
Yes, Judge.
Okay. Often, but not always, what I do is get the lawyers, they agree to stipulate that there's a foundation for the recording, and then they ask me to review it. I understand what the requirements of Jackson Deno are, and I look at it to see, was he Mirandized? Was it a knowing waiver? Were there promises or threats? That kind of thing. I don't mean to take away from you the ability to advocate. And if you think it's important to have a hearing so that the detective can come in and say, all that stuff that's recorded, that's what happened. We can 100% do that. But I'm also fine doing it the way I described, where then I review it and then I'll enter an order saying, hey, there were these issues or there were not issues. And that way people know the statement is coming in with the caveat. There may still be things in the statement, if it's constitutionally admissible, that still need to not happen at trial. Your client is young, so it's less likely, but what often happens is the detective will say, well, what about that other shooting? Well, that doesn't come in at this trial. That would be a different case that the detective is investigating with the suspect. But that's different from whether the individual was administered his rights and he knowingly waived those rights. So tell me how you'd like to manage the hearing process.
Well, Judge, I mean, really, I would generally prefer a hearing, but in light of the court's, movement coming in July, and because I do believe we're close, to resolution, I think, for judicial economy, I'm happy to go ahead and stipulate to a combination.
Okay.
Allow the court to ask the court to go ahead and review in camera.
Okay. You've reviewed it. Are there particular things that you want me to be attuned to, or just watch the flow to see, did he read him his rights? And did Mr. Thomas say yes, or did he say, I'm not sure, it was equivocal, or just absorb it and let you know what I think?
Yes, Judge, I'm confident that, I actually would hate to limit the court. I think the court, has a good grasp on all these matters, and that whatever the court identifies, will be the issues.
Okay. Ms. Smith, are you able to get the recording to me at some point? Great. Perfect. Then let's bring Mr. Thomas out. I just propose to tell him you are still working hard on the case. I'll handle the motion that you filed, and then we'll bring him back whenever there is a reason to bring him back. Is that about right? Okay. He can just be at the door. Hey, Mr. Thomas. How you doing? I'm all right. I just want to give you an update from my side, as in the judge. I don't have a side on this, but I have been speaking with your lawyer a great deal, as well as with the prosecutor. And we've got a couple things going on. Ms. Tembeka filed a motion on your behalf that challenges the admissibility of the statement you gave to law enforcement. So I'm going to review that statement, and I'll enter an order that lets everyone know if there is a trial is coming in or it's not coming in. And I'll explain why. So I'll review the statement, get that order out soon. And then in the meantime, Ms. Tembeka continues to negotiate with Ms. Smith to see if there is some proposal from the state that works from your perspective. You are the remaining defendant. There have been 2 pleas, I think 1 dismissal. One of the females had the case dismissed. Other female pled today. Mr. Cotton pled last trial calendar. So you're technically on a trial calendar because Ms. Tembeka has come in much later than all the other lawyers. She is entitled to that extra time to get up to speed. Oh, and there's one more moving part. There are police reports, or a police report from Roswell, that neither side has yet. I think all the reports were from Sandy Springs. Opposite. Okay. All the Roswell reports we have, and there's a Sandy Springs report that you're entitled to. It may not have anything particularly interesting, but that's not the test. It's that it's part of the case. So Ms. Smith is getting that available to Ms. Tembeka so she can read it. If it's important for you to see it, she'll make sure you can see it. But until she has that piece and my ruling on whether your statement to the police will come in, she's not quite at the position to say to you either it's not going to get any better because I don't have any more leverage, or to be able to press the prosecutor saying, look, his statement's not coming in and we've all read that Sandy Springs report and it's not helpful to the state. And then we'll see if we can sort it out. If not, I'll just move your case to the next trial calendar. By then, Ms. Tembeka is out of can I have more time requests. She'll be ready to go. And if the answer is you want a trial, because you've got an absolute right to trial. If you think that's the best way forward, then it'll be ready for trial. Okay? Any questions for me, not about the facts of your case, but just sort of where we are and what's going on? No? Okay. You're in good hands with Ms. Tembeka. I'll get that order soon and she'll get that discovery soon. We're good? Thanks.
Judge, after a brief conversation with them, am I free to go?
Yes, ma'am.
Thank you, Judge.
Ms. Rios, Mr. Reynolds is that plea you've been ready for since, okay. I'm just seeing what's left here.
Right, I remember you were like, oh, you said you're free next. And I was like, really? I'm not gonna stay here all day? And then, here I am.
Well, at least, Ms. Simpson's kept you snack fed.
Yeah, I mean, lots of candy.
So I know we've got Varner. Is that it? Oh, and Reynolds. We've got Varner and Reynolds. Yeah, but, oh, there we go. Yeah, we'll do the Washington bond hearing, so you can take a break. And then when we come back, we'll probably do Reynolds before Varner, only because Ms. Rios is getting rusty.
You just want me and client?
You tell me if you would prefer to sit or stand.
I'm good to
If
stand.
standing is good, then please at the podium.
Standing is great.
One second. Okay. We're going to get on the record in the bond hearing we have from our bond hearing calendar. It's 26 PI 0030466, State versus Mason, Washington. Mr. Washington, we had your brother mistakenly brought over this morning. That's why this has taken so long. But I'm Judge McBurney, and your case is assigned to me only for bond purposes. So as long as it remains unindicted and there are questions about bond, Ms. Gibson's your lawyer, I'm the judge, and Mr. Abate is the prosecutor. If you are indicted for these charges, that'll get assigned to a judge. It will not be me, and that judge will take bond issues and everything else from that point onward. But as long as your case is unindicted, then we'll be talking here in courtroom 8D about bond and release and things like that. What we're going to do this afternoon is I will hear from Ms. Gibson in just a little bit about you and about this case. And she's going to give me her perspective as to what bond is appropriate, dollar amount, conditions, et cetera. And then I'm going to hear from the prosecutor, Mr. Body, about the state's perspective. They typically oppose bond, so don't be surprised if he says bond's not appropriate. He'll probably tell me a little bit about the case as well. And then there may be members of Mr. Tucker's family. He is the deceased in this case, who I hear from. They're entitled to be heard at any phase in the proceedings, whether it's a bond hearing, pre-indictment, all the way, unsurprisingly, to sentencing. If someone pleads guilty or is found guilty of the murder of Mr. Tucker, we hear from family members then, as you might expect, but they may want to say something now. That's up to them. Okay, that's the plan. And then I'll let you know what I'm going to do. I'll say, yes, I'm setting a bond, or based on what I heard, I don't think bond is appropriate. We'll keep moving the case forward. Ms. Gibson.
Yes, Judge. Mr. Washington, Mr. Mason Washington, is 21 years old. He is from Riverdale. He grew up in Roswell, Alpharetta. He graduated from Milton High School in 2023. This is his second lifetime arrest. I believe his first was about a year ago, misdemeanor related, as far as I know. He has worked as a mechanic for luxury car dealerships since his graduation in 2023. He's been at Mazda, Classic Cadillac, and is now, was about to go to Hennessy Land Rover Jaguar. His family all still lives here. They were here earlier today and they weren't able to hang around all day. But his uncle, his mother, I believe some aunts were all present and ready to support Mason. Judge, this case is really unfortunate in the end result. It really boils down to Mr. Mason Washington being in a very wrong situation and feeling the need to defend his brother, and I think likewise brother defending him. He had been threatened by the victim for quite some time leading up to this date. And then on this date, there were some threats that continued. I do believe that with a high school graduation, a good work history since graduation, he's young, not a significant arrest history, that he is a good candidate for bond, and his entire family's here. So he has no reason to abscond. I think he wants to answer for this charge and show that he is not guilty of what he is charged with. I would ask for a bond in total not to exceed $50,000. I think that Mr. Washington is okay with an ankle monitor if the court would impose that. Obviously, no contact with co-defendant would be hard because that is his brother.
His brother right now is in custody, so it would be easy unless and until Derek Washington got a bond.
Correct. So I would ask that if both were to be released, that not be a condition, but obviously no contact with the Tucker family. Stay away from that apartment location. I think he can go live in Riverdale with his family. That was where Mason lived, but obviously not a great place to go back to at this point in time.
Meaning he lived in the apartment complex where the shooting happened?
He did.
Got it. And did he, when you are saying it's not realistic to have a no contact with Derek Washington, did they live together?
They did.
Okay.
So they were in that apartment complex together, and I believe if they were to be out, they would both live with family together. That's just my presumption.
Okay.
But I do not think that Mr. Mason Washington poses a flight risk at all. I do think that if released on bond, he would be in front of the court anytime he was summoned, and that he's been a law-abiding citizen, I would argue, even up until today, Judge. And I don't think he poses any threat to the Tucker family either. So I would ask for a bond to be set in this matter.
All right. Thank you. Quick question for you, Mr. Washington. I'm going to hear a little bit about criminal history, and then I'll hear from Mr. Abate. Who is older, you or your brother Derek?
My brother,
And how much older?
5 years.
So you're 21 and he's 26?
Yes, Your Honor.
Got it. All right. Ms. Harvey, criminal history for Mason Washington, if any.
Yes, Your Honor. He has one prior arrest from September 1st, 2025 out of Forsyth County for possession of marijuana less than an ounce, possession of a Schedule I controlled substance, and possession and use of drug-related objects. The felony possession of a Schedule I controlled substance, I'm sure, was dismissed. The 2 misdemeanor offenses were transferred to state court on February the 20th, and nothing further to add, Your Honor.
Okay, thank you. Mr. Abadi.
Thank you, Judge. The state would respectfully request you deny defense counsel's motion for bond for several reasons. The first being that this defendant poses a significant danger to the community and the people in it based on the facts and circumstances of this case. There's really no other way to put it other than the fact that this defendant and his brother executed Justin Tucker. There are several eyewitnesses, but one in particular who was an unbiased witness who didn't know any of the parties. He was an Uber driver who witnessed Justin Tucker cower behind a car with his hands up, begging for his life, saying, "Please don't shoot me." And then this defendant along with his brother, shot him over at least 5 or 6 times. 2 of them had stippling, and the Uber driver actually saw this defendant go up to Mr. Tucker after they opened fire on him and made sure that he was dead and shot him one extra time in the head. His injuries were severe. He was shot in places that caused his neck to actually break, in addition to the gunshot wounds. I'd also submit to the court that the defendant is at risk of committing felonies pending trial. As you heard about his criminal history, it's only 1 arrest and it is for minor offenses, but he is on bond for those offenses when he committed this one, Your Honor. Furthermore, I would submit to the court that he's at risk of intimidating witnesses, as there are several witnesses who witnessed the shooting, the execution, followed by doing photo lineups where they identified this defendant specifically, and he's a threat to intimidating them because of his access if released. He or his brother, one of the 2, worked with the maintenance department at the apartment complex. And what I can tell the court is there were no threats that were made by the victim. The victim made reports to the apartment complex managers or management office because this defendant and his brother had been accessing Mr. Tucker's apartment, taking things from his apartment without authority based on their access to the keys, being a member of the maintenance team. So the threats were really complaints that his stuff was being taken by both of these defendants. Furthermore, I would submit to the court that he's also a risk of flight. I understand that he is local with his family and things of that nature. But what I can say to the court is that the Sandy Springs Police Department gathered a significant amount of evidence, overwhelming, making this defendant a flight risk if released to return to court, Your Honor. There is one family member who would like to make a statement, but the victim's father and sister are also present, but his mother, Mrs. Ding, would like to address the court when appropriate.
Okay. Danielle Dixon. I'm not trying to administer a quiz. I just had been looking at the affidavit for arrest, and there was some Ring camera footage that supposedly showed one of the Washingtons trying to get into her apartment. Is that also Mr. Tucker's apartment, or that's just an example of one of the Washingtons trying to get into an apartment with which they're not associated?
That would be an example of that. This Mr. Washington, that's before you, Mr. Mason Washington, he was actually positively identified as the person who was trying to get in to the apartment of Ms. Dixon on the Ring camera. That footage was taken directly after the shooting, where this defendant then walked in towards a building and tried to get into that apartment. I would say to, abscond or be out of the view of anyone, but Ms. Dixon had no idea who this defendant was and refused.
Oh, so this was post-shooting?
Post-shooting, yes.
Okay, understood. Okay, all right. And do you know yet if there were shell casings from multiple guns recovered.
I'm glad you bring that up. Yes, Your Honor, there was shell casings from two different types of guns. And what I can say is after the police responded to the apartment complex in Sandy Springs, what they were able to do is they did a search warrant for the home that this defendant and his brother were living in, and they found 3 weapons, 2 of which after being test fired had preliminarily been identified as the 2 weapons used to shoot Mr. Tucker through Nibin. Both of those weapons, as well as all of the shell casings, have been sent to the GBI for confirmation.
Okay, so we have preliminary something, but more importantly, that there 2 different types of guns were used to fire whoever was firing.
Yes, sir.
Based on the shell casings.
Yes, sir.
Okay, thank you for that information. Now would be the right time for someone or some people from Mr. Tucker's family to come up and sit where you were sitting. Good afternoon.
Good afternoon. My name is Santina Dean, and I'm the mother of Justin Tucker.
Can you spell your last name?
Dieng.
Dieng. Great. And thank you for being here. You were Mr. Tucker's mom.
Yes, I am.
Okay.
I just think it was a coward act. My son asked him to fight, and he agreed to fight my son. And then him and his brother murdered my son. I told my son, he had told me about the incident of them breaking into his apartment. And I told him to handle it like a man. And I told him that I would rather him be here, that they could handle it with a fight and to, you know what I'm saying, let it go. And he agreed to fight my son. And then he called his brother, and him and his brother murdered my child. And I just think it's a coward act that you would agree to fight somebody and then turn around and murder them. And it all wouldn't have happened if they wouldn't have never broke into his apartment. They used the key from the apartments that he was working at to go in my son's apartment and steal out of his apartment twice. We made reports to the apartment complex and they did nothing about it and let him continue to work there as he went in other people's apartment and stole. And then because he went in my son's apartment and stole and my son confronted him about it, they murdered him.
So the confrontation was sometime before the date your son was, because it sounds like you knew maybe they were going to fight it out just to resolve.
I told my son, he said that he was claiming that he was going to murder him and this and that. And I said, Justin, it's not worth it. I told him, I would rather you fight it out and be here than all of this gun stuff. I said, it's not worth you know what I'm saying, losing your life over. I said, I would rather y'all fight it out. And that's exactly what he told him. And he agreed to fight him and then murdered him.
Okay. Anything else?
No, I just miss my son.
I bet you do. How long has it been?
Yes, it's just been 2 months.
Yeah.
Just 2 months. And I can't even believe that, you know what I'm saying, he's here trying to get out and I don't even have my son anymore. I mean, I would like him to stay incarcerated. I would not like him to be on the streets where he can do this to someone else's child. That's all I have to say.
Okay, I understand that. I appreciate you being here to share that. Thank you.
And just for the court's edification, this case is scheduled to be indicted next week, Your Honor.
Okay. So, Mr. Washington, in a moment, I'm going to hear from your lawyer. She's the movement, so she gets the last word. I want you to understand that I very much appreciate Ms. Ding's feelings and her sentiments, but I also appreciate that you're presumed innocent. People may have decided in their minds exactly what went down, but in this court and any other court, the state has the burden of proving your guilt beyond a reasonable doubt. So if I end up not granting bond, it's not because I've decided this or that. It's helpful to understand some of the alleged facts and circumstances around this. And that's what I have heard from your lawyer, what I heard from Mr. Abadi, and I heard some from Ms. Ding as well. I heard her say that her son said, I'm gonna murder the guy. Well, that complicates the situation. Maybe he said that to you as well. And then you've got a different thought about, well, what does a fight mean? Those kinds of things are going to get worked out in front of a jury and a judge at a later time. I'm not making decisions about who did what. That's not the role here. It's a decision about what most of all will ensure you show up in court. And right behind that is what will ensure that something like this doesn't happen again between now and the time you sort your case out. Those are the two primary things that I'm tasked with worrying about. Ms. Gibson.
Yes, Judge, I would just like to comment on what the state brought up about Sandy Springs having all this evidence that my client is a flight risk. I've not been presented any of that evidence. I don't know what that is or could possibly be, in that he's 21 years old and has only ever lived in and around the Atlanta area. I also would like to note that it was Derek Washington who Mr. Tucker had agreed to fight with, not Mason Washington. But the things that were said by Mr. Tucker were said to both Washington brothers. Again, his lack of criminal history, I would ask for the court to set a bond.
Okay. I appreciate you providing those clarifications. I didn't hear Mr. Abadi saying that Sandy Springs had developed a lot of information about flight risk, so much as it seemed to him to be a pretty compelling case evidentiarily about what these allegations are. So I'm not thinking that there have been strong demonstrations one way or the other. I'll note, I need to consider this, the charges are serious. That's a reason to worry about whether Mr. Washington would stick around. But he's got family here, his ties are here. He's only ever been here, meaning Metro Atlanta, whether it's Riverdale or Sandy Springs. Mr. Washington, at this point, I am not going to set a bond. That doesn't mean forever I wouldn't set a bond. If the state goes ahead and indicts next week, then it's going to be a different judge who'd be talking with your lawyer about this anyway. But based on what I've heard, I'm not comfortable that there's a set of conditions I could impose that would keep you safe and would keep people in Mr. Tucker's situation in the future safe. I'm a little less concerned about risk of flight because you seem like you've got all your connections here. But in the same vein, you're young with no kids and a lot to lose with the life sentence if you are found guilty, And so that's an incentive to say, well, I'm happy to be a 21-year-old in Thailand rather than in the United States. And I need to factor that in as well. This is an incentive to not be local. And it's important that this case be resolved on the merits and not, well, we're spending all our time trying to find folks. So for now, it's a no bond case, but Ms. Gibson has worked with me before. And if for some reason the state doesn't indict and time passes, she knows to come back and say, hey, it's been another 60 days. My client sits in jail without an indictment with the presumption of innocence. And so we need to talk about this again, and we will talk about it again. If it isn't indicted next week, like I said, then there's a judge who is assigned to the case who can say, no, we're moving it forward. Your lawyer, and it may not be Ms. Gibson, it often transitions after indictment. There'll be a lawyer who will get all the discovery, and that person can start talking to you about the case and give you a sense of, ooh, we better figure out how to work this one out versus this is an amazing self-defense case, but we need to get you out so you can go help find witnesses or whatever the situation is. So there's another chapter to this conversation. This chapter is ending with me deciding that bond is not appropriate at this time. Okay? Ms. Gibson, I appreciate your patience and toing and froing. I hope your investigator's okay. He slipped and almost knocked his brains out in the back row there, but I appreciate your work. And to Mr. Tucker's family, I know it's been a long day for what is one of the least happy situations you ever had to deal with. Things will pick up once the case is indicted, and then a prosecutor can give you a sense. All judges move at different paces. My hope for you is that it goes to a courtroom where things go like that. If it's not, hopefully that lawyer will be candid with you that it's going to be a hurry up and wait situation. You're entitled to know that. But I hope that you continue to move forward as a family, working through your loss, regardless of what, I mean, your son is dead. And that doesn't change whatever happens with, Mason Washington or Derek Washington. So thank you for being here. Okay. Any questions?
No, Your Honor.
No. Okay. You go with the sergeant.
Thank you so much, Judge. May I be excused?
Yes, ma'am. When do you take your break?
July 10th should be my last day.
All right. Assuming there's no exciting news before then.
Right.
All right. Well, good luck with everything.
Thank you.
Yes, sir. Thanks for your time. So, wait, before you, hold on, before you two run out. Hey, wait, Adam. So there's nothing left on the trial calendar, pretty much, unless I make Melnick try this. I will not bring in Charles, but is something gonna happen with that, or?
I didn't speak to family.
Okay.
I think you heard the facts.
Yeah, no, and the age of the case, et cetera. You're new to it, so, yeah. Okay,
Yeah, I have a very good feeling that we can all get that bottom.
okay, so maybe I'll just say people should be here Monday.
I think Mr. would like that.
Okay.
So he isn't good enough.
All right.
Judge Warren.
Sounds good.
Thank you.
You bet. Yes, you can go. Ms. Charles would be the only thing that's left of your cases, because we're not doing Auburn Johnson. And I can try and remember, that's one where you said ready if reached, but we've also talked about your unit situation. Let me just find her case number 20. That's Ms. Wood, so we can talk about it. Is that one we should just roll over one calendar?
I don't have an objection, Judge.
All right, and I was also gonna say that we should look at the operating and continue to discuss maybe something that we can resolve.
Does it help by listing it for Monday or not? In terms of you looking at the offer again?
And Judge, to be fair, I sent, I'm sure you haven't had a chance to look at it. Miss Charles had sent me a lot of documents from like school records from Florida. There was like a separate police report, and I had sent some of it to Miss McGillicuddy, but then I resent it to Miss Williams recently just so that it was, make sure she had it.
Yep.
And also like full videos, so I understand if you haven't had a chance to go through everything.
What if we put both of the Charles cases on for Monday to have a conversation on Monday? And I won't order up jurors, but I just want to keep us poking at it a little bit. Last gasp, if nothing happens, then it goes to another judge. But if there's a way to get closure on it, super. If not, we'll just press on. Does that work? Okay, because I know you are managing like 18 other courtrooms over the next couple of weeks.
Yes, we'll have 3 lawyers, so we'll have 5 courtrooms each.
All right. So that's not 20. You're fine.
No, it's not. Could be worse.
It could be better. All right. Well, I think that'll be the plan. Assuming the Reynolds plea and the Varner pleas go forward.
Thank you, Judge.
You're welcome. It's 4. You guys should head out. Did he already bust out of here? Captain Short Time. Well, okay. You're welcome to stay. We have 2 more pleas. Mr. Reynolds is armed robbery. Is he pleading to armed robbery?
Yes, he's doing a downward deviation.
Okay, so we got a guy pleading to an armed robbery, and then what's Mr. Varner?
Shoplifting.
Shoplifting. Let's see if shoplifting. Although he's got 2 cases. Is his new case shoplifting also?
Receiving stolen property.
Okay. Yeah. Those often go hand in hand. Is it tomorrow? You should come here, but then I'm gonna have you guys go to Judge Krause's courtroom. She's doing drug court, so you can see drug court. You can watch it for a little bit. If it ends up not being interesting, you can come back here. We're doing some of the same, but it's virtual. I'll be here, and sometimes the lawyers show up, but the defendants are all gonna be at the jail. So everyone is in custody, and they're in these little booths at the jail, and we handle whatever's going on with their cases. So you saw that in another courtroom, so you've seen it. That'll just be more of those. But the drug court will be something new and different. And so I'll take you down there or get someone to take you down there. But that'll be a big chunk of tomorrow morning. Okay? All right. How was lunch at the Sloppy Floyd?
It was good.
Yeah, ours was better.
I was actually,
We had Thai food. They're now up Mitchell Street. Have you guys seen Mitchell Street now?
No.
Brand new pizza place. It's open. Glide Pizza. Mexican place, Tesoro, also open. The Thai place has always been there. I mean, it's 3 years or so now. And there's a donut shop. Yes. Dough in the box. And then there was one, it had sushi. I don't know what else was in it. It was called Bottle Rocket. These are all thanks to World Cup and the redevelopment that's been down there. So, yeah. Well, we didn't go in that one. The majority vote was for the Thai food. Remember, you have stuff in the fridge.
oh, yes, thank you.
You're welcome. Okay. See you around. You are Mr. Reynolds. Let me get your case here. Ms. Allen, are you good? I forgot to ask if you need a break.
Yes, Your Honor, I'm okay. Thank you.
Okay. We got 2 more pleas and then we'll be done. Oh, should we try one of Mr. Godfrey's cases next week?
Yeah.
Wow. You can see Miss Smith's face. Wow. It's like, seriously? Seriously? Yeah. Oh, Lordy. It's all right. I'll learn how to do family law next week. So we're gonna go on the record with position 30. It is indictment 24 SC 002-029, State versus Reynolds. Mr. Reynolds is here with his lawyer, Ms. Rios. And Mr. Reynolds, Ms. Rios tells me you are ready to enter a plea. Is that right?
Yes, sir.
Okay. Ms. Smith has put you under oath in just a moment. Ask you a bunch of questions about your case and your rights. You need to answer all those truthfully. If at any point during the conversation that we're all having, you've got questions, you need to let me or your lawyer know. Will you do that?
Yes, sir.
Okay. Ms. Smith, it's position 30.
1 second, please.
Okay. So that.
I trying to have an emergency TRO status of this,
Is it the Moors?
yes.
Have them come inside.
Mr. Oh,
Wait.
No, they can come. It will just take 2 seconds, but Ms. Niles already told them what the deal is, so they can just come in the door. This is not going to be a surprise to them.
Mr. Reynolds, please raise your right
Hold
hand.
on 1 sec.
Oh.
Sorry, I got to tell these people what's going on.
Okay. I've seen that show.
Hey, are you the Moors?
Yes, sir.
Hey, I'm Judge McBurney. Nice to meet you. You have already had not 1, but 2 lawsuits concerning this property that Judge Edwards handled. You remember Judge Edwards? She's my next door neighbor.
Nobody handled it because they remanded to federal, and it's been sitting there for 8 months waiting on remand to come back here because federal has no jurisdiction. Meanwhile, this bank that is.
So you guys stop talking about your case. We don't have the other side here. And I'm not trying to misrepresent anything. I'm gonna pull up your case. So it was removed to another court and then it came back and the judge, she administratively closed it due to removal. Be that as it may, twice you brought suit. Maybe it was removed, maybe it wasn't, But Judge Edwards, my neighbor, had those. So this case needs to go to Judge Edwards as well. Because we try to,
Individuals, said, this is not the quiet title. This is
Okay.
a whole new case.
but it's what's not whole new is Bertram Moore and Tanette Moore versus Nurez and PH Moore. I'm reading from the old case. So we have one judge per set of litigants. And so I'm gonna make this up. Let's say PAH Mortgage decided, we're gonna sue the Moores. It's about the same piece of property, it's the same dispute. That will go to Judge Edwards. You didn't know that. You filed your lawsuit. It was randomly assigned to me. And then Judge Benton is presiding because this is urgent. You guys went to very much the right place, Judge Benton. She's supposed to check with the judge to whom the case has been assigned to make sure, hey, McBurney, are you okay if I handle this emergency hearing? I would have said, of course, Judge Benton. But then we noticed, wait, there have been 2 other lawsuits about this piece of property with you all trying to get stuff sorted out. That's Judge Edwards right next door. So she's the one, I've already signed an order transferring your new case to her. So she's the one who needs to tell Judge Benton, yes, you can go forward with the emergency hearing. I know this is making your head spin. You're like, gosh dang, you're making us go everywhere and everywhere. But Judge Edwards, who is a colleague of mine, all the same authority, she had your other 2 cases, so she gets this case as well. No, because then there was the removal and a bunch of stuff and then administrative closure. Let me pull up the other one. That one she dismissed because you allegedly, I'm not saying it happened, you didn't serve certain parties. Okay, so you're a veteran now, and it's just going to be Judge Edwards again. So Deputy Gordon can show you, but is literally right next door. I don't know if she's in court right now, but if not, you can buzz the buzzer for Edwards because it lists all the judges. Don't press McBurney, press Edwards. And then if she's got staff in, they'll say, can I help you? You can explain, we've got this TRO, it's been assigned to you. And if they look it up, it may still say McBurney in the system, but they'll see, oh, we handled the other Moore cases, so they'll know it's coming. And then they can engage with Judge Benton because you just want your hearing in front of Judge Benton. But that has to be approved by the judge to whom the case is assigned. Nope. Judge Edwards is going to have to do it because I've sent your case to her because that's where it's supposed to be. All right? Good luck. So you got a crash course in how cases are assigned in Fulton County. Now we're going to handle your case. Ms. Smith is ready to put you under oath. She got bonus time to prepare.
Mr. Reynolds, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Jerron Anthony Reynolds.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
29, and I got my high school diploma, and I did some college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Reynolds, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 2.5 with the balance probated?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, transport, possess, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Reynolds, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 24 SC 002029, how do you plead to count 1, armed robbery, count 2, hijacking a motor vehicle, count 3, aggravated assault, and count 4, possession of a firearm during the commission of a felony?
Guilty under Alfred.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that that process must be completed within 30 days from today?
Yes.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right, thank you, Mr. Reynolds. Your Honor, if this case were to proceed to trial, the facts would show that on May 3rd, 2022, officers of the Atlanta Police Department responded to 2065 Metropolitan Parkway, Atlanta, Georgia, and also in Fulton County. This establishment at this location is a Captain D's fast food restaurant. When the officers got there, they spoke with the victim in this case, Brandy Lynch, who informed the officers that she was in the drive-thru about to purchase some food in her gray Chevrolet vehicle when a Dodge Challenger, black Dodge Challenger, got behind her in that drive-thru line. She saw 2 males get out of the car. One came to the driver's side, other person came to the passenger side. These 2 individuals had on masks, and they both had long guns that she described as AKs. The person that came on the driver's side said, "You already know what it is, get the F out." At that time, Miss Lynch, the victim in this case, got out of the car, and while kind of in shock, she just stood there for a moment. The person that was on the driver's side hopped in the car. The victim was not too sure if the person who was on the passenger side got in the car, but eventually the car that she was in, the person who came on the driver's side sped off in her car, and that black Charger went behind her car to leave the location. She told me the victim in this case said it had to be 3 people because 2 people came to her car, then there was another person who was driving that black Charger. So after they left the scene, this happened around 2, 3 o'clock in the afternoon, so the sun is up. Next to this Captain D's restaurant is a BP convenience store. They gave us surveillance footage in this case, and it's reported that there were 2 phones stolen from the vehicle, so a Galaxy and an iPhone.
Stolen from Ms. Lynch's car.
Correct.
Okay.
So those two phones were stolen, but the iPhone 11 was recovered at that BP location by the garbage can. About a couple of days later, the victim's car was found on I want to say the east side of Atlanta, but it was abandoned. Nobody was in it. That car was recovered. When the officers started their investigation, they were able to, because it was 2, 3 o'clock in the morning, and with the footage of Captain D's, they were able to find the plate for the car. That car came back registered to the defendant in this case.
The black Charger.
The black Charger, yes, came back registered for the defendant in this case. Also, after that, the officers went to Mr. Reynolds' house to have an interview with him, and they asked Mr. Reynolds what his phone number was. So they ran that phone number through T-Mobile, got his records and things like that, and the investigators were able to basically track the location of the phone based on the towers, and it was reported that the defendant was traveling in the same direction as the victim in this case. I failed to mention that prior to getting into the Captain D's line, this black Charger had been following the victim in this case for about an hour. She was on one side of Atlanta and she came to the other side. But she noticed when she got in the drive-through line that, hey, this car has been behind me for a very long time. So that path she took from one side of Atlanta to the other one, Mr. Reynolds' phone was pinged off of those towers. They kind of took the same route. So that was recovered also during the investigation. When the investigator went to speak with Mr. Reynolds, and even during his interview, he informed that sometimes he gives his vehicle out for cash rides. And on the day of the robbery, he had loaned his car out to, at the time, his girlfriend's brother, and that he was in Stone Mountain with his aunt.
Oh, right. There's an alibi notice in the
Correct.
docket.
So he was with his auntie to prepare for his cousin's birthday, I believe. So because of the facts and circumstances in the case, and after talking to the victim, I've explained to her what the potential weaknesses would be if this case would go to trial, depending on the evidence that we already have and evidence that we don't have. So because of that, the state is deviating under that mandatory 10 years for armed robbery for us to recommend 2.5 years, with the remainder of those years to be served on probation. But those are the facts and circumstances of the case. I did get a chance to speak with the victim. She is not excited about the offer. The offer was originally higher than the 2.5 years.
She's probably on. There's a Brandy that's on, and there had been some Lynches who were on. So I don't know if the Brandy is, and she doesn't need to say anything if she doesn't want to, but I just wanted to make sure we acknowledge that she's plugged in.
Yep, I was about to let you know that she is on the Zoom, but she submitted a victim impact statement for us to give to the court today.
Okay.
I will read that. Miss Shirley was here to read it, but I think she is in another courtroom, but I will read it for the victim. But before that, for the state, we are recommending for count 1 and count 2 will merge in this case for
I don't think hijacking merges. I think it has language in the statute that says it doesn't merge. But I'll look while you keep doing what you're doing.
Do you want me to continue with the recommendation?
I do. I'm listening.
So for count 1, the state is asking for the defendant to serve 2 years and 6 months. We're asking for 10 years for the defendant to serve 2.5 years, for the rest to be served on probation. And for count 3, 2 years and 6 months of probation, and count 4, 5 years of probation to run consecutive. And that gets us to our 10 years to serve 2 years and 6 months. Regarding the special conditions of probation, the state is asking for the defendant to be banned from Fulton County, for there to be no contact with the victim, for the defendant to stay away from the incident location, which is that Captain D's location I mentioned earlier.
But that's in Fulton. So if he's staying out of Fulton County, we don't need to.
That is correct.
Okay.
For the defendant to complete an anti-theft course, and for the defendant to pay back $7,500 to the victim. I do understand that a restitution hearing may be scheduled in this case. I have talked to the defendant. This case happened back in 2024. So most of the items that were stolen, she either has a receipt for them or she doesn't. So I intend that she told me that she would send a market value price of the items that were stolen from inside of her car. And I'll get that over to Attorney Rios, and we'll be able to move forward with that restitution hearing.
Okay. So I shouldn't impose restitution yet. We may have a hearing on that.
That's correct.
Okay. But you said it was $7,500?
Yes.
Okay, and I've confirmed, OCGA 16-5-44.1 D is in Delta. The offense of hijacking a motor vehicle shall be considered a separate offense and shall not merge with any other offense. So no merger doesn't change the sentence. It just means there'll be a sentence for the overall sentence. There'll be a sentence for each count.
Correct, Judge. I would like to read the victim impact statement.
Before you do that, do you have, I don't have in front of me, there's a statute that you're invoking and it's subparagraph E to get us both to, if I go along with it, to get below the 10-year mandatory minimum.
1 second. Okay. Seventeen, 10, 6.1.
So what? You want to try typing?
I'll look that up if you want to read the,
I got it.
okay.
It is OCGA 17-10-6.1 E.
Okay,
Yes,
thank you.
sir.
Victim impact statement.
Yes.
Judge, we had one more thing about the sentence
Oh,
that I
yes.
just want to make sure it's clarified.
That's correct. So defense and I spoke about it's my understanding that the defendant will receive 2 years of credit for the time that he's already served. So with that remaining 6 months,
How, I guess that's going to be explained to me. I have him with 168 days in Fulton County.
He did, so he just ended up pleading Douglas County in March. And so he's actually been in continuous custody.
Since his arrest in this case?
Since
That's
October
4 years ago.
At October 24, so he
Yes,
did.
yes. I don't know which one comes first, but his, arrest date for the Douglas County starts October 16th of 2024.
Oh, and so he was arrested in Douglas County in the middle of October of 24, and he's been in custody continuously since then. Huh.
I don't know if you remember, Judge, I tried to do a motion to set aside the bench warrant because he missed court because he was in.
Yes.
And then we talked about it and you informed us that he would get credit for that time.
He will. I'm not pushing back on that. The law is very clear that custodial time since this incident would be credited towards that. That's helpful to know because it helps me decide is 2.5, where does that fall if it is like, hey, you're getting out shortly. Some of the 168 days then that I did the math on are included in the time since October of 24, but there's a chunk of time that you'll get additional credit for because you were in custody in Fulton County for a couple months right after your arrest.
Yes, sir.
Then you got out, and then apparently you did something in Douglas County a couple of years later. Okay.
And then.
Oh, well, it's my understanding that the defendant will receive 2 years of credit, so the remaining 6 years. The defense and I talked about the defendant serving that time as weekend jail. So we don't oppose if the court gives the additional 6 months of custodial time for it to be served on weekends.
All right, we'll work through that.
Okay.
Victim impact statement,
Yes, Judge.
please.
From Brandy Lynch, she says that a few years ago, I was carjacked by multiple individuals who were armed with what appeared to be AK-style rifles. During the incident, they took my vehicle, my phones, my purse, and my personal belongings. I feared for my life and genuinely did not know whether I would make it through that encounter safely. What makes this crime even more disturbing is that I later realized the same vehicle involved in the carjacking had been following me before the incident occurred. At the time, I was not aware that I was being targeted. Learning afterwards that I had been watched and followed before the crime took place made me feel even more vulnerable and unsettled. It was not a random encounter. It felt calculated and intentional. The effects of this crime did not end when the incident was over. Even today, I experience fear and anxiety while driving. I constantly check my mirrors and pay attention to vehicles around me because I worry that someone may be following me. Something as routine as driving now causes stress and fear because of what happened to me. This crime took away my sense of safety. Before this happened, I never imagined I would be a victim of an armed carjacking. Now, years later, I still carry the emotional effects with me. I am more cautious, more fearful, and less trusting of my surroundings than I was before. I am also deeply concerned about public safety. The individuals involved were willing to arm themselves with powerful tools, follow a victim, and commit a violent carjacking. These actions show a complete disregard for human life and for the safety of others. The fact that such dangerous weapons were involved makes the crime even more alarming. I respectfully ask the court to consider not only the property that was taken from me, but also the lasting emotional impact this crime has had on my life. I continue to live with fear, anxiety, and trauma caused by this incident. I believe the seriousness of these actions and the danger they pose to the community should be fully considered when determining an appropriate sentence. Thank you for considering my statement, Ms. Lynch.
Well, Ms. Lynch, insofar as you're listening, you're very welcome. It's always important to hear from the victim in a situation like this. It sounds incredibly frightening. And I think you said this was in the middle of the day. This was 2 or 3, not AM, but PM. So a time when it ought to be safe to go to Captain D's and get some fish and chips. And I understand that you carry this fear forward, and I would too. I don't know why you were the subject of their unwanted attention. I'm glad you weren't hurt. I know emotionally this was difficult and has left scars that way, but fortunately, no one fired their guns at anyone. And so you lost property, but not life or limb. But I appreciate you preparing that statement and getting it to Ms. Smith so she could share it with me. Ms. Harvey.
Yes, Your Honor. 2 cycles out of Georgia, 1 cycle out of Louisiana, and 1 out of Massachusetts. He was sentenced out of Douglas County, March 11, 2026, for possession of a firearm or knife during the commission of a felony, 2 counts, purchase, possession, manufacture, distribution, or sale of marijuana, and possession of a Schedule 5 controlled substance. There is an arrest out of Louisiana from April 25th, 2022 for sale, distribution of drugs, and illegal carrying a weapon. There was no disposition listed on that case, Your Honor. And nothing further to add.
All right, thank you. So it's not a lot of arrests, but you've been all over the country, Massachusetts, Louisiana. What's your Massachusetts connection?
That's where I'm from.
You're born in where in Massachusetts?
Boston, Massachusetts.
Okay. And when did you leave Massachusetts?
2021.
Oh, so recently. You really did grow up in Massachusetts. Okay. And then what's the Louisiana connection?
I was just driving from Texas.
Okay. With drugs and guns?
Yes.
Okay. And Georgia is now home?
Yes.
When you get out, are you staying in Georgia or going back to Boston?
Staying in Georgia.
What's in Georgia in terms of family or friends?
My aunt.
Okay. And where's she?
Stone Mountain.
Is that where you'll live when you get out?
Yes, sir.
Okay. Ms. Rios.
Yes, Your Honor. Mr. Reynolds is 29 years old. He's been in the Atlanta area for 5 years. He was living with his aunt, and he also has an uncle here who lives in East Point. He's forklift certified. He previously worked with his aunt in her cleaning business and also did some work with his uncle delivering and installing dishwashers. He did graduate high school and had some college. He has aspirations of working with sheet metal and HVAC systems. He plans on pursuing that when he gets out. I've spoken with his aunt who told me that he was with her planning his cousin's birthday party that day. And he did let me know that he frequently lets people use his car, and then he would leave his cell phone in for tracking because he's not sure if they would make sure that they don't do anything with the car purposely. He had 2 phones. We were trying to get information on the other phone to show there was 2 phones.
That would help.
And so we were working on that. We provided the name of his
girlfriend's little brother to the state to see if we can get more information on him.
Is that who had the car?
Yes.
In your version of events, it was Mr. Reynolds's girlfriend's little brother who was the borrower of the
Yes,
car.
Your Honor.
And the fact that Mr. Reynolds's phone followed Ms. Lynch all over the place that day is for the reason you said, which is, I mean, he wants to make sure he gets his charger back.
Yes, and he frequently lended out his car for money. So we understand that. That's why he's taking it under Alfred, but he's not admitting to the charges. But he knows if we go to trial, the jury could either, believe that, but they're probably not familiar with people doing that type of stuff. People, right. Jury selection will be confused. So it's better, especially with between our negotiations, that he is satisfied with this offer. He's been in for 2 years and he just wants to get out and continue his life. He'll be on probation for a very long time, and he doesn't have an extensive history. He's 29 years old, and we've seen some 29-year-olds have like much longer history than he does. So we're just asking that you accept the plea as negotiated and sentence him to the amount of time of probation. I think total would be, it's
7.5 years.
7.5 years. I'm also asking for a behavioral incentive day if you're inclined to, and for him to do the 6 months weekend jail. And he understands how I've explained to him how seriously we take the weekend jail, and that he needs to report on the 5 p.m. and then make sure he is reporting each weekend, and that he knows to contact with me if something's going wrong or he's going to be late or something like that.
Okay.
Oh, his mom should be on.
Could be. There is a Lasagna Reynolds.
Yeah.
Okay. She's on. I'm curious, the car in one count is just referred to as a gray vehicle, and in another it's a gray Chevrolet. Did no one ever figure out what kind of car it was, or it just didn't make it into the indictment? Meaning Ms. Lynch's car.
It was a gray Chevrolet.
Right, but Corvette or pickup truck, you don't need to look at it. I'm just curious why. Normally it says it's a gray Chevrolet. Yeah, Malibu. Okay, it's not critical. That was jumped out as peculiar to me. A track, okay. Mostly I was trying to figure out what was so special about this car that it was followed around everywhere, and then in broad daylight it was carjacked.
While looking at the police report, she was at a friend's house before she left, and that friend may have had other people that was watching his house. So once Ms. Lynch left, whoever followed her, maybe followed her because they thought she had something involved in that house she left.
Got it.
That makes sense.
Okay. Ms. Reynolds has suddenly come alive here. Was she going to be saying something?
I think she did want to say something on his behalf.
Okay. Good afternoon, Ms. Reynolds. Was there something you wanted to add?
Hi, how are you today? I'm working from home, so that's why I wasn't actually on. I would love for my child to come home. Jerron is a very good kid. I know sometimes kids get older and they sometimes do things that they're not supposed to do, and which that you definitely shouldn't do things like that. But I love my son. He is a good child. I would like for him to get a second chance because he's almost 30 years old, and to sit in jail and to just give your time away, you have so much life ahead of you to live that I need you to stay out of trouble and do the right thing.
Those are wise words, Ms. Reynolds, and I hope your son absorbs them, because he does have a whole lot of his life in front of him, and he will get out soon enough and he can live those years. He just needs to make a different set of choices. One might be to not lend out his fancy charger to other people.
No, never lend out. No, you never let anybody, you're not borrowing my car and I'm not loaning you no money.
Well, there you go, where your mom stands on that one. Okay. Thank you, Ms. Reynolds.
Thank you.
All right. Mr. Reynolds, anything you want to add? You don't have to say anything at all, but you have the right to speak about your situation if there's something that you want to share.
Yes, sir.
Okay. Well, Mr. Reynolds, I find there's a factual basis for your plea. this is one of those where I could see, wow, a jury could go either direction. I suspect your aunt would come in here at trial and say, it was a long time ago, but I think on May 3rd, 2022, he was with me. But then a good prosecutor would say, what were you wearing that day? I don't remember. Well, how do you remember that Jerron was with you? But there's that potential defense coupled with the fact that your phone is following Ms. Lynch all around. And so as Ms. Rios put it, you'd be banking on jurors saying, oh, I get it. You leave your phone in a car that you're lending to someone. And if you don't have proof of that second phone, that could be a tough one for the jury. So I understand why it's an Alford plea. I'll accept it as an Alford plea. I do find a factual basis. A jury could say, I don't buy the you hid your phone in the car as a tracking device. And then you're looking at a whole different world if the state isn't agreeing to reduce things the way they did in terms of that safety valve provision in subparagraph E. I also find that your plea is knowing and voluntary. Voluntary meaning no one's forcing you to enter this plea, and knowing meaning you've understood the things we talked about. Do you agree with both those?
Yes, sir.
Okay, then I'll accept it. Ms. Rios, do you authorize someone in my office to sign the indictment on your behalf and Mr. Reynolds' behalf?
Yes, sir.
Ms. Smith, can someone sign for you? Excellent. Restitution, we're tabling for now. So Mr. Reynolds, I'm going to follow the state's recommendation. Initially, I thought that dropped too far as I heard about masks and assault rifles, et cetera. But it would be hard for the state to connect you to it beyond the circumstances.
Healthcare Visual Services, this is Sonia.
It's okay. We muted her. She's working. She told us she was working. She just didn't know she was working with us. What does she do?
She does like medical, like for like people's appointments and stuff for like eyes.
Okay, got it. Anyway, your car, your phone, but then no one can make an ID because these guys were smart about their bad acts. So for count one, I'm not sure how I guess because you've invoked E. I'm just trying to think if I know I can have the custodial part be less than 10, but I guess the whole sentence for that count can be less than 10? Because we've got count 4 is a +5. And so if we're having something be 10 serve, then for the armed robbery, for example, it would have to be 5 years to serve 2.5. We'll try it. We'll see what happens. If I need to amend it, I may turn the firearm count into 5 years suspended if it turns out we have to do 10 to serve something for the armed robbery. Okay. Count 1, your sentence is 5 years to serve 2.5 years, balance probated. Count 2 is the same sentence. They'll run concurrently with each other. Count 3 is the same sentence. Finally, count 4 has to be 5 years and has to run consecutive. I'll run that consecutive to count 1. So that's a total sentence of 10 years to serve 2.5 years with the balance on probation. Your special condition number 1 is stay out of Fulton County. You're going to live, was it with your aunt?
Stone Mountain.
Yeah, but is it your aunt?
Yes, sir.
So you're going to stay in Stone Mountain. That's DeKalb. DeKalb, Clayton, pick your county. Just don't come to Fulton County. No contact with Ms. Lynch. I think she's a stranger to you, but don't look her up online or anything like that. She needs to do her best to recover from the continuing trauma from this without you reaching out to her. You may end up being liable for restitution. That would be a separate hearing, and you'd be present, likely virtually, for that if that comes to pass. I am sentencing you pursuant to 1710 6.1E. The state has asked that I do that. I think it's appropriate given your fairly minimal criminal history. I'll tell you, the reason why I'm not going along with Ms. Rios's request, which is your request to do weekends, is if you hadn't picked up that Douglas case, but that tells me that even after this situation, whether you were involved with it or not, you knew it was out there. You got mixed up with things in Douglas County. And the bulk of the time that you've served, for which you'll get credit in this case, was really for the Douglas County case. So you will serve the 2.5 years. You'll get credit for all the time you've been in Fulton County, all the time you've been in Douglas County. And did you ever go into the Department of Corrections, or it was all in Douglas County?
Oh, Douglas County.
Okay, so you get credit for all those days, which means you are well into the final fifth of your sentence because you've done over 2 years. I think that's it. Ms. Smith, anything else?
Did we have a, was it looking to start to do an anti-divorce or moral recognition?
So that means you did a.
You had, I don't remember you asking for the second one, but we could do that. Moral recognition?
Yes.
Okay.
No, you did. I'm trying to calculate.
So one more thing, and then I'll hear from Ms. Rios. A final condition of your probation is that you complete what's called a moral recognition course. It's also called MRT. You may have heard about that, but MRT, that's something you can take while you're in custody. If you don't, you'll complete the MRT program when you are on probation. Probation will help you find a class. You'll sign up for it. You'll pay for it. You'll do it. Ms. Rios, you were working on something.
I was trying to get the math. He's trying to understand like how much she would have to serve less, and I think it's at least 5 months from the math I'm doing. So he was just asking about that.
Well, I can help. He did 99 days. So he already did, you have less than 3 months left, I think. When did he go into custody in Douglas County?
October, I had 16th, 2024.
Oh, okay. So then, yeah, you got a little more time than I thought. So you've done October till now is 1 year and, oh, okay. Yeah, you're right. Your math is better than mine on this one. Yeah, you got about 5 months left. I didn't realize it was October when he went in. I thought it was August.
Does that change your weekend idea?
No, it doesn't. And it also doesn't, you still get credit for all that time. We just need to figure out that October date. You've been in nonstop since then. And then there's an additional 99 days from your arrest. You were arrested on May 26th of 2022 in connection with this case. And you did 99 days there. That'll get added to the how much have you already served. Okay.
But with also the 2 months that I've been in Rice Street.
Oh, yeah. Another 69, more than 2 months. Yeah, that's in there. But I don't know that they'll look at it that way so much as you've been in continuous custody since October of 24, and you still are. So today is another day you get credit for, and then they'll add the 99 to that. Okay?
Okay.
If you feel like they did the math wrong, you let Ms. Rios know, she'll let me know, and if they did it wrong, I'll get them to fix it. If they did it right, then you just keep on.
So there's no 2 for 1 for the.
Not in this case, not with the charges you're pleading to. Okay? All right. Ms. Simpson is with probation. Ms. Simpson is with probation. She's going to come talk to you just to give you the heads up, since you're going to be in DeKalb County where you need to report when you get released.
Okay.
Okay? All right. Good luck.
Quick question, Ray. Should I email those dates? Because I'm not sure if the jail will calculate all of that.
I would email them to Ms. Nelson and we'll put them in the final disposition. And then if there's a disconnect, we can always follow up.
Thank you.
Mm-hmm. So we're gonna do Mr. Varner. I gotta go make sure my kid has let the dog out because he's home alone. And then we'll do Varner. And then I think that's it. Can we go home after that? Okay.
See what Kane is like.
I wasn't paying attention. What are you talking about? Even with the weekends, it's gonna be 5 more months, basically.
What, how many months?
You'll have to do 5 more months.
Oh, is it enthusiasm for us to go?
No.
Where's your other cab?
What's that for the cat that you made?
I don't know.
What's the back of that?
I would frustrate.
What are those special conditions on Varner? I don't remember.
Anti-theft, stay away from all senior stores and to be gainfully employed.
That's right, that's right.
I was trying to see, how much time has he done already?
118 days, if you add up both bookings.
I just wanted him to have something to go to after it, and I know Pat is volunteer, so
Mhm.
it's like, I don't know, is he the type that can do Salvation Army or something like that?
Like I said, he said he's got a stable address, but I don't know how stable. Yeah, but we'll see.
MRT.
Moral.
Recognition.
Moral recognition. I call it
Therapy.
therapy. Yes, therapy.
Yeah, that's it.
Okay, I didn't get that last one, okay. And, does the, 16 point blah, 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 I have it written down on another piece of paper, has to do with the entire sentence or just counts 1 and 2 or what?
1 and 2.
1 and 2.
This is a down remediation, they both have.
Oh, yes, thank you.
So it still remains armed robbery and hijacking, but it's under that code of the
Yes,
downward?
it allows us, so just leave this time.
Okay.
So yes.
You guys are making me earn some big time. Yes.
Do you need the Douglas, like, proof of incarceration? I'm sending an email with these, if you want this too.
No, I just need the date, like the Douglas date, and, cause was it consistent? He went to.
Yeah, so he went from Douglas straight there. Yeah, so he did, so the time here is from, May 2026 to 22 to September 1st, 2022, and then again, 10/16/2024 to present. So I just want to put the date now.
Okay, so as long as I have it all, cause I was like, I don't know what he was doing in Douglas County, but you guys do. Thank you.
Yes.
Yes. Let me find it, hold on. He's going into custody though. Do you still want it though? I mean, he's like staying in custody. A year. I can give it to you though if you want to put it. Well, cause he's got.
Yeah, I still need it, but.
Okay.
People give me things.
Okay. If I can read my writing.
Okay, I'll walk.
Yeah, is that what you got?
Yes.
Yeah. Oh, yeah, because exactly.
We're ready for Mr. Warner if you are.
The dog okay?
Roscoe wasn't even home yet. He was in the car. I'm like, where you been? He said, well, we were playing golf and then we went to Thomas's house. Like the dog's gonna be sitting with his legs crossed. Like, when you get home, let Bruce out. All right, all right. Come on. Hello, Mr. Varner.
Good afternoon, sir.
Good afternoon.
You got a decab home. You got a decab, right? Did you know that? No. Yeah. Certainly. Probation just told me about it. It's a case. I know.
Ms. Smith, are you ready?
Yes.
Okay, Mr. Varner, you are position 10 on our trial calendar, 25 SC 007132. You have a second case we're resolving today as well, 26 SC 002659. And Ms. Wood told me you are prepared to enter pleas in both cases. Is that correct?
Yes, sir.
Okay. Ms. Smith will put you under oath and ask you about your rights as a criminal defendant. A few other questions. You need to answer her questions truthfully and completely. And also let me know if you have questions so that your lawyer or I can try to answer them. Will you do that?
Yes, sir.
Okay. Ms. Smith, we're ready.
Mr. Varner, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Joseph Denard Warner.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No,
Is there any medication that you would normally take that you haven't been given today?
no.
How old are you and how far have you gone in school?
56, high school grad.
Are you able to read, write, and understand the English language?
Yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in these indictments?
yes, I am.
Do you need more time to discuss your cases with your attorney?
No, not this time.
And are you satisfied with her services?
Yes, I am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. Varner, do you remember being arrested on these charges?
Yes,
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
no, I'm not.
Attorney Wood, is this negotiated?
Dr. Warner?
Yes. Okay. Do you understand that this is a Mr. Varner, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 1 with the balance probated?
Yes, I am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, I am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I do.
Do you also understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, I do.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, I do.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea?
Yes, I do.
Are you a United States citizen?
Yes, I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, I do.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, I do.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, I do.
Do you also understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney,
Yes.
the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Oh, I'm sorry, go ahead. Do you understand that these are the rights you're waiving by entering this guilty plea?
Yes, ma'am.
Okay. Counsel, are you satisfied that your client understands that these are the rights they're waiving by entering this plea?
I am.
Mr. Varner, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, they haven't.
As to indictment number 25 SC 007132, how do you plead to count 1, theft by shoplifting, and count 2, giving false information to law enforcement officers?
Guilty.
As to indictment number 26 SC 002659, how do you plead to count 1, theft by receiving
Your Honor, I can't hear you all anymore. I don't know if you can still hear me.
And all right, we should be back. Sorry about that, Ms. Allen. You were thinking like, wait, what? Everyone left. But we need you and Ms. Harvey just a little bit longer. Our default is for things to stop at 5, and today was a busy day. Where were we, Ms. Allen, when you stopped being able to hear us?
As to indictment, I wrote the last 4, 2659, how do you plead? That's the last thing I got.
Okay, that's a critical juncture. So let's repeat that question and see what Mr. Varner says.
As to indictment number 26 SC 002659, how do you plead to count 1, theft by receiving stolen property, and count 2, willful obstruction of law enforcement officers?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Mr. Varner. Your Honor, this case were to proceed to trial, and I'm going to start with indictments ending in 7132. The facts would show that on October 24th, 2025, officers of the Atlanta Police Department responded to a CVS pharmacy location. This is at 2429 Martin Luther King Jr. Drive, Southwest Atlanta, Georgia, 30311, also in Fulton County. When the officers got there, they went to the store's camera room where they were able to watch surveillance video of the defendant who entered the store. They saw that when the defendant entered the store, he had on a black hoodie, a gray backpack, and black pants. He picked up a blue box of merchandise from the shelf of this CVS store and concealed it in his hoodie. The defendant at that point continued to walk through the store and proceeded to an area that was not visible on camera. A couple of minutes later, about 10 minutes later, the defendant in this case re-entered the camera. So they're still watching the footage at this point, and he proceeded to walk toward the exit, passing all points of sale without paying. The officer met with the suspect as he exited the store and placed him under arrest without incident. When the officers searched the defendant after he was arrested, they found 5 bottles of Gatorade, 2 Dove deodorants, a blue box containing 4 razors, and 1 container of nasal rinse. That was all located in the suspect's backpack. That merchandise ended up being around $51. However, it was indicted as a felony because of the previous shoplifting convictions that the defendant has. At the time when the defendant was arrested, the officers asked what his name was, and he identified himself as William Walls. The name that he gave and the date of birth was incorrect and was not identifying to him. So in addition to that theft by shoplifting, a giving false information charge was added to the indictment. Those are the facts and circumstances regarding the indictment ending in 7-132. Regarding the facts for the indictment ending in 2659. If this case were to proceed to trial, the facts would show that on May 3rd, 2026, officers of the Fulton County Police Department responded to a stolen vehicle alert around the MLK and HE Holmes Drive location. When the officers approached the car that they got the bolo hit out for, they saw a man who was later identified as Mr. Varner, who is the defendant in this case. He was sitting inside of that car. There was also a woman inside of the car that was identified as Miss Melinda Tauber. Well, she wasn't inside the car. My apologies. She was outside the car talking to Mr. Varner. The officers then went to go speak with the defendant in this case and asked him to step outside of the car. He stepped outside of the car, but then he tried to flee on foot. The officers were able to apprehend him, and he was arrested for being in possession of a stolen vehicle. The incident address that I have is 26 Peyton Road, Southwest Atlanta, Georgia, also in Fulton County. Those are the facts.
That address is for where the car was parked? I thought you said MLK and HE Holmes.
Yes, the stolen vehicle alert was around MLK
Oh,
Drive.
and then they found it. Okay,
Mhm.
got it.
Those are the facts and circumstances of both of the cases, Judge. Regarding the negotiated plea between the state and defense, we've agreed to a sentence of 5 years to serve 1 with the balance probated. That 1 year is pursuant to the mandatory year after having 4 or more theft by shoplifting charges pursuant to OCGA 16814 BC2. That is the provision for the mandatory year for
Okay.
theft by shoplifting. Regarding the special conditions of probation, the state is asking for the defendant to complete an anti-theft course, to stay away from all CVS stores, and to be gainfully employed and, if possible, voluntarily work with PAD so we can make sure he gets a job and he's able to make money of his own. But that is all from the state, Your Honor.
All right. Thank you. Let me hear, please, from Ms. Harvey, her final report of the day. She's out of here.
Yes, Your Honor. 62 cycles, felony convictions from 2021 for theft by taking, 2015 theft by receiving stolen property and fleeing or attempting to elude, 2013 theft by shoplifting, forgery convictions from 2012 and 2008, 2007 theft by receiving stolen property, criminal damage to property in the second degree and obstruction, also 2007 forgery, and 2004 2 counts of forgery. And nothing further to add, Your Honor.
Thank you. And thank you for your help today. Appreciate it. You are good to go.
Thank you.
All right, Ms. Wood, I would like to hear what you want to share. And if you could add, just based on your time with Mr. Varner, what you think Mr. Varner could most use help with, because we're not talking about drug court, probably because he has to go away for a year. But I'm wondering what we want to weave into probation so that there's support for him. 62 cycles says to me, you're wrestling with something, Mr. Varner. For some people, it's an addiction. For others, it's a mental health condition. Sometimes it's both. But that's a whole lot of arrests to have. That's more arrests than years, bad ratio. And so it would be great to help you enjoy your next 56 years, not cycling in and out of custody. But I need to have a sense of what's going on.
Yes, Judge. So, Ms. Smith and I had actually earlier today talked about, obviously I know he's going somewhere else, so he couldn't do PAD right away, but she had asked if that might be a good route. I don't know. I'm I'm assuming once he gets out, he could contact our office and we could do a referral. We have such a good relationship with PAD. So I would be happy to do that, although I know we can't put that in the disposition. I have no objection with doing a drug and alcohol evaluation and treatment as recommended. I think that might be beneficial. Otherwise, I'm not sure what other types of programming. I did speak with Ms. Simpson as well. I think there might be a DeKalb County situation hanging out as well.
Oh, okay.
So it's a little complicated, but I would be happy to work with him if he wanted to reach out at the end of his custodial time. He is 56 years old, Judge, so yes, he is. It's time for him to stop being in the system, I hope. He's a high school graduate. He does have a stable address. He lives with his grandmother here in Atlanta.
How old's your grandmother?
Like 90 so.
But she's hanging in there.
Yes, sir.
Okay.
I'm sure she's probably tired of seeing him
Right.
go in and out of the system, Judge. For the 7132 case, he is entitled to 118 days of credit. And then on the 2659 case, he's got 44 days of credit. So we would just ask that you accept the state's recommendation.
Okay. What's the DeKalb situation that you think is out there, Ms. Simpson?
This case, well, the 25SC case, that you're in violation.
He has probation in DeKalb. Got it. Is there a warrant from DeKalb? Okay. All right. That just needed us to be clear about that. So, Mr. Varner, I'm going to sentence you in a minute. I'm going to see if there are things you want to add before I do that. But so you know, and you may already have known this, your next stop will be DeKalb, where they are going to work through what the probation consequences are of these pleas. My guess is that's the 19, is that by taking from 2021? How much time is left?
He would initially have just under 2 years for the cap's whole.
They want you. So you got you're gonna need to work out what's gonna happen in DeKalb. And they may, because you're gonna get some jail time through this plea, say, we'll just run it concurrently. I don't know. But I wanted you to know that DeKalb is your next stop. Is that a surprise to you?
Yes, sir.
Okay. Not that you were on probation at DeKalb. It's just a surprise that you're going back to DeKalb.
Oh.
Okay. You didn't know you were on probation at DeKalb?
No, sir.
Judge, I think there was some confusion about non-reporting.
Got it. Okay. They've been out of your hair for a while and you thought, hey, we're done. Unfortunately for you, not.
Well, I was under the assumption that I had a fine. Once I paid the fine out there, that the probation was over with.
Got it.
So
apparently that wasn't the right assumption.
yeah, exactly.
Okay. Well, this may not make things worse. It may, like I said, it may just be that they say, fine, you got a year in Fulton County, we'll revoke a year and close it out because you'll have more probation here than what's left in DeKalb. Sometimes that's what judges do, but they will sort that out with you and you'll have a lawyer there to help you through that. Anything else, Ms. Wood?
No, Judge.
Mr. Varner, was there anything you wanted to share?
No, sir, not this time.
Okay. What about the answer to my question about what makes you tick? Why are you getting, I'm looking at what you get in trouble for. You're not out there shooting people. You're not running and gunning, but it's a lot of forgeries, some thefts, shoplifting, stolen truck, that kind of stuff. What's going on? You're not someone who is actually I work in a bank or I'm a doctor or life is more complicated for you than that.
Yeah, sir. I'm having problems with addiction at sometimes.
Yeah.
I get a little carried away.
Okay. Is it alcohol or drugs or what is it?
Alcohol, yeah,
Okay.
drugs.
And drugs, both. Have you ever received treatment?
Yeah, it's been a while. It's
Okay.
a long time ago.
All right. Well, I appreciate you sharing that. So, Mr. Varner, first, I find there's a factual basis for your plea in both cases. They got you kind of dead to rights on the CVS case. It's just, those are the sad ones. It's not like you were stealing 6 stereos to go sell. You were cleaning up. I mean, you're getting stuff you need to live, but not paying for it. And then I don't know what's up with the stolen F-350. That's a big truck. But I think the state could prove both those based on what they shared. So I'll accept the pleas. I also think your pleas are knowing, meaning you've understood what we talked about. Do you agree with that?
Yes, sir.
And voluntary, meaning no one's forcing you to enter these pleas. Do you agree with that?
Yes, sir.
Okay, I'll accept both. Ms. Wood, do you authorize someone in my office to sign your name and Mr. Varner's name to the two indictments?
I do.
And Ms. Smith, can someone sign for you?
Yes, Judge.
Great, we'll do that. In your first case, Mr. Varner, which if I get back to number 10, count 1, the shoplifting, the sentence is 5 years to serve 1 year with the balance on probation. Count 2 is 12 months to serve. That'll run concurrently with count 1. You'll get credit for all the time you've been in, which is 118 days. Special conditions of probation, number 1, you got to stay out of CVS's while you're on probation. You can visit Walgreens or somewhere else. Number 2, you're going to need to complete an anti-theft course. Probation can help you find that. And 3, maybe the most important one, you'll need to have a drug and alcohol abuse evaluation. And if that doctor or clinician recommends any treatment, that's the treatment you're going to need to do. That may be going to the day reporting center through probation where you get treatment daily and job preparedness. It may mean that you go to some AA meetings. I don't know what they're going to recommend, but if there's something you're struggling with, it would be great to lift you up with some support. And that's the point of that. It's not to get you in trouble. It's to figure out what might help you. Okay?
Quick question. Would probation made to hook me up with the pad?
With PAD?
Yes.
Connect you with PAD?
Yes.
So yes and no. PAD is very, very independent. And so probation might literally be able to get you there, but you can reach out to PAD all by yourself. And I encourage you to do that. When you get out, if you want to hit you, if you know where PAD is, they'll do intake with you and they may be able to, it sounds like you have a place to stay with your grandmother, but is it your grandmother or your mother?
Both. They both live there.
Oof, okay, but you could stay there. But PAD could help you with housing, and it may be that you just want PAD to help you with some other stuff. PAD is something you can do, just like you could join the 4-H club if you want. That's not a requirement of probation. It's a way for you to make your situation better. So I encourage you to do that. I just can't require it because if I make it a condition of probation, PAD will reject you. They don't want it to be a condition. It needs to be what Mr. Varner wants and what Mr. Varner does.
Yes, sir.
Okay? In your other case, 26 SC 002659, your sentence as to count 1 is 5 years to serve 1 year, the balance on probation. And count 2 is, that's misdemeanor obstruction. So it's 12 months to serve. That'll run concurrently with count 1. So same sentence, same conditions. You just have the same sentence twice.
Yes, sir.
Okay. Anything else, Ms. Smith?
Nothing further, thank you.
Ms. Wood?
No, Judge, thank you.
So Mr. Varner, again, your next stop is probably DeKalb, but all the days you're dealing with that is credit towards this sentence.
Yes, sir.
All right. Good luck with things.
All right, thank you.
Bye, Mr. Brown. Good luck.
Thank you, Ms. Allen. You made it. That's it. We're done.
You're very welcome, Your Honor. I'll see you on Thursday, I believe. I think I have you.
Excellent. Well, look forward to